Welcome to Looking at Legal Stuff. Today we have 7 hearings, including a 5.5-hour trial in an epic roller coaster termination of tenancy case for the couple who claim that the sneaky old lady who they were in a lease-to-purchase agreement with to buy her stunning lake house went behind their backs to have the home fraudulently condemned while they were living in it, after she changed her mind about the purchase price. We will hear testimony about accusations of fraud, lies, property damage, lockouts, promissory notes, wads of cash, third-party defendants, theft of everybody's property, multiple firings of lawyers, missed depositions, a fraudulently condemned house, and so much more. What will the judge do with this messy, messy case? Let's find out. Today's more than 10-hour video contains all 8 previous videos in this case, plus a 1-hour new update.
All right, let's take up the next matter. This is Rosemary Blair versus Joseph O'Donnell,
Your Honor.
O'Donnell, okay, it says O'Connell here, but I wrote O'Donnell. Joseph O'Donnell, I put O'Connell.
Thank you, Your Honor.
I think it's a typo on the sheet. A typo on the judge.
Oh, okay.
All right, this is filed as a termination of tenancy action. Lori Hines is here with the plaintiff, Rosemary Blair. Also present is Douglas Kuhlman, who's a zoning enforcement officer for Fabius Township, among other things. This was a lease option to purchase on a property at 11247 Lakeshore Drive, Three Rivers. Term began November 12th of 21 and terminated December 30th of 22. This action was filed on December 20th. The plaintiff contended, now there are 2 Lakeshore Drives. There's one at Fisher Lake and there's one at Corey Lake. This is the one at Corey Lake, and this is a very fine home, or at least it looks like it in the pictures. The plaintiff alleges that the defendants are trashing the place, have removed the appliances, furniture, and want to terminate this lease as soon as possible. Ms. Hines, is that correct?
That is correct. Attached to the complaint also are 2 letters written by Robert Yonkers, an attorney, that basically laid forth the notice option to terminate the lease agreement. One letter is dated September 9th. The other letter is dated November 23rd. Doug Coleman has been actively involved in this matter as well, because so many things have happened criminally in this house that the sheriff for St. Joseph County will not pursue. My client has changed the locks twice. They've been broken twice. We know they've been in it. Basically, the house has been gutted. The house has also been condemned. Doug can speak to that as well.
This beautiful house has been condemned?
Yeah. So there's issues with it because of some tree damage and some other damage that's been done. So my client is in.
Let me stop for a minute.
Okay.
She was locking the house up while they still had a valid lease. The lease was valid through November, and the locks were being changed in August. So I have some concerns about that, but all right, Mr. O'Connell, Mr. O'Donnell, and Ms. Bowers, what's your position?
Your Honor, I mean, this is very personal case. This went on. Originally, we purchased this home back in 2021. And then my father got sick. I had to cancel the deal, and she cashed the escrow check. And then the following April, her daughter contacted me and said, my mom hasn't sold to anybody else. She waited for you. You know, I'm sorry to hear about your dad passing. I contacted her. She said she needed money up front to hold it. We gave her $50,000 at first. And then we agreed to pay her $100,000. And then she was going to hold it. And then once she finished off paying off, she said that she had some debt she had to take care of, and she had a few miscellaneous things she had to take care of. We paid for all of her boats to get out of Hawk. They were both in storage for years. I paid to get them going again. I had them insured. But then she also signed a promissory note when we gave her an additional $35,000 for $85,000 because she was kind of like not sick at the time, but she was sharp at the time. I don't know what her mental capacity is now, but at the time. And then she took another 35, and then we paid her the additional this July and this January. She was given up to 120,000 total, which she didn't give you a copy of that lease option.
Oh, just a minute. Just how much money have you paid her in total?
Over $120,000 in cash.
Your Honor, that's a complete and utter lie.
No, it's not. I have proof right here, signed document for $85,000. I have a promissory note.
Hey,
Sorry, Your Honor.
shut up.
I got it. Sorry. I
Both of
apologize,
you.
Your
This
Honor.
is a court proceeding, and you don't just get to shout over each other. They're contending that what you've done is a lie. Now, the video of this house on Zillow shows it to be a beautiful lakefront home at Corey Lake with a purchase price of about $600,000. And you have a lease option to buy, and you have not completed it. So it may not matter how much money you've paid her. They contend you've taken the stove, the refrigerator, the furniture out of the house, and the house has been condemned.
Your Honor, I paid separately for all that furniture. I have a receipt that I paid her for every bedroom, for every furniture, every piece of furniture in that whole house. I paid for.
There are two sides to every story.
Oh, I get that, Your Honor. But she also removed her washer and dryer. She removed, and she had her dishwasher. She stole my snowmobile. She took our snowblower. She took our wood.
All right, well, obviously there's a lot to this.
I can't.
Oh, it's gonna be a close to. She has 18% she owes us on that money too. That's in these promissory note that she's got to pay interest on that.
All right.
So, and I did a title search, and she owes $158,000 federal tax lien on this house that she did not disclose to us. And I have the tax lien. I pulled the title work a month ago, and I almost cried. I got fooled, Your Honor. I had blinders on. This is a beautiful home.
And the house was not.
And the house was not, and when we purchased it, it was not worth that value either. We purchased it 2 years ago when the value of it on Zillow was
Well,
maybe
I
$485.
saw, I wanted to see which Lakeshore Drive this was, the Fisher Lake one or the Corey Lake one. Both of them are full of very nice homes.
And Doug
So-
can tell you that he was through our house.
Stop.
Oh, sorry.
We're not sitting around the kitchen table. They're providing testimony and evidence in a court hearing. So I'll give you a chance to speak. Don't interrupt me and don't.
I apologize,
speak.
Your Honor.
I'll ask you to speak.
Sorry.
So I looked it up, and I recognize the house. Let's hear from Mr. Coolman. Doug, would you raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief. Would you state your name?
Douglas Kuhlman, Kuhlman.
And what's your position in Fabius Township?
I'm the zoning administrator, code compliance officer.
I can't hear you very good, Doug.
No, not at all.
Have you condemned this property at address? It's not on the
11247.
yeah 11247 Lakeshore Drive.
We did condemn it, Your Honor. It has since had minimal repairs to get that placard removed. But there is a tandem case to this, Your Honor, that you signed an order on. It's case number 221650 Ocean and Nora. So back in August of 2022, we were out there because there was a tree that came down on the property. State Farm sent out an engineer. And so myself and building inspector Joe Wicki was out there when the engineers were present. This south side, I believe it is, of the house is a huge glass wall at about a 45-degree angle. All the supports that supported that glass wall down on the foundation, all of the bolts or brackets had been broke by this tree hitting it. And so the engineers said that yes, it was a potential that this glass wall could fall in And if it did fall in, the only place it could go would be into the structure. So because of that, it was deemed as condemned. Looking at the property record from the county records, it indicates that Rosemary Blair was the only person on the title. And so we did issue a municipal civil infraction to Miss Blair. She signed a consent order resolving the matter, which is under case 2216500ON, that was signed by you September the 6th of 2022, that indicated that nobody could be staying or living in that dwelling. So I believe that under our direction that Miss Blair was instructed that she had to keep people out, is why she was changing the lock on the door.
Oh, yeah, that's him. Oh, okay.
Your Honor.
Yes,
I was out there that day with that engineer, and that engineer did not say that the tree caused that damage. He said that damage was pre-existing where those pins were out. He did not say the tree caused it.
all right, well.
I wanted to clarify that,
regardless,
because that's a big
there's
part of this case.
there's-
Rosemary knew about this before the fact. She
Okay.
misrepresented the whole thing.
Mr. Coolman, when you were there, was the inside of the house in good order?
As indicated, there was some appliances missing and stuff, but it wasn't, one of the big concerns is, and I can screen share if you'd like, there's a huge beam on the inside of that structure that had a significant sag to it. But overall cleanliness, it was clean, yes.
I could do this all day.
All right. Well, we have a mess.
Your
We have
Honor,
a lease option. Yes, stop. We have a lease option to buy. The plaintiff says she wants to terminate this tenancy because they haven't completed the terms of the lease. Defendant says we paid her a substantial amount of money and she's misrepresented the habitability and transferability of the property. So, Mr. O'Donnell and Ms. Bowers, let me ask you this. What do you want? Do you want to complete the purchase of this house, or do you want to walk away from this deal?
I mean, at this point, this house almost feels cursed to us. I mean, this has cost us everything. I mean, and I honestly, I'd like to continue. I'd like to have the home. I mean, but I mean, if not, I mean, there's a substantial amount of money there. You know, I mean, it's either way. And if it was just condemned and it was just a minor little thing that condemned the building, then I think that she knew about that condemnation. And I think this was a complete misrepresentation from the start. I mean, she got a lot of money out of us. And I mean, Carla's mom had to deliver $20,000 to her. I have pictures of her with the cash in her hands, so I can show you that she did receive the money. And I have pictures of her. We have plenty of evidence like that. But during the pandemic, it's on Rocket Law. We didn't have access to attorneys, but I did get it notarized in case anything happened.
Well, they also allege that you were in there a few weeks ago and you took a smiling selfie of yourself and sent it to her. What was that about?
That was the selfie and the thing. That was an accident. I didn't mean to send that. It wasn't supposed to go to Rosemary. That was just, I take pictures every time I'm there. I have pictures of every time I've been in the house, when I came in and when I left, to make sure that if this was here, that if she claimed anything, she took everything out of the house. There was a state trooper there that watched me padlock the garage with everything in there. And then she tore that padlock off and gave away, or had them take my snowblower, my swim mattress, all of our wood. I mean, all of our rafts. I mean, she stole everything. I mean, it's tens of thousands of dollars worth of total damages in property for that she had. Just, I don't know what she did with it. The snowmobile, she had a tow impound come, and I don't know how that's possible because we weren't gone that long. I mean, everything she's done. Carla, that was a no. If you ask Doug, they did a no-knock search on her, and while she was in bed, because Rosemary harassed.
They can do a administrative search warrant, but for one
But
thing,
Rosemary knew she was hard of hearing and that she just worked a 14-hour shift.
I don't think they knew you were in there.
Yes,
I didn't
Rosemary
know
knew.
you were in there. I signed this consent order with Rosemary Blair in August
She's a fraud, Your Honor.
and September without understanding there were tenants living in the house. Laura, your client does not have clean hands here. In this case, there's a much
Your
more-
Honor, you're taking their word against mine.
All
Maybe
right.
you need to talk to
Doug
Doug.
was there.
Coolman.
Doug
He
was
knows
there the
what
whole time.
you've been
Just a
through.
minute,
Ask
just a
Doug.
minute. She locked the doors, which violates the Landlord-Tenant Relationship Act. The house was condemned with tenants in it, and I didn't know there were tenants in it. That
And
much
they,
I
they
know.
received a letter, Your Honor, of
No,
September
we did
9th
not.
of that
All right,
notice.
Mr.
from the-
O'Donnell, just a minute. If you interrupt one more time, I'm gonna make you go sit out in the cold and speak through the window when we open and close it. Ms.
Oh, my
Hines, this is your opportunity.
Your Honor, they were given a letter of September 9th noticing them of the condemned property that was mailed to them by an attorney, Robert Yonkers. Then again, on November 23rd, they got another letter saying of all the damage that had been done, failure to pay the rent, the taxes, shutting off the utilities. My client is very elderly. She has no assistance. She has not removed anything from this home. These people have done everything and anything to give her grief. She is so stressed out about this. She's worked with Doug. I think she probably communicates with Doug at least once or more a week. He's been out to the house. He knows what frustration she's been through and the hell that she's been living because of these two. She just wants the property back. She was not paid the amount of money they're saying that she's paid. To me, she's told me that they've only paid $25,000. That's all she has. She did say they knew about the federal tax liens. So that's a lien against the property and they were aware of that. So all she wants is to get the property back. Can she even do anything with it? I don't even know. But at this point, they've not met the terms of it. They were given notice twice, September 9th, November 23rd, that they were in violation of the lease agreement. And she wants possession of the property back.
All right, well, let's unpack that. The September 9th letter, I guess we'll assume it's a notice to quit. Rosemary Blair has asked us to contact you regarding the above referenced lease with option to purchase. She informs us that the property has been condemned by the city of Three Rivers. That's not accurate.
Right.
This is to advise you, Ms. Blair is exercising her option pursuant to the terms of the agreement to terminate the lease. This is 20 days notice pursuant to the destruction or condemnation of the premises clause on page 2. If you do not vacate that property within that time, we will pursue any and all legal remedies, including but not limited to eviction. According to what the pleading said, the property was locked in August. They were locked out in August. All right, so assuming they're alleging, now the lease isn't up, purchase to buy isn't up until sometime in November.
December
But this
30th.
is September. So the next letter is November 23rd. And then close the earlier letter. Your acts of abandonment include, but are not limited to, failure to pay the rent or taxes, shutting off the utilities, moving all of your personal items and belongings out of the home. This list is illustrative and not exhaustive. She further informs us that if she legally took steps to secure the property by changing the locks, you unlawfully responded by breaking into it and have indicated, despite your clear abandonment of the property, that you own it. They still had a lease option to buy, and she locked them out in violation of the Landlord-Tenant Relationship Act. She also advises us there are missing appliances and furniture that belong to her. This is unacceptable. You're instructed to immediately vacate the property, cease and desist from re-entering, and reimburse Rosemary Blair for all damages suffered. You abandon the property and no longer have any legal right to occupy it. If you do not, we will advise her to pursue any and all legal remedies, which is what we're doing now, and a cause of action for injunctive relief, conversion, malicious destruction of property, costs, sanctions, and attorney fees. Well, that's easy for Mr. Yonkers. He's not here. Lori Hines is all the heavy lifting.
Yep.
But anyway, there's issues about the nature of the lease, the extent of the lease, what's been paid by who. Is there an unlawful lockout of the tenants? I didn't give her the authority to do anything. And as a rule, a landlord can't simply say, well, my lawyer told you to move and you didn't move, so I'm locking the door. there's a step in between which involves me, the judge, which has the authority to tell you to not go in there. So you've got your story. Now, Lori, what do you know about the state police removing a snowmobile and other property from the garage?
I know nothing about that. I do know that she called the 911 many times to get assistance for property that kept coming missing up from her property that came missing from the home and damage to the home. But I'm not aware of any state police coming to the home with a follow-up. The sheriff, I know, will not go out and deal with any of that either because they say it's a landlord-tenant issue and they won't get involved. Now, Doug might have some knowledge of a state police, like he's been very involved in this whole action, kind of like a township layperson almost for Rosemary. So he might be aware, but I am not aware of any police or trooper going to the home.
Well, let me go to Doug for a minute. I'll come to you, Mr. O'Donnell.
They wouldn't
Did
talk.
you know that when we did the agreement on the zoning case back in August, that O'Donnell and Bowers had a lease option to purchase this property?
The only thing that I knew is that they were in there and that there may be some type of an agreement there, but when I looked at the county records, there did not indicate anything. I would clarify, just for your knowledge, that when I did the administrative search warrant on August the 12th of 2022, it clearly indicated in this administrative search warrant that the owner of the property is Rosemary Blair, and that it is understood that Joe O'Donnell and a Carla Bowers may be occupying this parcel. As a result of our search warrant and talking with the engineers that did, as you're familiar, we a lot of times do unsafe for human habitation. In this case, because they said it could be in the state of collapse, which obviously could cause death, we condemned this property, and that placard says keep out. And so I did assure Miss Blair that she needed to do whatever effort she could to make sure nobody got into this building until it was properly stabilized. I do believe.
Were the residents notified of this?
So on the day that we were there, it's been indicated that we did it unannounced. We did knock several times. The St. Joe County Sheriff's Department was there with us. The sheriff deputy kind of was the leader, if you will, going through, because we several times knocked, announced, we opened the door. There was an unsecured sliding glass door. We opened it up. We announced several times that we were there with an administrative search warrant. It wasn't until the sheriff's deputy walked into the one bedroom that it startled Miss Bauer because she wasn't there sleeping. And he explained to her that we were there for an administrative search warrant. And obviously she was startled.
Who made the complaint regarding this?
Miss Blair contacted me because she had this tree fall on her house and that she was having difficulty with State Farm insurance because of the damages. And so the building department and I went out and did an inspection on it to find out the condition of the structure. So again, as a result,
so someone from the township didn't call you, the homeowner called you because she was having difficulties with her insurance carrier, and then she got you to condemn her house with her tenants in it?
Based on the inspection that we did after the administrative search warrant, talking to the engineers saying that it was in the state of collapse, yes, we did condemn the house based on the condition of the house.
All right. Were repairs made to the extent that the condemnation order was lifted?
Yes.
All right. So then theoretically, the tenants would be able to go back into the house.
Correct.
When was the condemnation order lifted?
Let me see if I can find that for you, sir.
They never got got on orders 2 times they came out there. It wasn't just the first time.
There's done.
I can't.
Looks like the construction crew is out there and stabilized these posts onto the foundation on November 16th of 2022.
Doug, is there still a placard on the home that it's still condemned though?
I don't know. I have not been out there, but Joe Wiki advised the construction crew that they could.
No,
remove
it's
that
gone.
placard.
All right,
As of November 16th, yes, there was a placard still on it.
all right.
All right, so if the landlord owns the house, the landlord causes the house to be condemned, so the tenant can't live in it. The tenant doesn't owe any rent during the time the property was condemned. Talk about abatement of rent. So from August,
Your Honor,
September,
there wasn't any rent being paid.
well, okay, theoretically, and we've got this purchase rental agreement, the terms of which have not been met. Mr. O'Donnell and Ms. Bowers contend they've paid a large amount of money to the plaintiff, but the final terms of the agreement have not been met. So if push comes to shove, Mr. O'Donnell, you haven't dotted all the i's and crossed all the t's in the agreement. And ultimately, she may retake possession of this property. There are a number of other issues that are yet to be resolved. So now, what do you want to say?
Two things, Your Honor. First, with regarding Doug, he was there, and Rosemary didn't just call the first day and have Carla harassed. They passed the first day. They went through, the house looked beautiful, everything looked good, it was fine. She called, had an engineer fly down from Traverse City the next day to do another unannounced, or whatever you want to call it. They know Carla can't hear. And she was there. I showed up during this inspection when the engineer was there. And this engineer was like, this was pre-existing. That's in Rosemary told him exactly where to go to look. I didn't know. There's 2 bottle jacks in the corner of the house. They went right down there, and I even have evidence here. She lied to us to take pictures of everything in the refrigerator that she submitted to the insurance company. I mean, this was insurance fraud too. I mean, there's a lot more involved with this. And I did, when we gave her the final $100,000 total, she signed that we could close on the 4th of July, that after that, it would start our 3-month period. And she has that signed somewhere. I'm sure she's not going to show it, but I do have a picture somewhere. I'm just trying to locate it from
All
her
right,
house.
so you've given her, I'm assuming you have receipts for this $120,000 that they paid to her.
Yeah, we have from her, handwritten, and I have photos of her taking the money too, and records from our cash coming out of our accounts too. It was taken from my, inherited IRA. And
Then you mentioned some sort of promissory note. What is that?
I had her sign when we got to $85,000. This is during the pandemic. I had her sign because if something would have happened to her, I told her her kids could turn around and, this is way too much money. So she signed that aside from everything, and we got it notarized, me and Carla, that we'd already given her $85,000. And that promissory note was signed and notarized on 11/15 of 21, that she had $85,000 that she'd received that day, that she got a total of $85,000 cash from us.
All right.
And then that went up to
promissory note is an offer to repay it. So
that was just in the event. And then in the promissory note says it was contingent upon this closing. It was the best we could do in a limited amount during the pandemic to protect our interests. We didn't know really, it wasn't like we could go out, there wasn't much going outside at the time for interactions.
So
and I
on that
blinders
day,
on
paid her $85,000. And then you paid a $20,000 payment and a $25,000 payment.
It was at the 85. Then there was a 15,000, which brought it to the 100, and then there was the other payments for I think a 10, a 5, and then I think I gave her 3 or 3,500 in July. I'm not sure, but I was giving her about 2,500 a month. Your Honor, I also put her on. I gave her a credit card for $5,000 when we did to help her out because her children. She told me her kids were helping her out, and I brought her food on Christmas. I mean, this was very personal. I mean, this is not like we were just some tenants. I mean, she gave us the keys to the home. She gave us everything. I mean, we'd already closed this deal at Zimmy's Bar.
Well, the bottom line in this, one, we have to adjourn this matter for at least 7 days, and two, this is gonna take a half day of testimony. There are a couple of issues. One is her ability to reclaim possession of the property. Her claim is that you have not executed the terms of the lease option to buy. Your claim is that there may be fraudulent representations as to the property. And I don't know about that.
Can I
Ms.
say
Bowers?
something? We were never told that condemned state was lifted. We were never told that there was anything done to rectify, like the condition of the home. Joe tried to reach out to Rosemary several times. She would not communicate with us or with him about anything going on with the home. She had our information. She could have at any time talked to us about this, and she refused to do so. I don't know. I don't even know where, we were fine one day and then we weren't. I don't know. Yeah, they did come out twice. They came out that day that I was sleeping. I work overnight as a nurse, so I was in between shifts, and when they came out, I was sleeping in the bedroom. They came out the next day and did the same thing, an unannounced visit, and passed through, which was fine. I had no idea what was going on. There was no communication here about any of this going on with the property.
Your Honor, they got communication, a letter of September 9th and
We
a
never
letter
got,
of
we
September
never.
23rd.
Stop! Jesus, stop it. I'm gonna set this for a hearing, and we're not gonna do it on Zoom. I'll put you all in a room and let y'all punch each other, and then you'll all feel better. This is complicated.
They never paid any of
We're gonna find a place to put it, which is not gonna be easy. I'm going on a trip. Ms. Hines' calendar is very busy. And I don't have a lot of days that are just sitting around without me having lots of stuff to do. I'm going to continue this to, Lori, are you available on Friday, January 27th?
I gotta go look at my calendar.
Your Honor,
Yes?
there was also a state trooper that
Stop.
came.
Stop, she's not here.
Okay.
Oh, I potentially will have a trial that day in a divorce matter because we did not get resolution at mediation.
As indicated, these things are very hard to schedule. That would have been an ideal day.
Yeah, I mean, tentatively, but we did not get, it would be off my calendar, but we did not reach an agreement at mediation, like one of my very few that did not. So it is set for trial all day in Judge Stutzman's court.
I'm going on a trip in January, so I've used Wednesdays for landlord tenant cases.
Right.
Wednesday, the 11th is full. Wednesday, the 25th is full. The morning of the 27th is full. The afternoon of January 30th is full. Let's see what I got for February 1st. How are you for Wednesday afternoon, February 1st?
That one works. We just sent my 2 criminal cases 11 that day.
Yes, Hannah Rawson. All right, I'm going to continue this to February 1st, 2023, and I'll block the entire afternoon.
Thank you.
It's going to be live, not Zoom. Mr. O'Donnell, you could benefit, and Ms. Bowers, from having legal counsel. You are unrepresented. You may wish to subpoena the Michigan State Police officer that seized your snowmobile. You may wish to get receipts to show all the checks that you've paid. There are so many issues here, I can't even quite name them all, but one is who gets possession of the property. Second, is there a violation of the Landlord-Tenant Relationship Act and an unlawful lockout? Third, are there money issues? Who owes who how much money? And what's the current status of the property? You are the lawful leaseholder. They claim that you have abandoned the property, but you're the leaseholder, and I have not ordered that you be evicted. If the house is no longer condemned, you have paramount right to possession of the property. It was said that the utilities were turned off. What can you
Right.
tell me about that, Ms. Hines?
I have it only on the information that was stated in the letter of November 23rd that all the utilities were shut off. And there was no rent that had been paid. That's where I have the knowledge. And I think my client has a file showing that the bills had not been paid as far as the utilities. She's got it right now in her possession. She just opened the file for me.
The home was
Mr.
condemned and we weren't allowed back in. That's why the utilities were shut off.
All right, are they still off?
And go off 10-5.
She shut off our garbage before any of this. On August 2nd, she shut off my garbage, and they sent me my check back and said that she called and they'd never had this happen, but she had our garbage canceled. She literally had it canceled and taken out of my name before she
And
even
five,
did any of this stuff. And this lady's, she's,
Your Honor, she has pretty good notes of all the utilities and when they were shut off and when they were switched.
Well,
on.
are they shut off right now?
Are the utilities shut off right now?
No,
No, they are
and I
not.
just paid I've been paying every bill. Here they are.
She's been paying the bills. They have not
What?
been shut off, Your Honor.
Nope.
She's got the bills right here. They're in her name.
And the gas, and I had everything. The utilities I had to pay. I had to pay the,
Only
What
after
do you
you
call
kicked
it?
us out,
The,
only
stop,
after
stop,
we
stop,
left
stop.
because it was condemned.
Stop. All right, did you
I know,
change
I know,
the
I know.
utility-
I have
now,
proof.
Mr. O'Donnell and Ms. Bowers, were the utilities in your names?
Yes, they were until she had us kicked
They
out of the
wouldn't
home
give
when it was
any
condemned.
search.
And then
She
I had them taken out of my
the
name.
garbage, she had the garbage shut off a month
Stop.
before the utilities.
Stop. You guys aren't very good at this. And there's a number of people waiting for their cases, and you're shouting over each other and talking over each other. I'm asking a question. Let her answer the question, and then we'll try to figure out what's going on, whether we have an unlawful termination of the utilities and reestablishing them in her name. Ms.
Your Honor.
Bowers, stop. Ms. Bowers, were the utilities in your and Joseph's name through this summer?
Yeah, and I have been paying them and I have proof of that.
All right, when I say utilities, that would be the electric company. Is it
And gas.
propane heat or is it gas?
Gas and electric.
All right, what is it? Is it gas line or is it a propane tank?
Gas line.
Gas.
Gas line, natural gas.
All right, so the electric and gas were in your name.
And I have proof that they had been paid up until we were kicked out.
All right,
Your
did you
Honor,
take
and,
the name off the utilities?
I took them out of my name.
All right, when was that?
I think the one I had paid up through November.
Oh,
The gas, I believe, and the electric was in October. I have, I mean, I have. proof of that.
She shut off our garbage in August 3rd.
Yeah.
Your
I
Honor,
got
I'm
that
looking
3
at a
times
garbage
already.
bill that's actually in Rosemary's name that goes back to early 2021. All of these garbage bills are in Rosemary's name.
All right,
Well, I can show my proof.
all right. So is there current heat in the
Yes, Your
building?
Honor. Yes, there is.
All right, I'm continuing this to February 1st. No one's to be in the property between now and February 1st. We're going to maintain the status quo. We'll see what I don't even know how to get all around it. If there's a lease purchase to price and it's in here, what the purchase price is, but,
It says right in there, the
provisions-
85,000.
No, the purchase price was 450,000.
Yeah, 450,000. It's probably assessed as substantially more than that.
Yes, it is.
Now, a $450,000 purchase on this price was a steal.
Not for the condition, Your
Pictures
Honor.
that I saw. All right, but if it's got all this structural problem, maybe not. So we'll sort of, anyway, no one's to be in the house. Utilities shall remain on. The plaintiff shall pay for those in the meantime, and we're gonna sort this out. Mr. O'Donnell and Ms. Bowers, you could use counsel. One, you don't understand the law. Two, you don't know how to conduct yourself that well in a courtroom. Ms. Hines is a very experienced lawyer. She knows real estate law. She knows landlord-tenant law. And she knows how to subpoena witnesses. And you guys don't. And so it's up to you. You are entitled to represent yourself. But when we're at this hearing, the rules of evidence are going to apply. Hearsay is not admissible. If you have things like receipts or check stubs or promissory notes or that sort of thing you want me to see, you're gonna have to bring that. But our next hearing is gonna be on February 1st. They are asking that your right to have this property be terminated. And if they get what they ask for, it would be 10 days after February 1st. There may be other ancillary issues about who owes who how much money, or was there a violation of the Landlord-Tenant Relationship Act? But the real question is who gets the house? And she wants it back and she wants you out of it. You're not to remove any piece of property, even a screw head, from this property between now and February 1st. And I'm gonna block out the whole afternoon for this unenjoyable task of trying to untie this knot. So for the meantime, we're gonna leave things exactly the way they are. And there are two sides to every story. We're gonna put people under oath. And we're gonna see if we can discern what the status of this is. All right, no one shall occupy the premises or remove anything from it prior to that date, or you will be in contempt of court. You'll get a new notice for that date. Thank you, Ms.
Thank you, Your Honor.
Good morning.
Good morning.
Good morning, Your Honor.
All right, are we on the record? All right, we are on the record in the matter of Rosemary Blair versus Joseph O'Donnell and Carla Bowers. And the case now also involves third-party defendants Mark Verpalat, Patrick Blair, and Karen Stiver. We have on the live feed Mr. James McBride and Mr. Jim Fish. Mr. McBride, how are you connected to this?
So Rosemary asked me, I'm her neighbor.
All
Here
right,
on
just
the,
all right, that's all I need to know at this point. And Mr. Fish, how are you involved?
Your Honor, yeah, my name is Fissinger. It's just my nickname, James Fissinger. I'm also a neighbor of Mrs. Blair.
All right. I'm gonna mute both of your mics till we need you, but you're certainly welcome to observe. We have present Mr. Matthew Hauser on behalf of Rosemary Blair. Good morning, Mr. Hauser.
Good morning, Your Honor.
And Daniel Hatch from Grand Rapids here on behalf of Joseph O'Donnell and Carla Bowers.
Good morning, Your Honor.
I'm disappointed that they're not here. I'd hope they would be, but they're here by counsel. Rosemary Blair is, are you Rosemary?
Yes, I am.
She
Your
is
Honor.
present. And are you involved in this also?
I'm Karen Stiver, yes.
All right, so Karen Stiver is present. This case is the procedurally most complicated case I've had in some time. There are all kinds of complaints and counter complaints and answers and counter answers. But it originally began as a landlord-tenant summary proceeding action. And it essentially still is. Counsel Lori Hines represented Miss Blair at that time, and she filed a petition to terminate the tenancy for this property. Street address of 11247 Lakeshore Drive, Three Rivers, a 5-bedroom, 3-bath house at Corey Lake. And here's Mr. Verpalat. It got complicated, then it got more complicated. And the court issued a stay that no one could be in the house back in January. And we had envisioned that there would be hearing on that in February. But new counsel got involved. The matter got adjourned. It got adjourned once again. It was continued from January 6th to February 1st. And the court expected that on February 1st, we would be making further ruling in the matter. Well, that didn't happen. It got adjourned and it got adjourned again. And then I scheduled a half a day for hearing in this matter for a day earlier this month in April. And March 29th. And somebody other than me, the County Emergency Committee, closed the courthouse that afternoon because of a feared tornado that never developed. So we squandered that half a day. And then I had a very difficult time rescheduling this in light of the court's other docket and the vacation I was on. So there are a number of other complaints and counter complaints, but there are only two matters I think that we have. It's the original case and question about lifting the stay for occupancy of the residence. I'll turn it over to the plaintiff and then we'll hear what Mr. Hatch has to say. Mr. Hauser, what's your position?
Thank you, Your Honor. So as it relates to the originally filed motion, in essence, the motion from, it's entitled Plaintiff's Motion for Relief from the January 6, 2023 no entry order, which was entered on the record during the hearing that day. At the request that we are seeking is due to the fact that this case is taking longer than we initially intended, and we're not back before this court in the beginning of February, that the home simply needs to be maintained. And that it would be in both parties' best interest to ensure the home is maintained. At the time, at the January 6th hearing, Ms. Blair was ordered to ensure that all the bills were paid, utilities were kept up, and the like. The question we have, and where we don't know, is what was the state of the home before the winter months, just to ensure the heat's on, the pipes are good, and the like. As we all know, that properties need to be maintained. And that way this asset can be preserved until further order of this court. So it's a request for possession for the purpose of maintenance. There is a notice of less pendants that was filed by the defense. We're not seeking to have the property conveyed or anything like that, just to ensure this home is properly maintained. Thank you.
All right. I think everybody's in agreement that we need to lift the stay. And maybe the question is who gets to stay? Mr. Hatch, what's your position?
Morning, Your Honor. Dan Hatch on behalf of countered plaintiffs Joseph O'Donnell and Carla Bowers. May it please the court. With respect to the motion for relief from the no entry order, there's three reasons why the motion must be denied. First, Ms. Blair does not have any right to access or enter the property without my client's consent. because she has failed to timely file and respond to the counterclaim and is now in default, which I think is the third motion before the court here. Not really a motion, but we filed a request and then the court is compelled to enter the default upon the request. So this means that my clients, Joseph O'Donnell and Carla Bowers, are entitled to exclusive possession of the property. So the court can't lift the no entry order and allow Ms. Blair back into the property because my clients are entitled to exclusive possession under that default.
Well, I can lift the no entry order in favor of your clients.
Certainly. Yep. And that's what we're asking your honor is that.
Well, go ahead with your other two reasons.
Okay. And I can go through, I can procedurally, well, the first reason is just because my clients are entitled to possession of the property. I can go through and say why a default is proper, but it was all.
All right, well, let's set the default issue for a side.
Okay.
What's number two? They had a valid lease at the time?
Number two is because the request is made under MCR 2.612 for relief from an order. The court rule that governs that requires, in case law, requires extraordinary circumstances to obtain relief from an order of the court. Ms. Blair has not set forth in her motion or provided any evidentiary support of extraordinary circumstances that will justify relief from the no entry order. So in her actual motion, Ms. Blair and Mr. Hauser here represented today that properties need maintenance, but there's no, and I don't dispute that, but there's no evidence that the property is in disrepair right now or in need of immediate maintenance or anything that needs to be performed on the home.
Well, that's partially probably because of my order. I ordered everybody stay out of there and now I think the heat is on, but so they probably felt somewhat constrained to do further inspection, but certainly. All right, go ahead. So no extraneous circumstances.
Extraordinary circumstances
Extraordinary
is what the case law requires. There's, again, no assertion of any extraordinary circumstances and also no evidence of any extraordinary circumstances. I emailed Mr. Hauser before this hearing on March 31st, and I said, what maintenance needs to be performed? Are you aware of the properties in disrepair? And I included that in our response, the email, and he said, I don't know of anything.
Well, at this point, I don't know if the fall leaves got raked, the yard needs to be mowed, you know, the things that you do when you maintain a household are all being deferred. And we're all in regret. We didn't deal with this in February, but we need to deal with it now.
Right.
All right.
So, Your Honor, you know, we obviously want to maintain the asset of the lawsuit, but the request is not to maintain the yard or to rake the leaves. The request is for Miss Blair to have unfettered access to the house. So another thing that I want to point out to the court is that in the motion, Ms. Blair asserts that after October, she has no idea what the status of the house is. That's wrong. Ms. Blair went out, and it was actually, I believe, in front of this court because there was a condemnation proceeding and there was a fix-it order that was required by the court. And November 16th of 2022, the township zoning officer, I believe, Mr. Coleman, confirmed that the property was repaired, it was habitable, and that was in good condition. So that's just factually inaccurate. And the bigger picture, Your Honor, is that the motion for relief is not even a veiled attempt. It's a blatant attempt to avoid the summary proceedings process. Ms. Blair wants to avoid the summary proceeding action that she filed, and we have a counter action for summary proceeding, and wants to avoid our hearing now that's scheduled for May 26th, I believe, the formal hearing, and to be granted unfettered access to the property before that time. And the reason is very simple why she wants access to the property. She wants to move back in. I have, through a FOIA request, which if I could approach the bench, and I'll give a copy to Mr. Hauser as well too. Can I approach the bench, Your Honor?
Yes.
Your Honor, this is an email from Lori Hines, who is Miss Blair's prior counsel, that she sent to the sheriff's department after she filed the lawsuit, and I've highlighted the relevant portions. Number one, Ms. Hines confirms that Ms. Blair has changed the locks twice, violating the anti-lockout statute, but that's for another day. But the last paragraph is the most important. Ms. Blair is hoping to restore the home to a condition she can live in full time. Until something is done about Mr. O'Donnell, she cannot move back into this property. She wants access to the property, not because there's any maintenance issues, not because she wants to maintain the asset, but because she wants to avoid the legislative enacted Summary Proceedings Act that we need to go through before the judge decides who's granted access to the property. So again, it's not an entry or it's not a motion to lift the no entry order for maintenance. It's so that she can be granted unfettered access to the property. And finally, so again, there's no extraordinary circumstances presented. There's no evidence. We know what the real attempt for the no entry order to lift the stay of the no entry order is. And then finally, procedurally, the third reason is that with the original motion, Mr. Hauser did not file a brief in support in violation of 2.119. And therefore the motion shouldn't even be entertained in the first place. But beyond the procedural defects, obviously, my clients are entitled to possession of the property, which I think is our motion for default here today. And there's no extraordinary circumstances. So nothing further unless the court has questions.
All right, thank you. Mr. Hauser, it's your motion. I'll give you the last word on it.
Thank you, Rob. No, we are not seeking to circumvent the summary proceedings. We are ready to go on May 26th at 3 p.m. If the court has any questions as it relates to the current status of the property, that's what we have Mr. McBride and Mr. Fisker here before. They both have had eyes on since the time in which this motion has been filed. As it relates to the reason why the initial motion should be struck, the ability or the request for relief and the court's ability to request that relief was cited within the motion itself, and that is sufficient. We then, of course, have had the argument today over the reply brief and the responsive brief. That was a separate motion, and the motion to strike filed by Attorney Hatch. So no, I mean, the request is we want the property maintained. If the court wishes to put limitations on what can and cannot be done with the property until further order, we are absolutely okay with that. We're not seeking to move back in, merely to maintain the assets so that when we figure out what we're going to do with this house, it is in a workable, safe, and habitable condition. Thank you.
Your Honor, just one more thing, not that I want the last word, but I did fail to mention something. We have 30 days until the actual evidentiary hearing
Yes.
for the termination of tenancy. There's no reason, there's no maintenance issues. Also, I'm going to object to any witness testimony here today. It's a motion, it's not an evidentiary hearing.
Well, they're certainly welcome to watch, but yes.
But it's not an evidentiary hearing, and it needs to be included in the motion. If they wanted to submit affidavits, they could have done that before here. But again, in the next 30 days, there's no evidence and there's no reason that Ms. Blair should be back into the house, allowed into the house, circumvent summary proceedings, and then also unfettered access to the home. There's no reason at all, Your Honor.
All right. I would note Mr. Verpalat, one of the third-party defendants, has also joined us, and he's here on the Zoom feed. It took me a while. I kind of, when we were at one of the first hearings, I got Ms. Hines's pleadings. I saw that email and she was indignant that the defendants were in there and they were removing property, and she contacted the undersheriff, and I was aware tangentially of the zoning action. There were several actions going on in the summer of 2022. There was a personal protection order between Mr. O'Donnell and Mr. Verpalat in August and July. That was going on. Then there was the zoning case. And that was in the name of Rosemary Blair and the other owners of the property, not in the names of the tenants. And then that was settled. She owned the property. She accepted settlement. You indicated, Officer Kuhlman indicated that the property had been made habitable, and I have the zoning, I have the PPO file, I have the zoning file, and this file. So as we got into the hearing and I learned and I started to hear Mr. O'Donnell's position, I was offended maybe outraged is too strong of a word. My opinion at that point was the defendant, the plaintiff, used the zoning system to force the defendants out of the house. And I have some serious concerns about violation of the lockout law. I felt that they got used. She self-reported a zoning violation. Allegedly, there had been some damage to the deck, but the photographs showed just minor damage to the deck from apparently a tree that had fallen earlier. And then they got under the house and realized that some of the stuff was supported by bottle jacks and it may have been dangerous. So they condemned the house immediately without notice to Mr. O'Donnell and Miss Bowers. And I believe the plaintiff used that as a pretext to terminate the lease with option to purchase. Miss Bowers and Mr. O'Donnell were the lawful occupants of the property on the day that zoning enforcement action took place. The police came out there like I won't say it. Anyway, they came out there. Miss Bowers was asleep. The house was neat and clean. All the beds were made. They were using it for the purpose they had intended. And they came stomping in there, got her out of bed, kicked her out of the house, told her she couldn't stay there, and they were evicted. And I felt at that time, I haven't made a ruling yet, that it violates the lockout law. Then they changed the locks and did some other stuff. And some earlier attorney sent an extremely threatening letter saying, "Rah, rah, rah, rah."
Your Honor, those letters, if you're looking for them, are Exhibit 9 of our brief in opposition to the motion relief.
They're in the original pleadings as well, but the lockout law, which is found at 600.2918, any person is rejected and put out of any lands in a forcible and lawful manner and is afterwards being held or kept out by force is entitled to 3 times the amount of his or her actual damages, or $200,000 or $200, excuse me, whichever is greater. Paragraph 2, any tenant in possession of premises whose possessory interest has been unlawfully interfered by the owner is entitled to recover the amount of their actual damages, $200, whichever is greater. And I think there's a position in there also for attorney fees. By changing or altering the locks, this is 2F, by causing by action or omission the termination or interruption of services provided. They called the zoning people to ask them to condemn their own house. And then they used the section of the lease option to purchase that says under destruction or condemnation of the premises, if the premises are damaged or destroyed by fire or other casualty to the extent that the enjoyment of the dwelling is substantially impaired, landlord in its sole discretion may elect to repair the premises or terminate the lease upon 30 days written notice to the tenant. Well, that wasn't even done. If the premises are condemned and cannot be repaired, this lease will terminate on 20 days written notice by either party. So on the day the zoning police show up, Miss Bowers and Mr. O'Donnell have a lease with option to purchase effective November 15th of 2021 with 0 monthly payment. However, the testimony at the earlier hearing was they had given Miss Blair $85,000 plus an additional $15,000 plus some other money. Their testimony was they were paying $200 a month, although the lease did not require that. What's really going on is this is a purchase price for $450,000, and this house is probably worth $800,000 to $900,000. A $450,000 sale price in this market for this house is a very low price. At any rate, they called the zoning police on themselves, condemned their house, immediately kicked the defendants out, attempted to change the locks, and this action was begun. Ms. Hines was indignant, and then I said, well, I'm not sure your client has clean hands. Well, then she was more indignant. I hadn't made any finding at that point, but that was my impression at the close of that hearing. And I'd seen the zoning case. I saw the very minor damage to the deck. And then it started out as this. So the lockout law could allow the defendant to claim 3 times their actual damages plus attorney fees. So it is a summary proceeding action. There's all this other stuff circling around, but it boils down to the defendants want to execute the contract, which is a specific performance action. The plaintiff contends in some of the pleadings that she wasn't competent or capable to enter into such a contract at that time. Specific performance is an equitable remedy, that mostly rests in the circuit court. So that's a concern that you should have on behalf of your client, whether they violate the lockout law, and she's going to be liable for 3 times the amount of their actual damages plus their attorney fees. And the question is whether or not they can execute the contract. So she wants the house back, but they have a lease. They had a lease that was in effect at the time, and they did an end around the lease by using a zoning action. I'm not sure whose idea it was. The PPO action was going on at the same time. The zoning enforcement people also get a phone call saying they want their house inspected. Again, with 0 notice to the tenants in the house. So they were out. Miss Blair, I think, has been paying the utilities. I'm not sure if anyone's mowed it or anything, but your clients aren't here. I was hopeful they would be here. What do they want?
Yeah, they want, at the end of the day, they want to consummate the transaction, which is our counterclaim for specific performance. And they also want to be made whole for their damages. Outside of the monetary damages, we have, I think, nine claims in our counterclaim, excuse me. In addition to consummating the transaction, which I have offered to sit down and try to work out with opposing counsel, but it hasn't been fruitful. They need to be made whole for the damages. Mr. O'Donnell has 5 children. So if Miss Blair claims that she was stressed by receiving the counterclaim, imagine the stress that Mr. O'Donnell had on his life and his kids' life when they were unlawfully evicted from the property, didn't have anywhere to keep his 5 kids. His relationship with Miss Bowers fizzled out after that because she was so distraught that 2 men came into the house when she was sleeping twice without warning and searched the premises, which she didn't know anything about. So it's ruined his personal life. It's really put a strain on his relationship with his children and where they're at. So at the end of the day, that's for a different hearing on the 26th, but they want to consummate the transaction. They've already provided Ms. Blair with over $100,000. And then also to be made whole for the damages that they've incurred by finding alternative housing and the attorney fees, which are very high at this point because we've had to file countless motions that I think are improper under the court rules. They're seeking to extend the time. There should be a default entered. Now there's a motion to extend the default, which is improper under the court rules. It should be a motion to set aside a default judgment, which they don't have a.
Well, I haven't
meritorious
actually
defense.
entered it yet,
Right.
so.
Right. So yeah, procedurally, I guess, but the motion for extension of time will get there because it's the next motion, but the grounds aren't there and the relief can't be granted by the court. So, if they want to try to have a pass at the default, under 2.603, motion to set aside the default, they have to have a meritorious defense and good cause, which they don't have. But to answer the court's question, at the end of the day, we would like to consummate the transaction. Mr. O'Donnell would like to move back into the house that he put a lot of work into and paid over $100,000 for. And then also he wants to be made whole for his actual damages after the wrongful eviction.
There's one other thing that you failed to mention. At the time, they had given notice to Mr. O'Donnell if they wanted to execute the sale within 30 days. I don't remember I wrote it down, 90 days.
90
So
days.
he had started working with a financial lender to complete the transaction. And his testimony was, it was his intention to complete the purchase of the home.
He was ready, willing, and able with the 90 days from Ms. Blair when she said, I want to move forward with the purchase price to purchase the house. After that time, I believe that was August 4th. After that time, the pretextual zoning condemnation happens. They get illegally evicted from the house. And then now she files a summary proceeding to recover possession of the property, which is ironic in itself because she already had possession of the property because she illegally evicted them from it. So, and one more thing, Your Honor, too, the lease with the option to purchase, which is a land contract, that Ms. Blair now claims she didn't have the mental capacity to sign because she has lymphedema, which is swelling of your lymph nodes, not a mental capacity order, doesn't affect your cognitive ability. That's the very contract that her lawyer relied on, Mr. Yonker, to terminate under the condemnation term of that contract. So when she was illegally evicting him, she used it to kick him out. And then now that she's stuck with it because the terms aren't beneficial to her, she's saying, I didn't have the capacity to execute that contract because I had lymphedema and I was in pain.
Well, where I was going was the interest rates have substantially gone up. The money that Mr. O'Donnell would have been able to borrow in August of 2022 and what he has to pay interest to borrow it today, I'm sure has greatly increased. And so I'm not sure what's going on behind the scenes, but they're certainly, their position is much worse than it was at the time. And that theoretically, that contract is still in effect. Now it's expired because of the legal action. By theory, they were supposed to complete it by, I think it was November 30th. At any rate, it has not been completed, but his testimony was, once she gave him the notice, he was ready to complete it. And then this pretext zoning action took place, which resulted in them being removed from the house. My more specific question is, what do you want me to do the next 30 days? Just leave it as it is in the status quo that neither party is in it?
No, Your Honor, just in response to the motion to lift the no entry order, we obviously want you to deny that in favor of Ms. Blair. We want you to enter the default under 2.603 because under our counterclaim, we have a claim for quiet title, which is properly before the court, and the court does have jurisdiction when it's coupled with a summary proceeding and the summary proceeding action where we are entitled to possession of the property. So it's really the opposite. We want Mr. O'Donnell and Ms. Bowers to be able to go back into the property. And then the hearing on the 26th is the evidentiary hearing about their damages.
All right.
Oh, I'm sorry. One more thing, Your Honor, too, if I may. After they were evicted from the property, all of their personal property was removed by Ms. Blair from the property. Snowmobile, snow blower, countless items in the garage. It was all taken out of there by Miss Blair. And that's what our conversion and statutory conversion claim pertains to.
And the problem with those items is they're all over $25,000. And where are those things?
I don't know. We made a demand for the return. We don't know because we didn't take them out of there. I do know, I did talk with Michigan State Police Officer Trooper Owen, who was involved when Miss Blair was calling, how do I say this nicely? Calling a lot the Michigan State Police and trying to report Mr. O'Donnell for coming back to the house when he was locked out, saying that he was breaking into the house and trespassing in the house when he had a lease that allowed him to do that. I did speak with Trooper Owen. He will be testifying at the 26th hearing, and I think the judge recommended that at the January hearing. He did tell me that the snow blower was in some salvage yard. Mr. O'Donnell doesn't know where that's at. We've demanded all the personal property back from Miss Blair. She hasn't returned any of it.
All right. So your position is the win by default. And then the question is, what do we do with the lockout law and the other issues of damages? And they should be entitled to immediate possession.
Correct, Your Honor. Under Quiet Title and the Summary Proceedings Act that we have in a counterclaim, the default establishes liability. Our client is entitled to immediate possession. The hearing on the 26th, and I do understand the reason we had the allegation in our counterclaim that some of our claims, which is really our statutory conversion claim, may exceed the $25,000 limit for jurisdiction for this court is because of the treble damages associated with that. That's the only reason that I pled arguably one of the claims is over $25,000. Now, the proper procedure for that is MCR 4.002 that says if a claim outside the district court's jurisdiction is coupled with other claims in the court's jurisdiction, that claim is bifurcated. So typically what I do is I file a motion for bifurcation, or opposing counsel would just stipulate to it. We could remove that claim to the circuit court. But this court does have jurisdiction over the summary proceeding and also the quiet title claim.
And I don't want to, my preference would be to get this all the way to the finish line. I don't want to do part of it and then dump this all on the circuit court. Or at least get it in a procedural posture that, because it's really going to delay things then. Transcripts will need to be prepared. It's going to take a year or more to resolve it if it's removed to circuit court. All right, Mr. Hauser, your response?
So I guess, the question here all comes down to how much money was paid. Through our pleadings, we stipulated to around $30,000, give or take, was paid to Ms. Blair. There's a question over when that money was paid and then how much, because I know there's now, 120,000 based off the transcript from last time.
That was her testimony, that they had paid her $85,000 at the front end, another $15,000, and then they had paid $2,000 a month for a number of the months, even though the contract called for zero. She needed the money and they were paying her $2,000. That was their testimony. So they contend they gave her $120,000 approximately dollars.
Yes, and it is.
And her contention, it was only 30,000?
Yes.
Okay.
There's a question over the promissory note for the 85,000. I think when those two numbers are added up, we get to about that 120. As it relates to the motion now, we still would request the ability to maintain the property, the lease itself, the option to purchase has not been executed. This is the best of my knowledge. At no time did the defendants contact Ms. Blair after there was contact, begin that closing process with cash in hand, ready to close.
Well, they had a time frame. Their testimony was they were working with a lender in New Buffalo or somewhere. This house is a bargain at $450,000, and they wanted to complete the purchase. So I'll take them at their word that they were attempting to get the money to close it before whatever the deadline was going to be. All right.
Yeah.
Anything further?
No, I was gonna say that by the end of 2022, whether or not the defendants were working on financing or not working on financing, that issue set for a different day. Financing did not appear to have been secured. Funds were not transferred to Ms. Blair. So until we figure out if we're going to allow for that lease with option to purchase to have a future set date to allow defendants more time or the like, the property still needs to be maintained. That remains the position of Ms. Blair.
All right, thank you. I'm going to grant the relief you're asking for. This was we'll call it lease option to purchase or land contract. The defendants were in there under a lease. The plaintiff used the condemnation section to kick them out. And then it says, landlord may in its sole discretion elect to repair the premises or terminate the lease upon 30 days written notice to the tenant. I don't believe that's ever been done. If the premises are condemned or cannot be repaired, which they can be, this lease will terminate upon 20 days written notice by either party. Neither of those have been done. The defendant is entitled to possession of the premises under his lease. Now, the lease is expired, which is problematic, but they're entitled to possession of the property until further order of the court. I have some serious concerns about whether this violates the lockout statute. But just as a practical matter, the plaintiff is not entitled to terminate their tenancy based on violations of the lease. They didn't follow their own rules. Now, maybe it's in that letter from Mr. Juncker that there was a 30-day notice. Let me see if I can find it. Yonkers. Yes, was exercising your option to terminate and give you 20 days notice. Mr. Blorm, Ms. Blair informs us you responded to this notice by abandoning the property. None of that's exactly accurate. So I find that the defendant is entitled to the premises of the property, and I will grant your entry of default. Damages are going to be substantial. The attorney fees, the meter is just ticking. There are other issues about loss of the things that you mentioned, loss of the ability to execute on the thing, change in interest rates, having to find other housing, loss of personal property. This case needs to be settled, but if it isn't, it's going to be very expensive. Anyway, I find that the defendant has possession of the premises and shall immediately have all utilities put in their name and pay the same. I will order that the defendants pay in escrow to the court $2,000 per month. Starting May 1st. And defendant's motion for entry of default is granted. That certainly doesn't resolve all of the issues in this case, but it gets us somewhere. we're still struggling with how to order specific performance of this contract. And what do we use for deadlines? And does district court have the authority to order specific performance? And there's the underlying issue. The defendant contends she wasn't competent to enter into such a contract. But as you point out, she uses it as a sword while asking to use it as a shield. So, Mr. Hatch, I'd ask you to prepare an order to that effect. Our next hearing, I had a very difficult time finding room to put this. I had blocked out that entire afternoon and I apologize. All my jury days were scheduled. We had a vacation. I have several other large cases that take a block of time, and we have the judicial conference where we're gone 2 days in May. So I've blocked out 2 hours. Let's look at that date. I may be able to move it ahead.
Your Honor, if I may just clarify the order, just so I don't get it wrong. Number one, I can submit it under the 7-day rule, if the court would like.
That's sufficient.
Okay, and then defendant is entitled to immediate possession of the property. Defendants, Joe O'Donnell and Rosemary Blair. Joe O'Donnell and Rosemary Blair will immediately put the utilities in their name. They will pay escrow proactively, not retroactively to the court, of $2,000 a month starting on May 1st of 2023. And that our motion for default with respect to our counterclaim is granted in its entirety.
Correct.
Okay, thank you, Your Honor. Oh, and then also logistically, Your Honor, I believe that the locks are still in the house. So could we have something in order that Ms. Blair will facilitate the unlocking of the property?
Yes.
Your Honor, and if I may, as it relates to the default, I guess just for the record, I haven't prepared. It will be filed with the clerk's office when we get out to finish today. The motion and affidavit to set aside the default.
All right. So now that it's entered, I guess you can move to set it aside.
Yes, it was previously filed with this court on or about April 5th.
Well, I tried to parse out all the pleadings, and then I had it all well organized before we canceled the day in court. Then I went on vacation. Then a bunch of more pleadings came in while I was gone. So I spent a number of hours this week trying to parse this all out once again and look at the new pleadings. But all right, we'll address that. Friday, May 26th is a landlord-tenant date. Let's move that hearing up to 3 o'clock. Excuse me, 2 o'clock. That will give us an additional hour. We'll do a new notice.
Judge, just logistically thinking here, if plaintiff is going to file a motion to set aside the default, I don't know if that's going to extend beyond the period for my response for the hearing on the 26th.
So let's see what we can accomplish on the 26th. I don't want to lose that date.
Okay.
And if we have to set further hearing, we'll do that.
Okay, thank you.
But we'll move it up ahead to 2 o'clock. It's a landlord-tenant day, and it always gets very full. I have the morning full, and I have I'll need some of the afternoon, but we'll start at 2. You're certainly encouraged to continue to discuss this and see if some settlement can be reached. The longer this goes on, the more expensive it's going to get for everybody involved. The defendants want to buy the house. Ms. Blair at this point doesn't want to sell it. But I've ruled at this juncture that the motion to terminate the tenancy is denied. And there's a substantial risk of finding a violation of the lockout law. All right, is there anything further we should place on the record here?
Just, I think you dealt with this with the motion of entering the default, but plaintiff did have a motion for an extension of time, and I assume that that is denied.
Yes.
Okay, and would you like me to prepare a 7-day order with respect
Yes.
to that? And then we do have a motion to strike the reply, but I think that is now moot at this point. You know, I would just ask for future reference. For non-dispositive motions, reply briefs are not allowed. The court rules matter. So certainly for dispositive motions, if we get there, but you know, we just get in this endless battle of reply.
Well, I'm trying to
reply.
focus on substance rather than procedure, and there certainly is substance here. There are real people with real issues. There's a lot of money at stake. There's heartache and anguish on each side of the equation, and that's substance, not whether somebody hit MRE 404BC1. That's my license plate number. Anyway, there's real people with real issues. You've got competent counsel on each side, but I do believe that the process was abused and they were unlawfully put out of this house. All right, we'll have more to do beginning at 2:00 on May 26th.
Thank you, Your Honor.
Your Honor, just if I may, is that the date and time set for the motion to set aside the default as well? Or will
You
it
might as
be
well
date?
notice it for that same date,
Okay.
but he may not have time to answer it. So we'll address it, but we may not be able to come to a conclusion on it. But I don't want to squander that date because this order's got a 7-day order. You're gonna file that. But go ahead and we'll notice it for that same time, but we may not be able to do it.
So currently, May 26th is set for now the motion to set aside default, the motion for a summary disposition and
Damages.
the damage. Okay. Thank you.
Thank you, Your Honor.
All right, thank you. All right, we will close this proceeding. This was live streamed. If people wish to watch it on the YouTube channel later, they can do that. All right, we'll be in recess.
Good afternoon.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon. I set this on pretty short notice. I appreciate everybody accommodating that. We had a jury trial set for this, 2 of them set for this morning. One defendant didn't show up and the other one entered a plea. So I had a block of time open for this, and this was time sensitive. So I've scheduled it for today. So let me call it. It's Rosemary Blair versus Joseph O'Donnell and Carla Bowers, plaintiff and defendant, and they now became counter plaintiff and counter defendant. Also, third-party defendants Mark Verpalat, Patrick Blair, and Karen Stiver. Matthew Hauser is here for the plaintiffs. Daniel Hatch is here for the defendants. And Mark Verpalat, I'm not sure if he's pro per or what his circumstance is, but they're not here yet. We have 5 minutes till the actual scheduled time. It's a request for a protective order under the court rule having to do with some discovery subpoenas and depositions that are requesting to be taken. Mr. Hauser is objecting to having those discovery subpoenas done at Mr. Hatch's office in Grand Rapids. Do you wish to speak to that any further, Mr. Hauser?
I guess just by way of, oh, I'm sorry, just by way of some quick clarification, there was an update submitted to the court on Monday, just to indicate that Attorney Hatch and I, when we were both down in person on April 27th, did discuss having the depositions at my office. I believe now all 3 depositions have been re-noticed to my office, that being the deposition of Miss Rosemary Blair, Miss Karen Stiver, and Mr. Patrick Blair. As of May 4th or so, the depositions of Miss Stiver and Mr. Blair have been adjourned for a future date, but the deposition for Miss Rosemary Blair is still on. And the long and short of it, the request is just to have the depositions be held at the St. Joseph County Courthouse, as that's going to save my client a little bit over of an hour and a half of drive time. And given the fact she is 82 years old and already driving from Crown Point in Indiana, if we're able to save her that time, especially since she has some hesitations taking I-94 and the like, I feel it's a very reasonable request to have her deposition be held at the courthouse. Thank you, Your Honor.
All right, so if there was an update, it hasn't made it to me yet. So some of the depositions will be done at your office in Battle Creek.
If I may respond, Mr. Hauser's motion is incorrect and his representations here are incorrect. I noticed originally Rosemary Blair's deposition at Mr. Hauser's office. He put in his motion that it was noticed at my office. That's not true.
All right, that's what I understood.
I originally noticed Miss Stiver and Mr. Patrick Blair's deposition at my office when they were in pro per, because they weren't represented by counsel. After many back and forth with Mr. Hauser trying to figure out if he would represent them, he has filed an appearance on their behalf, and I'm totally okay with taking their deposition now at Mr. Hauser's office. So I typically don't notice depositions at my office for opposing parties unless they're in pro per, because I don't know where they live. I don't want to take the deposition at their house. The court reporters aren't comfortable. I don't know if they have tables. So that's the only reason that their depositions were at my office when they were in pro per. But Miss Blair's deposition has always been noticed at Mr. Hauser's office. And to be honest with you, Your Honor, I've never had an opposing counsel object to producing their clients at their office for a deposition. If you look at Mr. Hauser's motion, it looks like Miss Blair would save 15 minutes traveling 2 hours to the courthouse or 2 hours and 15 minutes to Mr. Hauser's office. She chose to be represented by a lawyer in Battle Creek. The burden is actually more on my clients to have to pay. I mean, it logistically makes no sense to have Mr. Hauser travel another hour to the courthouse, have me travel another hour to the courthouse, have both of our clients incur more fees and costs to convenience Miss Blair for traveling 15 less minutes. So the standard is good cause under 2.302. There is no good cause, and it's to prevent annoyance, undue burden, embarrassment, undue expense, or oppression. And if the court were to order the deposition at the courthouse, it would actually go against that as an undue expense on both of our clients. So we haven't had a chance to respond because Mr. Hauser in writing filed an amended motion, and we had to get it in today. But I hope the court would take that as my response. The standard hasn't been met, and I quite frankly think it's incredibly inappropriate to not have a client's deposition at Mr. Hauser's office.
If I may, in brief response to that, Your Honor.
Yes.
Attorney Hatch indicated the additional drive time from the St. Joseph County Courthouse to downtown Battle Creek is an additional 15 minutes from Miss Blair. I have no idea how one could make that drive in 15 minutes. If Mr. Hatch is aware of a way, I would love to know, as it would save me considerable time every time I need to appear in St. Joseph County. It's about 45 to 50 minutes between those 2 points. The additional drive time for Mr. Hatch, as I did a cursory review on Google Maps, was about 10 minutes each way. Myself, I'm adding about an hour and a half round trip. But Ms. Blair, who was already driving over 2 hours just to get to the state line, is saving about an additional hour and a half. Given the fact she's 82 years old, and this is going to be a rather lengthy day, I'm sure, if we can save her a hour and 15 minutes, I'm certainly willing to come to St. Joseph County to save her a little bit of drive time.
Judge,
Yeah,
if I may, I didn't say that it was 15 minutes from Mr. Hauser's office to the courthouse. What I said was in paragraph 4 in his motion, he says from Rosemary Blair, she lives in somewhere in Indiana, Crown Point. Never had the pleasure of being there, but it's 2 hours and 15 minutes from Crown Point, where Miss Blair lives, to Battle Creek. It's 2 hours from Miss Blair's home to the courthouse. That's 15 minutes. So I'm not saying that it's 15 minutes from Mr. Hauser to the courthouse. We're arguing over 15 minutes here for a deposition.
yeah, I was hopeful that you guys could work out a settlement of this very complicated case. We can't even agree on where the deposition is gonna be and whether it's 15 minutes or 45 minutes. There's a lot of acrimony in this case that mitigates against resolving it. And this is expensive. The clients are being billed to argue about this. It's a matter of geography. I suppose it depends on which way she comes. If she comes from Chicago via the Indiana Toll Road and up through Sturgis on M66, it's probably an additional 45 to 50 minutes, as Mr. Hauser says. If she comes straight up the Indiana Toll Road, I mean, I-94, which I just drove from Chicago this weekend, and came I-94 south on 131 to Three Rivers to Centerville, it's probably marginally shorter than to continue on I-94 to the courthouse in Battle Creek. If you do it that way, it is 15 minutes or so difference. If you do it the other way, the other thing is she's paying her attorney to travel from his office to the courthouse here in Centerville.
And the letter that attorney Hatch was.
All right, I just received this. I'm really enjoying all these additional complicated pleadings in this case. I think I got a handle on things, and then I get a 29 pages more stuff. So it happened when I got back from vacation, and more of this. We do have hearings in May. Anyway, I'm disappointed. And I understood from the pleadings, and I didn't get this amended motion till just now, that I thought the deposition was at Mr. Hatch's office in Grand Rapids. And I thought, well, that doesn't seem unreasonable. To have the deposition here at the courthouse. So it's a difference of which way she comes. She comes up I-94. It's really not that much. Might actually take her less time to get to the courthouse in Battle Creek than it would to get to the courthouse in Centerville. She'd have to go south on 131 through Schoolcraft, through Three Rivers, where both three bridges are out. You can't get from here to there. We're just discussing this. The Broadway Bridge, the Hoffman Bridge, and the Fifth Avenue Bridge are all out in Three Rivers. Make it difficult to get from 131 across to Centerville. I feel bad because I don't know how much money just got spent fighting about this, but I'm going to allow the deposition to be at Mr. Hauser's office. It will actually save her money that she won't have to pay him to drive back and forth to Centerville. And if she comes up I-94, it may actually take her less time to get to Battle Creek than it would to get to Centerville. So I guess I will do an order directing deposition be at Mr. Hauser's office on West Michigan Avenue in Battle Creek. And what is the date? The 16th?
Yes, that's correct, Your Honor.
Correct, Your Honor,
What
Tuesday.
time?
I believe I made it at 10 a.m. so I could accommodate Ms. Blair in the morning for her drive time.
All right. I got out of Chicago in pretty good shape on Sunday. Going in on Friday afternoon was not so great, but if she stays on I-94, it'll actually take her less time. I am still hopeful that some settlement can be reached, not because I'm lazy and I don't want to do it. In point of fact, some of this may end up being removed to circuit court. I think it's just in everybody's interest to come to some resolution of this. But that's not up to me. I'm here just to do my job. So, Mr. Hauser, I think this motion was made in good faith. Your client contacted you, but as a practical matter, it's not going to take her any longer to get to your office than it is to get here if she comes up I-94. It would be 45 minutes less if she came up the toll road, but so I will do that order. Hopefully these depositions may get you somewhere closer to where you need to be. I've got a new batch of pleadings to digest. When we're here later in May, we still have a lot of heavy lifting to do here. But as far as this is concerned, the deposition will occur May 16th, 2023 at 10 a.m. at Mr. Hauser's office on Michigan Avenue in Battle Creek. All right, anything further we need to do here?
Just briefly, Your Honor, you mentioned the May 26th hearing, and I would like some clarification on that. My understanding from attending the last hearing on April 27th and reviewing the live stream is that a default was entered against Miss Blair with respect to our counterclaim. And the hearing on the 26th is an evidentiary hearing on my client's damages with respect to the claims asserted against Miss Blair. I got a witness list, an exhibit list from Mr. Hauser that names 15 witnesses, including 2 doctors, for the May 26th hearing. Some are neighbors, some people I don't even know who they are. They don't identify what companies they're with. None of those witnesses have anything to do with damages. So I don't know if Mr. Hauser intends on trying to relitigate the motion for defaults or to try to have a termination of tenancy hearing. But my understanding at the last hearing was that a default was entered in favor of Joe O'Donnell and Carla Bowers with respect to all of our counterclaims against Rosemary Blair. We've submitted the order to the court. They're entitled to exclusive and immediate possession of the property. So rather than filing a motion in limine and to have the most efficient process start at 2 o'clock on the 26th, I guess I would just ask that, I mean, am I misunderstood that the hearing on the 26th is about our damages?
No, you're not. I thought he was going to move to set the default aside. I'm not sure. I can't remember if that had been pled or not. So, and well, the time on the 26th is going to be inadequate for what we have to do. But no, we aren't going to relitigate the termination of tenancy matter. I also have a proposed default against Mark Verpalat for failure to respond to the counter plaintiff's request. I haven't yet seen anything, so I think I'll go ahead and enter that. File 221862. It's a request for a default on the counter defendant Mark Verpalat for failure to answer. Yes, I found in your favor. I found, well, first of all, there were 2. I found that it violated the lockout statute. But then I upheld your default, which was all your claims. Then there's questions about what I have jurisdiction of. Do I maintain jurisdiction of the equitable claims? Do I maintain jurisdiction of damages over $25,000? Because this is district court, not circuit court. I, point of fact, probably could block out 5 days to litigate all the issues in this case, and I don't think we'd be done yet. But yes, a default entered. It has not been set aside. And you stated on the record more than once that you were prepared to argue the issue of damages on the 26th. And they could be substantial. They could be treble damages. There's issues, as I mentioned, about the change in the interest rate. And the costs that Mr. O'Donnell incurred as a result of this lockout. So yes, I suppose we're going to have a lot of arguing to do, but no, my intention was not to relitigate your termination of tenancy claims or her termination of tenancy claims. I filed on behalf of the defendant. Maybe you guys, yes.
Oh, I'm sorry. I
Go
guess
ahead, Mr. Howard.
just to make sure we have all the documents up to date. There was a motion and affidavit to set aside the default that was filed on or about April 28th. It was my indication that the court did have a copy of that. Is there one in the file? Because that was set for hearing.
Yes, I believe I do. And I think I set that for hearing at the same time. But I don't need, we have to get past that hurdle before we get to litigating the claim again. So I would not summon all those witnesses to court that day. Yes, I believe it was filed. The pleadings in this case are this thick. And I think I got a handle on it, and then I get more pleadings, which I got today. So yes, I guess we'll be hearing the motion to set aside the default. And then depending on where that goes, the issue regarding defendants' damages. Also, I have signed the default judgment against Mark Verpalat for failure to answer his counter complaint. The third party defendant. So you guys will all be in the same place at the same time on Tuesday at Mr. Hauser's office. Any progress that's made is fine. If it isn't, we will use the 3 hours we have set aside, try to inch this matter closer to the finish line. Summer is coming. People want to use the property for its intended purpose as a dwelling. There are issues about personal property that's missing. There are issues about the expiration of the land contract. There are a lot of unresolved issues here. And if we have to fight it every step, I guess we'll do that. It's just going to be awfully expensive for each side. All right, so I will do an order indicating the deposition shall be on May 16th at Mr. Hauser's office at 10 a.m. And I've signed the default on Mark Verpalat. Next thing we'll be getting is a motion to set that aside from him. And we'll deal with Miss Bowers, excuse me, with Miss Blair's motion to set aside the default, and then the issue regarding damages. All right, I will see you on the 26th of May. I'll do that order as soon as I sign off. Thank you.
Thank you. Just sorry, very, very briefly, Your Honor. So the 26th will be prepared to argue the motion to set aside the default, and we'll have a response. And at that hearing too, just to make sure I don't waste the court's time, I'll have my witnesses and exhibits ready for a damages hearing if assuming that is not set aside. So that's my understanding of the time on the 26th. And then I just want to make sure, because I do have a deposition scheduled for Miss Blair's doctor that claims she lacked capacity to sign the land contract on the 18th of next week. I don't see it now that we have clarity on the hearing for the 26th and the exhibit list. I don't see a need to conduct that deposition because a default.
Well, there are issues regarding that, as you argued at our last hearing. On one hand, she said she didn't have the cognizance to enter into such a contract, but she used it as a sword to terminate the agreement. But when it was used by the defendant to sustain their right to possession of the property, she claimed that she wasn't competent to enter into it. I'll leave that up to you, whether you think you need to depose that doctor or not. It could perhaps be delayed. If the motion to set aside the default is denied, it won't become relevant. If it is, it may still be. But again, all of this is expensive. And I'll just leave it at that. So I'll leave that up to you. But the other depositions, I think, may help get you to where you need to be.
Right. The only reason I would take that deposition if she was going to be called as a witness on the 26th, from my understanding, she's not going to be, even with the motion for default is not set aside, and we do go with damages, that the doctor has no relevant testimony with respect to damages. So that helps, Your Honor, because I'll adjourn it out. I hate to keep incurring costs.
Well, there are still some issues. I'm unclear as to the $85,000 that was allegedly tendered, and then it was some sort of promissory note. I don't have a handle on whether Miss Blair actually got $120,000 of O'Donnell's money or something less than that. All right, I'll leave that up to your discretion. If you don't think that we need it for damages, then we won't deal with it. If it becomes relevant later, I guess it could always be renoticed.
Certainly.
All
right.
right.
Thank you, Your Honor.
Thank you very much, Your Honor.
Let's go on the record. Good afternoon, everyone. Thank you for being here on this sunny Friday afternoon when we probably would all rather be somewhere else. This is a further hearing in the matter of Rosemary Blair versus Joseph O'Donnell and Carla Bowers. There are also some third-party defendants, Mark Verpalat, Karen Stiver, and Patrick Blair, who may not be too relevant to today's proceedings. Yes, I heard you. Miss Blair, can you hear me?
No, she's not able to hear you.
We have a
hearing.
Yes, I get to use these very much. Let's turn them on.
Let's see if the battery's in charge, right?
And they seem
Well,
to
they
be
should be if it's
on the chargers.
Thank you.
Yes, well, hopefully this will help. Doug, do you need one of these?
I might.
All right.
There's a volume control here. Move up and down. Yeah, so that way it's not too loud or.
I'll wait till someone talks.
All right, well, let's see. Can you hear us?
Yes, I can.
All right.
Thank you.
Very good. It beats the shouting method. We recently had the courtroom redone for our video recording system with new high definition cameras, and it was quite a difficult process. But among the benefits is we now have this equipment, which we can use for people that are hearing impaired. So let me call the case again. It's entitled Rosemary Blair versus Joseph O'Donnell and Carla Bowers. The file number is 221862. At least that's the original title of it. There's a counterclaim that's been filed and there are pleadings with various names on it, but the original case had to do with the lease option to purchase a property at Corey Lake. It started as a termination of tenancy matter under summary proceedings, and it's evolved into a much larger case. Attorney Matthew Hauser is here on behalf of the plaintiff Rosemary Blair. Daniel Hatch is here on behalf of Joseph O'Donnell and Carla Bowers. All those parties are present. This was the time and date for a hearing on plaintiff's motion to set aside a default and for damages from the counter plaintiff, defendant O'Donnell and Bowers. As I mentioned in chambers, I spent a good deal of time on Wednesday going over all the pleadings. It now fills a whole box. As I mentioned last time, I reviewed the personal protection order matter. I reviewed the zoning enforcement matter. I reviewed the original summary proceedings matter. I watched the videos of the previous hearings and felt I was in a position to address the issues. Yesterday, I received a motion from Mr. Hauser, motion to withdraw as attorney for counter plaintiff pursuant to the court rule. Mr. Hauser, would you like to speak to that?
Just briefly, I would do stand by.
You can stand
Oh,
at the
sorry.
podium there and then you'll be in frame for the
Oh, there we
camera.
go. We would stand by the pleading that was submitted to the court yesterday. At this time, it's been indicated to me that Ms. Blair wishes to seek a new attorney on this case. And therefore, we would also request that any further proceedings before this court scheduled for this afternoon be adjourned to allow Ms. Blair the proper time to obtain new counsel, as we feel her moving forward at this time would be prejudicial to her, as there's quite a bit on the court docket for this afternoon. Thank you.
All right, thank you. Ms. Blair, you no longer wish to have Mr. Hauser represent you in this matter?
Correct,
You have no objection to him withdrawing?
correct. I have no objection.
In fact, you wish him to withdraw.
Yes,
Mr. Hatch, what's your position?
Your Honor,
I have no objection to Mr. Hauser withdrawing as counsel. I just do want to put that it's been nice working with Mr. Hauser. It's been a difficult case. I think he's done a good job on this file. I do have an objection to an adjournment of today's hearing. MCR 2.503B requires good cause to adjourn a hearing. Number one, that was not cited in Mr. Hauser's motion. There's no evidentiary or factual support for it. The case sites are Zorillo versus Dykehouse, 191 Mishap 228, and Henry Kruger Estate, 176 Mishap 241, which establishes the good cause requirement. So Mr. Hauser is Ms. Blair's third attorney, to start out with Mr. Yonker, who the letter was sent to my clients on behalf of Ms. Blair, illegally evicting them from their property. Then she moved on to Miss Lori Hines, who either withdrew as counsel or was terminated. And now she's moved over to Mr. Hauser as her third attorney. We are here at today's hearing to establish, after a default, our damages. Ms. Blair, Mr. Hauser, at the direction of Ms. Blair, filed a motion yesterday, the day before the hearing. So I think it's incredibly inappropriate to adjourn today's hearing, and really just offensive to our system, because now we've been here 4 times in front of the judge, spent a lot of money for today's hearing, and there's not good cause to adjourn today's hearing. If Ms. Blair wants to represent herself, she is entitled to do that. I'm sure there'll be a continuation of today's hearing if she wants to try to seek counsel. But the case was filed by Miss Blair in December. And again, there's no good cause to adjourn the hearing, Your Honor. So no objection to withdraw as Mr. Hauser, but we would like to proceed today.
Any further?
The only thing that I would like to add is since the April 27th hearing before this court, the defendants / counter plaintiffs have been in full possession of the property in question. If this matter is set over for a brief adjournment, they will be able to remain within the house. They have their wishes met, and Ms. Blair can be adequately represented by a new attorney in what, as everyone knows, is a rather complex matter that we now find ourselves in. If she was to continue improper at this point, I do not believe she'll be able to adequately represent herself moving forward today. Thank you.
Thank you. Well, Mr. Hauser, I don't want to leave you in a position where you got 1 foot in the case and 1 foot out of it. So I'm going to grant the motion to withdraw. I've enjoyed having you in this case. The pleadings here are very well pled for many issues. You've been easy with the court to work with on this difficult case, but I don't want to buy you a grievance. And so I'm going to allow you to withdraw. And at this point, you don't have anything to say about anything. So one may argue that good cause for an adjournment is the fact that I don't have a lawyer. But the reason I don't have a lawyer is because I don't want this lawyer. And oh, by the way, I told you about it 1 day before this complicated hearing where we blocked out a large amount of time. And as I expressed to the parties, I don't want to do this twice, and I don't want to increase the price. So, Mr. Hauser, you're excused. I don't want to leave you with ethical dilemma.
I can't.
All right, so yeah, you fired him and he withdrew, so you're free to go. And then we'll discuss what happens next. I put you in an ethical problem if I make you argue and then she's expressed she doesn't want you as her lawyer. All right, thank you. I will see you again sometime, and you're always welcome here in this court. All right, Miss Blair, now here we are. This is your third lawyer, and they're arguing that it's unfair that yesterday in the afternoon, I don't know when the clerk brought it to me, about 2 o'clock, after I spent hours and hours on Wednesday and Thursday preparing for this hearing, that, oh, by the way, I want to fire my lawyer. He made an argument that Mr. O'Donnell has been granted possession of the premises pending the final decision. But there were 2 things set for hearing today. One is the motion to set aside the default, which your lawyer filed. A default entered because an answer wasn't filed in a sufficient amount of time. In addition to the default, I made some findings that they were entitled to relief on the substance. One of the things I found is that the action that you used to remove them from the house violated the Michigan lockout statute. The pretext of condemning the house to remove them from the premises, I found violated the lockout law. In addition, he filed a lengthy counterclaim with a number of counts, which was not answered in a timely manner. So that was on the 27th. The following day, on April 28th, he filed a motion to set aside the default. but that was it. It was a one-page state court form to set aside the default. Mr. Hatch filed a response and a brief, and he set forth a statute which has to do with setting aside a default, which is in the 2.603 rule. A motion to set aside the default or a default judgment, except when grounded on a lack of jurisdiction over the defendant, shall be granted only if good cause is shown and an affidavit of fact showing meritorious defense verified in the manner prescribed by the rule. So he didn't file anything to show that good cause was shown or that there is a meritorious defense. So I'm going to deny the motion to set aside the default. Mr. Hatch, you can do an order to that effect.
Certainly, Your Honor. And because
Just a minute.
Mr. Hauser is now removed from the case, I'll do it under a 7-day order, and Ms. Blair is in pro per, so I will serve it upon her last known address.
All right. Now, so that was one of the two issues we had to deal with. All right. The next issue is this issue regarding damages. So you have removed your lawyer. They want to proceed.
I can't defend myself, Your Honor.
Okay.
I just can't. You know, I'm 82 years old. This has been the most stressful year of my life besides the year I was.
So you're asking for an adjournment.
Absolutely. I can't defend myself.
So what do you plan to do?
I plan to have another attorney. I don't know what I can say. I can't.
Well, you can.
I can't tell the truth because it'll all be used against me.
Well, perhaps this isn't a criminal case, but have you talked to another attorney?
Yes, I have.
And who is that?
Bob O'Brien.
From where?
Grand Rapids.
Miller Johnson, I believe, Your Honor.
That's a fine firm. My son declined a job offer from them to do what he's doing now.
I didn't hear you, sir.
But it's just an aside.
Okay.
It's a fine law firm. They have a fine reputation. I don't know him specifically. But they're saying, how is this fair to us? We're here, we're paying our lawyer hundreds of dollars an hour to be here for this hearing. At 2 o'clock the day before the hearing, you say, wait a minute, I want to fire my lawyer. And they're all here and they're ready.
I can't say I can't tell the truth, so because it'll be used against me about the whole thing.
All right, well, let's talk for a minute. The counter complaint has about 12 facets. Some are more relevant than others, but there are a couple of, there's damages. And in theory, not in theory, but when the damages exceed $25,000, the law says I must remove the matter to the circuit court. There's also an issue regarding specific performance, but I believe that's an equitable remedy that normally district courts don't have jurisdiction over. But in a landlord-tenant case, the court does have some equitable jurisdiction. And one of those equitable reliefs is specific performance. That means I order you to go through with the original lease sale agreement. That I order that they have the ability to purchase this house for $450,000, which was the agreed upon price. That's one of the things that they're asking for, that this matter be completed. Now, there are issues because the interest rate in the summer of 22 was different than the interest rate now, but he wants me to order you to sell him the house at the agreed upon price. In fact, that may be the primary thing that he wants. There's also a dispute. The defendant claims that he paid, I calculated about $115,000, $85,000 in cash, and then some subsequent payments and some $2,000 a month payments. And then I've ordered escrow. So they're claiming they've paid about $115,000. They claim that $85,000 was given to you. In your pleadings, Mr. Hauser claims she never got the $85,000.
I didn't get all of 85,000, and he was supposed to pay me $4,000 a month. $4,000 a month for 12 months is 48,000.
Now, it does not say that in the lease agreement. This says the amount.
It says zero.
It says zero.
Exactly. I didn't draw up the lease agreement, Your Honor.
Well, you didn't draw it up, but you signed it.
Judge,
I-
I'm just gonna object to the extent that this is part of the hearing to any testimony, if we want to.
Yeah, well, she's not under oath
Okay,
and we're not
I
taking testimony,
okay,
but,
okay.
and she's also a layperson doing the best she can, but she bought a firestorm, she fired her lawyer, and you're here ready to go. And they've got pictures here, they've got exhibits. There's a picture of you sitting here with a great big pile of green cash. None of this is in evidence yet. I'm interested to know what it's about. They've got charts and graphs, and they're prepared to present evidence on how much money they paid you.
I can't defend myself today, Your Honor. I just can't.
Yes,
You understand?
I do understand, but you caused this problem.
I
You
didn't-
fired your lawyer the day before the
I
hearing.
didn't fire.
All right, well, anyway, whatever happened, the relationship broke down to the extent, and what you told me is you no longer wanted him as your lawyer. So I don't know how that came to an end, but he's not here. And so Mr. Hauser, Mr. Hatch is chomping at the bit to show me all these exhibits.
Well, I can't defend myself today. I cannot.
Yes.
You understand that?
I do understand it, and I don't want to do it twice, and I don't want to appeal it. But you caused this.
I didn't cause it. I'm sorry, I didn't cause it. I have to say it how it is.
All right, well, all right, that's your position, and so I'll respect that.
I never
But-
caused it the first time around, Your Honor.
All right, well, obviously they have an opposite view of it. But anyway, the fact that your lawyer filed a motion to withdraw yesterday at 2:30, you're not blameless in that.
I didn't.
So, and they're saying, look, we took the day off work, we came over here, our lawyer's here, he's on the clock, we're paying him. We have witnesses here that we're under subpoena, and that's not fair to us. So it'll be an issue regarding costs, but
How can I call these witnesses for me? I don't know.
no, I agree. You're not, I'm not being insulting or condescending. You're not qualified to represent yourself in this hearing.
Right,
It's complicated. There's a lot of money at stake.
right,
There are rules of evidence, rules of procedure,
right.
that are going to apply. And you can't represent yourself. So I could let them go and present everything. And then you could hire a lawyer that would move to set all that aside because you weren't
I don't
qualified.
want to have them do it and hire a lawyer to set it aside. I want to wait till I have my lawyer here. I thought that Matthew Hauser was going to stay here today when we were gonna have this. I had no idea what was happening, Your Honor.
Well, no, that leaves him in an untenable position that he's representing you on something where you don't want him to be, and then he could get grieved for it.
I had no idea of any of this until 7:30 on Wednesday night.
All right. I'm also advised that you failed to appear for your deposition.
I was very sick. I had bronchitis.
All right,
and was-
well, there's a dispute as to that, and I didn't give you permission to not appear. It was a subpoena, which was an order from the court to appear.
You know,
And so I have people call up every day and say, well, I didn't feel like coming in today. I didn't feel good.
no, I had a doctor's.
Yeah, I know. And they're talked about the doctor's slip. There are two different signatures, and there was a first letter and a second letter. And so they're suspicious of your doctor's letter. But at any rate, you didn't show up and the deposition wasn't accomplished. And so that'll be an issue that may have to be addressed. Anyway, all of this is expensive.
Are you telling me?
Yeah, I'd hate to see what the legal fees are in all of this before we're finished. And I'm cognizant of that. I'm trying not to run the bill up for each side. But I can't do it, Mr. Hatch. That's fraught with too many problems. You're a fine lawyer. You've got lots of exhibits, lots of rules of evidence, foundational things, people under oath, examination, cross-examination. I can't proceed.
Your Honor, if I may just respond very
Yes.
quickly. Today's hearing is, I would call Joe O'Donnell to testify regarding a lot of the payments that were made between Miss Blair, or excuse me, Mr. O'Donnell and Miss Blair, along with the factual underlying basis for the land contract. That we're not going to testify about real damages here today because we don't have enough time. I will lay the proper foundation, which is subject to me to avoid an appeal for that. Miss Blair chose to fire her lawyer at the beginning of this hearing. I heard you ask the appropriate questions. And now she claims that she cries wolf, I'm unrepresented. She chose that today. I know Bob O'Brien from Miller Johnson in Grand Rapids, and I would be shocked if he didn't call me yesterday and say, I'm representing Miss Blair. I'm about to represent Miss Blair. Here are some dates that we have available. So if we want to get Bob O'Brien on the phone to see if he's representing Miss Blair, to see if there's an engagement agreement between them. But this is the third time we've been here, and I'm cognizant that the court does not want to create an appealable issue. What we would be going through today would just be documentary evidence underlying the factual legal positions and not anything regarding damages or any conversations outside of what happened between Miss Blair, Mr. O'Donnell, and Miss Bowers. It's as simple as laying a foundation, admitting the evidence, and we can stipulate, and the judge can, if there's not a proper foundation, then you can rule there's not, but I'll lay a proper foundation and we go forward today. And then we can have another hearing that I'm sure based on the court's calendar is going to be probably a month out because you're very busy. Miss Blair can find a representative during that time and he can come to a hearing, he can represent her. She's not calling any witnesses today. I'm just calling Mr. O'Donnell, and it's a couple hours, Your Honor. So I would respectfully ask the court if we could just at least get a couple hours out of the way today and admit some basic documents.
Thank you. It was very well stated. And I understood everything that you just said, but I don't think she did. What you're proposing, it makes sense to a lawyer. I don't want to buy a redo on this, and so I don't have to like it, but she's not gonna even know what we're talking about, laying a foundation and evidentiary hearing. She doesn't understand what you just said. And that's not a criticism. She's not an attorney. So I don't think I have any choice. Now, I had strongly encouraged the parties to settle this case. And Mr. Hatch and Mr. Hauser said they worked diligently on trying to get to a resolution. But they don't get to decide, the parties do. And if it isn't resolved, I will hear it and make a decision. There's a lot of money at stake. They claim they paid you $112,000, which is close to what I had estimated from the proceedings, from the hearing. Now, this started out as a termination of tenancy case. Ms. Hines was indignant and you were being moved out of your house. They were taking things. And then at the first hearing, Mr. O'Donnell and Ms. Bowers showed up. And I said this in chambers, I didn't realize I had handled the zoning case, which was in your name. And you consented to everything. You called them, asked that the property be inspected and condemned, consented to an order, and stop. We're not in school. You don't have to raise your hand, but I'll give you a chance to say something. And then I hear that they use that to remove the people from the house. It was frightening. She's in bed asleep and the cops come and the zoning people come and they're kicked out and then the doors are locked and then we're here in December and then I get his version, our property's missing. I get this notice to quit. I have this agreement and I said, there's more here than meets the eye. I found that was a violation of the lockout statute. I've never seen it done where the landlord condemns the house that the tenant's in and immediately gets them removed from the house. Anyway, so then we're at that hearing. It's like there's a whole bunch of issues. So Mr. O'Donnell and Ms. Bowers hired Mr. Hatch. You hired Mr. Hauser. Things got adjourned. They got adjourned again. They got adjourned because of a tornado that didn't show up. And finding time to hear this has been very difficult. And let me repeat, I denied your motion to set aside the default, or Mr. Hauser's motion. All he did is file a motion without anything more. So that default is in effect. And one of the things in there is a motion for for specific performance, that you sell the house at the agreed upon price. And that's really what this is about. But I'm not going to make you try to defend yourself in this proceeding. She said she talked to Mr. O'Brien. That's different than retaining him or signing an agreement. And he's not inexpensive either.
I'm meeting with him next week. Can I say something, Your Honor?
Yes, you may.
I never had the house condemned. That is an absolute non-truth. Mr. Ard from State Farm, who's a structural engineer.
Your Honor, now we're getting into, you're not under oath.
Okay.
Yes.
I never had the house condemned.
Your Honor, I'm going to object again to any evidence.
Well, the house was condemned.
Not by me. I wasn't even there.
Your Honor,
All right.
I'm going to object to any testimony from Ms.
Well,
Poirier.
she's not under oath. The house got condemned and Officer Kuhlman testified, I believe that you called him and asked to have him come out there and you consented to the order. I'd have to look at the record from the condemnation hearing, but anyway.
I never had the house condemned.
Well, the house was condemned and
I had to pay to have it fixed then.
Well, you were the owner.
Right. But
Okay.
they said they were the owners.
Well,
That's
they weren't, they were the tenant.
right.
All right,
So-
that's one of the fundamental issues here. So you're not under oath. I don't want to get into it. But,
Right. I understand, Your Honor. I don't know what's right and what's wrong to say.
all right, well,
But I do know I did not have the house condemned. and I will tell that to
Your Honor, I would
anybody in the
object
world.
again. I mean, I've heard it 5 times here
Yes,
today.
yes.
She's not under oath, and I'll object to any further statements.
Well, and she didn't show up for your deposition where you could have asked her those questions under oath. Well, then who did have the house condemned? Did it just show up out of the blue? There was a little bit of damage on the porch, and the next thing you know, they're crawling into the house, looking at how the window was bottle jacked up. So it was not good. Anyway, that's a separate issue. This is a termination of tenancy. And that condemnation, whether you did it or not, was used by you to terminate the tenancy. Mr. Yunker sent them a letter
Right,
and said, we're using the condemnation clause of this agreement to terminate your tenancy. You have to move, that your contract is terminated. So you used it to try to get out of the contract.
I didn't use it to get out of the contract, sir. The attorney said that's how it was. Because they
All right, well,
weren't,
stop. That's what happened. The attorney used the condemnation to attempt to terminate the tenancy. But what really offends me is they were removed immediately without notice from the house.
but they weren't.
Well, I took testimony that they were.
From whom?
From Mr. O'Donnell and Miss Bowers.
They were not.
All right, I don't want to argue
Okay,
with you. She was in bed asleep and they came and they put a condemnation on the house on the 9th of August.
No, it was the 12th of August when it went on in the house.
All right. Well, at any rate,
That I know.
Your Honor, I think that Ms. Blair has alleged capacity issues, but it seems like today she has a very fine memory of the facts of this case. So again, I would just ask that Ms. Blair not testify anything at today's hearing, even if she's not under oath, because number one, a default's been entered.
Yes.
So liability's been established. We're here for damages. So again, I would maybe just ask Ms. Blair to
I
listen
don't
to the court.
understand any of
and I understand that you don't. So I'm going to grant your adjournment. I don't have to like it, but I'm going
I
to.
don't like it either, sir.
Okay, well, that's.
I don't like it any more than you do.
Well, it's unanimous. Nobody likes it.
Right.
Very intrigued by this picture of you sitting with a large pile of cash, which would seem to support their contention that they gave you a large sum of money. It looks like there's a contract, looks like the lease may be sitting on top of the purchase agreement.
Same time, yes. And you can see how my eyes are. I was sick as a dog and they knew it. I have an aneurysm.
Stop. You
Okay,
can't
I'm
keep
sorry.
testifying.
I'm sorry.
All right.
I don't
And
know
what
what-
I said is, on one hand, you said, well, I didn't have the capacity to enter into this contract. On the other hand, that contract was used to kick them out of the house. So you can't have it both ways. And they were going to present evidence to show that you were competent to sign it. Now, this house, if it went on today's market, would sell for more than $450,000. And that's what's going on here. But there was a signed notarized purchase agreement to sell it at that price. As Mr. Hatch indicated, I have a hard time finding large blocks of time, particularly in the summer. Judge Patterson's going to be gone. I'm going to be gone. There are judicial conferences. I have a jury. I have a million things set. So finding a spot to put it is problematic. I'm going to continue this matter for the damage hearing for Wednesday, June 28th at 8:30. Does that work?
It works for me, Your Honor. I just want to check with my clients.
Which gives you about 30 days to get an attorney to come in here and represent you in this matter.
Correct.
All right. Does that date work for you? You don't have an appointment or?
I don't know.
All right. Mr. Hatch?
Ms. Bowers and Mr. O'Donnell are available on the 28th, Your Honor. Do you know what time that would be?
8:30 in the morning. I'm gonna block
8:30
out,
a.m.
I'm gonna block out the entire day.
Just for clarification, Your Honor, that would be a continuance of today's hearing, which is a damage hearing on our motion for default to establish default judgment damages. Correct?
Yes, so I granted 2 orders today. I granted the order allowing Mr. Hauser to withdraw. I granted an order denying the motion to set aside the default because they failed to provide a petition of an affidavit of meritorious defense, and they didn't show any good cause. As you indicated in your pleading, you can ask for a continuance rather than default and then afterwards ask for relief.
Did you check the calendar?
I have a jury trial that day that is not gonna go.
Okay, I just wanted to double check to make sure.
I don't want to say his name, but I think that's gonna settle, and if it doesn't, I'll bump it out.
Okay, all right, I just wanted to double check, Judge. Thank you.
All right, motion to withdraw granted, motion to set aside default granted, defendant's motion for adjournment, defendant's pro per motion for adjournment, and I'll do this order.
I think that was motion to set aside default, Your Honor, denied.
Yes, oh, granted, yeah, denied. Pro per motion for adjournment, granted to June 28th at 8:30. And Laura, let's block the entire day. We'll take as much time as we need. Also, I know an apology to Mr. Verpalat. The last hearing we were here, I entered a default against third-party defendant, Mr. Verpalat, because no answer had been filed. Well, everybody sat there, nobody said anything. I didn't have an answer.
I couldn't hear.
All right, I granted a default against Mr. Verpalat because he had not answered, when in fact he had answered. He had filed an answer with the court in a timely manner. And I didn't know it. And so a day or two after the hearing, the clerk brought me the answer and said, well, he did answer. So the default judgment against Mr. Verpalat is set aside by the court because it was entered in error. Now, the 3 third-party complaints are also just sort of hanging out there. And I think all those claims are going to need to be removed to the circuit court.
I believe, Your Honor, the way that I see the case going is that after the damages hearing from Ms. Blair, then we can address the third-party claims against Ms. Stiver and Mr. Patrick Blair and Mr. Verpalat as well. A lot of those factual issues are going to be resolved through the deposition of Ms. Blair. And I don't mean to get sidetracked, but I would like to put it on the record and for the judge to order that Ms. Blair's attempt to seek new counsel will not interfere with my ability to take her deposition. And then over the next 30 days, which I intend to do, even though she no-showed for her prior deposition. So I don't want to there's a common theme here, Your Honor, which is the day before it's judgment day or it's time to show up to the show, Ms. Blair comes with excuses about why not to show up. So I would like it to, she be ordered that.
I'd ask you to stand by the microphone because she's getting her
feedback.
Well, but she's getting it through the microphone.
Over the next 30 days, I would like it to be ordered that Ms. Blair will show up for her deposition to be taken, and that it will not be impacted by her attempt to seek new counsel.
All right, you can give her 14 days. The deposition shall not be scheduled. Ms. Blair, would you turn that down a little bit? No deposition for 14 days, but it may be between 14 days and the 28th of June, and she shall appear unless she is excused by the court. Not some doctor who I don't know who signs his name differently 2 different times. So they have 14 days and he's going to depose you and put you under oath and ask you a bunch of questions. And you're compelled to answer under oath and you're compelled to appear unless I excuse you. And it won't be until at least 2 weeks have passed. Then all these third-party complaints are just sort of in the background. I've got some time constraints and each of the third-party defendants has their own concerns and they've had to retain counsel. So let's see what we can do on June 28th to get this case to the finish line.
And I'm, to hold the claims against the third parties in advance, but Judge, that brings another interesting issue. Mr. Hauser represents Patrick Blair and Karen Stiver. So I don't know if he has withdrawn his counsel for just Rosemary Blair, or if the request was made, I don't believe in the motion was made for Patrick Blair and Karen Stiver, but he did file an answer on their behalf. Not to add more.
Then
issues.
he's still in that case. So if Ms. Blair and Mr. Blair and Ms. Stiver want to not have him, they have to address that with him and can move to withdraw, but he's still counsel of record in those 2 cases.
Sure. So to bring it all together, Judge, I think that I don't want to do anything with the third-party complaints before the 28th, because we obviously are seeking attorney fees and costs for our damages against Ms. Blair. And I don't want there to be an argument about, you were doing stuff for the Mark Verpalat claims and the Karen Stiver and Patrick Blair claims. So to keep it really clean, we can keep everything to Ms. Blair, Rosemary Blair, until the 28th. And then if those other claims don't resolve themselves, then we can pick those back up in an expedited manner.
All right, well, here is another thorn in the side. The statute, MCL 600-5739, the amount of money sought by a claim or counterclaim shall not exceed the amount in controversy that otherwise limits the jurisdiction of the court. This court has $25,000 statutory jurisdiction. On the court's own motion or the motion of either party, all money claims and counterclaims exceeding the district court's jurisdiction must be removed to the circuit court in accordance with MCR 4.002. If the money claim or counterclaim is sufficiently shown to exceed the court's jurisdictional limit. I don't want to dump this on the circuit court. I'd like to resolve it here, but the statute says must. So new counsel, Mr. O'Brien or whoever comes in, may raise that issue. And costs and damages are 2 different things, and attorney fees are something different altogether. But it says all money claims and counterclaims exceeding the court's jurisdiction must be removed to the circuit court. So take a look at that. And that is a shadow looming over these proceedings.
I think there's an easy answer to that question, Your Honor, which is after we establish the amount that Mr. O'Donnell and Ms. Bowers have paid Ms. Blair, then we have a balance left on the land contract. That balance left on the land contract will be set off in recoupment from our damages. So there wouldn't be an affirmative award of damages exceeding $25,000. It's just going to come out of the kitty about whatever Ms. Blair claims that she's owed the $300,000 for the remainder of the purchase price. So it wouldn't exceed the jurisdiction of this court through set off and recoupment over $25,000.
All right, again, I don't think she understood anything you said, but we'll address that.
Well, Can I say something, Your
Yes.
Honor? I mean, I'm no judge. I'm no lawyer. I don't know all, but I have damages that exceed over $25,000 that happened to me.
All right, that's your claim. Right now, this started out as a termination of tenancy action.
Correct.
You wanted them to
Correct.
move.
No,
And
I wanted them to do what was right. That's all I wanted, Your Honor. They could have not gone in the house.
Your
when
Honor,
the
again, I'm just
placard-
gonna
Stop.
object.
yes, you filed an action to remove them from the house.
What do you mean? Oh,
You filed a termination of tenancy action.
right,
So this started as a termination of tenancy. I do,
because they wouldn't get out of the house when the placard, and you signed the thing. They couldn't, dog, animal,
all right, all right, all right.
no
That-
one
that-
could stay in the house and hear if the front.
Stop, because you're sort of testifying and you're the party. So you're right. Things you say can come back to haunt you.
I'm.
All right, anyway, you asked and Miss Hines was adamant. She wanted them kicked out of the house. And Mr. Yonker wrote him a letter and said, you got to get out of the house immediately. We're using the condemnation clause to terminate this agreement. So it was a termination of tenancy. They wanted them out of the house. The condemnation had already been resolved by the time we heard this. The problem had been rectified and the house was habitable sometime later that fall, I think September.
No, November 16th.
All right.
November 16th is when the placard came
Okay.
off.
All right. So our hearing was after that.
Yes,
Okay. So you wanted them to move. I denied that order, saying they don't have to move. I believe this violated the lockout statute. And they have a purchase sale agreement. So I allowed them, after several adjournments and delays, to move back in the house, and I set the rent at $2,000 per month. They're paying that to me. So far, I believe they've paid May and June. I think the court has received $4,000. And they will continue to pay that to the court while this matter continues. And then depending on how it turns out, they either get the money or you do. But the termination of tenancy case is denied. But, all right, so let's say we go through, let's deny. Well, the period of he continually calls it a land contract. I'm not sure that it is a land contract. It's called lease option to purchase. Which is different than a land contract, because if it was a land contract, they've got to be given time to cure and 90 days or 180 days. So I think it's a lease option to purchase and not a land contract. But at any rate, it's expired.
you're right.
Because we've been fighting this legal fight for 6 months now. It's expired. So their time to purchase the house for that price has expired. They contend it expired because of the actions of our landlord. And we wish to enforce the terms of that contract. We wish to purchase the house at that price. And one of the things I granted in the default is a specific performance that they be allowed to purchase the house at that price. Now, right now, there's no time limit on it. I probably would calculate the time that was left at the time they got the notice to quit. But that's what they want. I think you understand that. They want to purchase the house at that price. Now, they want to offset it by money they've claimed they've already paid you. So $450,000, and they claim they paid $112,000.
24.5 of it was for option to purchase, which is non-refundable.
All right,
and not
well,
against the purchase price.
no, I don't think that's what it says. And it also, they want to offset all their expenses. So $100,000 attorney fee would be applied toward the purchase price of the house. So you need a lawyer, and I'm giving you until June 28th to get one. And if you don't have one, you have to appear yourself and do the best you can. This is a civil matter, not a criminal matter. You don't get a court-appointed attorney in a civil matter, although frankly, there is some legislation percolating around to give tenants the right to have court-appointed counsel. But that's not currently the law. I don't think landlords would get court-appointed counsel, but tenants may get it. Anyway, there's a lot at stake here. There's a lot of money at stake. There are complicated legal issues, and I understand that you're not prepared to represent yourself in those complicated legal issues. So I'm not trying to threaten you or frighten you or intimidating you. I'm trying to alert you to the fact that the waterfall is not very far away and you're about to go over it. That's why I strongly encourage that the parties resolve the case to save lots of attorney fees and gnashing of teeth and wailing. But we'll address it further on June 28th. Nobody wanted to adjourn it, but I don't see another answer that's any better than that. So I will do the order setting aside the default on Mr. Verpalat. I will do the order granting the plaintiff's motion to adjourn. And Mr. Hatch will do the order to deny the motion to set aside the default. Anything further?
Nothing further. Well, a couple things, Your Honor. Would you like me, because it seems like the motion to withdraw actually requested an adjournment of the hearing, so I'm happy to prepare a 7-day order and say the motion to withdraw, so we have it in the file, was granted, or excuse me, was granted with the adjournment as part of
that's
that
fine.
motion. So I can do it all.
That's fine. And put
I'll
the
have
adjournment date to June 28th at 8:30.
And then I'll also draft the order for the notice to set aside the default, which is denied. My only other point that I'd like to bring up, and I know it's the Friday before the holiday, so I won't keep you too long, is we would be happy to participate and facilitate a mediation before the 28th, which I think is a big part of this case that hasn't happened yet. I think if we got a good mediator, if we brought the parties together, if we took a day or an afternoon, then we might not need to proceed with the gamut of issues of this case.
Well, here in this court, we use the Citizens Mediation Authority, which is out of St. Joe, and it's responsible for about 6 counties in this corner of the state. They do a very good job. I don't send very many cases to them. Some judges dump all kinds of stuff on them. I use them only when I think it's appropriate. This is an awfully big case for them. If she gets counsel, you can discuss that with them and I can try to help set it up. We don't have the same kind of facilitative mediation they have in circuit court, but I think mediation could help. I'm not afraid to do this, other than it just takes lots of time and there are a lot of legal issues and I don't want to make any appealable issues. But everybody's better off if the parties can come to a settlement. So that's certainly something I would consider.
And that's right up the line, Your Honor. I wasn't suggesting that, the court didn't want to take the time for this, but I think that Ms. Blair sees this, the light is red and we see the light is green. And I think if we took a day to come together, like I did with her lawyer at the deposition she didn't show up for, I think that would resolve a lot of the issues.
I'm not sure what it is, but something's providing feedback, microphone.
Yes, it's the hearing device. When she turns it up too hard, it feeds back. All right.
I'm sorry.
You're fine. You're doing the best you can. And frankly, it's only the first or second time we've used it. So
First time I ever used it.
well, you don't need to apologize. We'll work the bugs out, but as long as you can hear us, we'll be fine. What he's suggesting is that perhaps the matter be set to mediation. There's not a lot of time. and there are a lot of issues. And if you need my help, I will do what I can, but she's gonna need legal advice.
Thank you.
All right, now, again, why don't you do an order regarding the deposition as well? It shall not be before 14 days, but she shall appear unless she's excused by the court.
Okay. Do you want me to do a separate order for that? So I can
Now, the problem is that was gonna be at Mr. Hauser's office.
Mr. O'Brien's at Grand Rapids, if she just chooses to.
All right.
And again, I don't want to.
Well, it'll be where her attorney is.
I think we've had that motion before, and I think the court spoke on that. So if she
All
didn't
right.
want to come to Grand Rapids before, which I.
All right, or you could do it here at the courthouse. We'll make space available here.
Well, Your Honor, we would ask that, I do it at her lawyer's office. I'm in Grand Rapids, her lawyer's in
Oh.
Grand Rapids.
All right, well, that's fine, whatever you guys can come up with. But right now, he's not our lawyer. Mr. O'Brien might say, I watched that video and I don't want to touch this with a 10-foot pole. So I don't know. We'll see where this takes us. All I know is we're gonna resume on the 28th of June at 8:30 in the morning. All right, Miss Blair, nothing's gonna happen. The status quo remains in effect. If you haven't paid June's rent, you're gonna pay it to the court. And everything else, you have possession of the premises. There are also those issues about personal property, wave runners and trailers and stoves and refrigerators. And so a mediator could help with that too, I suppose. All right, we are in adjournment. And Miss Blair, I will see you on June 28th at 8:30 in the morning.
When do I ever get to say anything?
Well, you don't, because I've granted your motion to adjourn.
I mean, but when I get new counsel, do I get to talk?
Oh, yes, you can get under oath and you can tell your whole side of the story to your heart's content. I'm not gonna prohibit you from telling your side of the story. I didn't want you to do it here today. One, you're not under oath.
And I'm not an attorney.
And
I
you're not
haven't
an
talked to-
attorney. So when you have an attorney, and if you want to tell your side of the story, and that's what he wants to do, I'll listen to everything you have to say. There are two sides to every story,
Thank you.
sometimes more. I'm gonna put on my tombstone, the truth is somewhere in the middle. Anyway, we'll resume on the 28th of June.
Thank you, Your Honor.
Thank you.
You can just leave that right there.
Rosemary, you can leave it right
Oh,
there.
you just leave it right there. Leave them here? Okay, thank you.
Good morning, everyone. We're about to go on the record. We're continuing the matter, complicated matter of Rosemary Blair versus Joseph O'Donnell and Carla Bowers. It's had quite a procedural slog through the system. Been adjourned several times, continued several times. I blocked out the entire day today for the matter. We have two new attorneys that will be appearing here, Robert Soltis for Rosemary Blair, and Jennifer Wu will be appearing for Mark Verpalat, one of the third-party defendants. Anyway, good morning, everyone. Let me get started here. For my Rutgers friend, I finished in second place at the end of the Learned League season. I think I'm in like a remedial division, but it's the highest I ever was. All right, let's go on the official record. This matter is entitled Rosemary Blair versus Joseph O'Donnell and Carla Bowers. The file number is 221862. There are 3 third-party defendants, Mark Verpalat, Patrick Blair, and Karen Stiver. Attorney Daniel Hatch is here on behalf of Joseph O'Donnell and Carla Bowers. Mr. Soltis, why don't you go ahead and put your appearance on the record?
Thank you, Your Honor. Robert A. Soltis on behalf of Rosemary Blair. Ms. Blair is right to my left.
Good morning, Ms. Blair.
Good morning.
Mr. Hatch, why don't you go ahead and place your appearance on there as well?
Good morning, Your Honor. Dan Hatch on behalf of defendant counter plaintiffs Joe O'Donnell and Carla Bowers,
Who are both present also. We have a new participant here. Attorney Wu, would you come up and place your appearance on the record as well? Come up to the podium if you would.
Sorry.
Just come to the podium there so you'll be on camera.
Oh, lovely. Jennifer Wu of the law firm Lewis, Reed & Allen on behalf of third-party defendant Mark Verpalat.
Thank you very much.
Thank you
for being here. Theoretically, this matter was set for a hearing regarding damages in this matter. As I indicated, it's got quite a procedural history. We were here on May 26th and made a pretty extensive record. And Mr. Hatch presented an order to reflect my finding where I denied plaintiff's motion to set aside the default. Mr. Hauser filed an objection to that, so that order has not been signed. It just simply states, for the reasons stated on the record, the court being fully otherwise advised in the premises, it is hereby ordered that the motion to set aside the default against Rosemary Blair is denied, which was accurate. But there's a question about whether it's denied with prejudice or without. I'm not sure what difference it makes, but anyway, that order has not been entered, but I did deny the motion to set aside the default. The default entered. There was, I believe, a non-timely motion to set aside the default, which didn't comply with the court rule. It was just a one-page thing that said I moved to set aside the default. So I denied the motion to set aside the default because it didn't comply with the court rule. Shortly after that, Ms. Blair indicated she didn't want Mr. Hauser to represent her anymore, and he was released from his obligations. So we didn't do what we had hoped to do on May 26th. I again blocked out that entire day, or maybe just the afternoon, but I blocked out a block of time. So we searched for another day, and today is a jury trial day, and the 2 cases that were set for jury trial, fortunately, both resolved. So I blocked out all day. So Ms. Blair, at that point, asked for an adjournment because she didn't have counsel. Mr. Hatch objected to that, but I felt in good conscience she needed to have representation. It was clear she didn't completely understand everything that was happening here, not because she's ignorant, but because she's not an attorney. And so I did continue the matter. She was scheduled for a deposition on June 12th. And was that the date, Mr. Hatch?
I believe it was June 16th, Your Honor, which was a Friday.
All right, June 16th.
Correct, Your Honor.
And there were some last minute scrambles. She requested to not appear. I denied that request. There was another attorney in there somewhere from Crown Point or somewhere in Indiana, said she has to be there. She didn't appear. So a separate record was made. She wasn't present. Mr. Hatch requested contempt, jail, attorney fees, and a number of other things. And that matter is somewhat left open as well. So we've got the issue regarding the entry of the original order. We've got the issue regarding the contempt of Rosemary Blair. And theoretically, this matter is set for a hearing regarding damages. I raised the issue multiple times regarding the plaintiff's request for damages in excess of $25,000. All of the third-party cases, the claim, counterclaim, or third-party claim is in excess of $25,000. By statute and court rule, the district court has jurisdiction in matters up to $25,000, including landlord-tenant matters. And the court rule, it's in 4.2 something.
4.201, Your Honor.
4.201. Doesn't really give the court discretion. It says if either party moves to remove the case, the court shall remove it to the circuit court, not may, shall. This comes up several times a year. So that issue had never been joined. It was discussed. Mr. Hauser never made such a motion, and neither did Mr. Hatch, and the court didn't make one on their own. Frankly, I didn't want to dump this matter all on the circuit court. It's complicated, it's fact specific, it's got a lot of previous court proceedings, and to remove the matter, I think would put great amount of delay and expense. So in hindsight, maybe I should have removed it right from the get-go and let the circuit court start with it, but we did not. So Mr. Soltis, who appears before this court quite often in landlord-tenant matters, has filed an appearance on behalf of Ms. Blair, and he's challenging the jurisdiction of the court to determine the damage question, and that it's over $25,000. Normally, the district court does not have equitable jurisdiction, but in some landlord-tenant cases, there is some equitable jurisdiction. And in this case, by default, I have ordered specific performance that she comply with the terms of the original lease option to buy or land contract or whatever we're going to call it. So they've asked for specific performance. We want to buy this house at the agreed upon price, and that's been ordered. We haven't nailed the terms down, but that's in the pleadings. It was subject to the default. It was not set aside. So where does that leave us? Let's start first with the entry of the order. Mr. Hatch, you submitted the order as I directed, and it states that the motion to set aside the default was denied for the reasons stated on the record, which I've restated here. Do you wish to speak to that any further?
I do, Your Honor. Thank you, Your Honor. Dan Hatch on behalf of Joe O'Donnell, Carla Bowers, and may it please the court. You're right. The May 26th order, I drafted it. I submitted it under the 7-day rule. A couple things. Number one, Mr. Hauser was terminated as Ms. Blair's counsel on May 26th in front of this court. He withdrew his counsel. He no longer represents Ms. Blair. The court denied the motion to set aside the defaults because it found, as we briefed, that there was no meritorious defense and no good cause to set aside the defaults. So I offered to submit an order. I submitted an order under the 7-day rule. It stated that the motion was denied for the reasons stated on the record. And I put with prejudice, as I do on most motions, because you can't just bring the same motion over and there's a there's a way that you can seek relief from the court. It's called the motion for reconsideration. You can't just file another motion because you hire a new attorney and now you want to try to bring it again. So that's why I put in the order it's denied with prejudice, which it was. Ms. Blair, Mr. Soltis could file a motion for reconsideration, which they have not done so far. So number one, the order is accurate. And number two, it's precarious that Mr. Hauser would be filing an objection when he doesn't represent Ms. Blair. He was relieved of his duties to represent Ms. Blair. He still is counsel of record for Karen Stiver and Patrick Blair. He has no standing to object to an order that has nothing to do with his clients, who are Karen Stiver and Mark Verplat. So for the reasons that the order is accurate and the fact that Mr. Hauser doesn't have any standing, we would ask that the court enter the order as it was submitted. Thank you.
Mr. Soltis, do you have any comment regarding that?
Yes, Your Honor. A couple things. If the court is ordering that order that was presented be entered, the time for reconsideration hasn't even begun, never mind passed. So that's still open. I've gone and looked at the tapes that we were made of the hearings in the past. I don't believe the court said with prejudice or without prejudice. So what my request is, Judge, just strike out that last language and let the order accurately state what you did. You denied the motion.
And I didn't state it, so that is what I'm going to do. I'm just going to take that out. Counsel's right. You can't just refile the same motion over and over again, but there is a way to do it. So I've stricken the last two words with prejudice and I've signed the order. Somehow it's got a 220. So the date of the order is today, 6/28/23. Denying the motion to set aside the default. It has the same effect. That order remains, including the order for specific performance. All right, the next issue is regarding the contempt of the defendant, Rosemary Blair. Mr. Hatch was quite vocal in his objections. He was here. I don't think they ended up bringing all their everything they needed, but he was here prepared to do the deposition. She was told on the record she was to be here. There was an order denying her request to not come, and she did not come. So we're here for today's hearing. Mr. Hatch has not had an opportunity to depose Miss Blair. She wanted to tell her side of the story. And she said, when do I get my turn? And I said, well, I'll get the turn at the deposition and at a later hearing. So this record was made without counsel being here, without the defendant being here, and I didn't make any finding. So at risk of having you say everything all over again, what's your position regarding the contempt of the plaintiff, Rosemary Blair?
Thank you, Your Honor. I won't rehash everything that we talked about on the 16th already, but the motion for direct contempt was entered by the court on June 16th. So as I stated, we've got various sanctions and relief that were requested in the motion. Some of those are moot at this point, but at this time, we are asking for two forms of relief for the direct contempt. So under MCL 600.1721, following the finding of civil contempt, the court may order any or all of the following sanctions: a fine of not more than $7,500, a coercive conditional jail sentence to compel the party in contempt to comply with the order. I understand the court has denied that. And if applicable, damages for loss or injury caused by the contempt conduct. So it's up to the court to decide whether they want to impose a fine. We would be asking under MCL 600.1721 for damages for loss or injury caused by the contempt conduct. Those damages are, as we state in our motion, $6,500 that we incurred And that's not the total expense, but I think that is a reasonable expense for Ms. Blair failing to show up for her deposition twice. She failed to show up for her deposition on May 16th, and she failed to show up for her deposition in direct contempt of this court's order on June 16th. So I prepared for Ms. Blair's deposition twice. I drove to Mr. Hauser's office. Here is the deposition exhibit book with all the exhibits that I was going to go through with Ms. Blair. It was going to last all day, 7 hours. I spent a significant amount of time preparing for a deposition of a critical witness in this case. So it's not like something I was just going to do in 2 or 3 hours. I spent a lot of time preparing twice for a deposition. So at my rate of $395 an hour, which is reasonable under the per group factors and under the State Bar of Michigan, State Law and Economic Digest, it's 16 hours, which would be very reasonable for my travel time from Grand Rapids to Kalamazoo to Mr. Hauser's office, which Ms. Blair didn't show up to, and from Grand Rapids to the courts, which Ms. Blair didn't show up to, in addition to the preparation for the deposition twice. So those are the money sanctions we're asking for. Also, as a sanction for her failure to comply with discovery, MCR 2.313, which is failure to permit discovery sanctions, under section MCR 2.313 B2 subsection B. If a party or an officer, director, or managing agent of a party or a person designated under MCR 2.306 to testify on behalf of a party fails to obey an order to provide or permit discovery, including an order entered by the court under subrule A, the court in which the action is pending may order such sanctions that are just, including but not limited to the following. So subsection 2 has been met. Ms. Blair failed to appear for her deposition and permit discovery twice. Subsection B states, an order refusing to allow the disobedient party to support or oppose designated claims or defenses, or prohibiting the party from introducing designated matters into evidence. So in addition to the monetary sanctions, we are asking for the sanction to prohibit Ms. Blair from supporting or opposing our claims today for damages. And that's probably the next issue we're going to get into, which is what are the claims and what damages are going to be presenting. But that is the sanction we're asking. There's no trial by ambush. I have the opportunity to depose Ms. Blair before the trial. If she wanted to tell her story, she should have come to the deposition twice. It's not fair for her to duck out in a deposition and then try to hoodwink us at trial by going up and testifying when I haven't had an opportunity to depose her. If that was the rule, no party would ever show up for a deposition. They would just try by ambush every single time. So there's reasons for depositions. Ms. Blair chose not to show up for a deposition, and there's a court rule specifically stating that if the disobedient party fails to permit discovery, i.e. a deposition, that the court can prevent her from supporting or opposing the designated claims. That's directly on point and what we're asking here for today. So $6,500 of our expenses incurred for the direct contempt, and that also prevent Ms. Blair from testifying, opposing our claims, or admitting any evidence in this hearing or any subsequent hearings in this matter. Thank you, Your Honor.
Mr. Soltis? Yes, Your Honor. Ms. Blair informed the court that she couldn't be here because of a doctor's appointment. And that information, according to the Register of Actions, was transmitted to Mr. Hatch before the death. So, and then my understanding is he came down here and he was down here anyway. He said to the court, yeah, I'm down here anyway. So, let me take care of that. Well, Your Honor, first of all, if he drove to Hauser's office, I don't know that. I've not seen any bill of cost here or anything like that. So I don't have that information. So I can't respond to how much time and whether or not that's reasonable. If I had it, I could, but I don't. Second of all, Your Honor, when he says he has to prep twice, I don't think I would do that, and I don't think that's reasonable.
I can identify, I've had this file out 15 times and I get all ready to go. And one day we got tornadoed. It was nobody's fault. And I had everything, spent 2 days going over everything, was ready to go. And the tornado never came, but they shut the courthouse down. So we had to move it. Then I had to do it all over again. Then we were here on the 20th, in the date in May, and I prepared everything. And Mr. Hauser was removed, and so we didn't do anything. So I had to prepare all over again. So I can identify with having to get ready over and over again. My memory isn't what it was when I was 25. And so I have to reacquaint myself every time I have to dive back into this big, thick file.
Well, I understand that completely, Your Honor. However, Mr. Hatch claims that he's got a big old binder here, which means he prepared. And for him to go through that all over again, I think would either take a very little time, if he's even going to go there. I normally write down my questions before a deposition. And oh, by the way, if I have to take the deposition later on, I look at my questions, they're already there. So it's not a chance where he has to go through the whole amount of evidence that you had to go through, but just whatever he wanted to ask of Ms. Blair. And Your Honor, there was no trial, and right now there is no trial. So I think the sanctions, yeah, there should be some money sanctions against Ms. Blair. $6,500, I can't tell you whether that's good or bad or indifferent, but I do think it's maybe a little, maybe high. I think Ms. Blair should be able to question the damages and present evidence that, you know, the evidence is not correct. One of the issues in this case that I know the court has mentioned before is how much money was given to Ms. Blair for representing the down payment, if you would, on the lease option. It's not a land contract, the lease option. And, you know, that is probably going to end up being determined by the circuit court. I've talked to Mr. Hatch, and I think we both are in agreement. He can disagree with me if he wants, that because of the fact that the court doesn't have the jurisdiction over 25,000, that if the damages here go over 25,000, that's got to go up to circuit too. And I know it's not the ideal resolution, because I know the court doesn't want to send this up to the circuit court, because yeah, it'll take a bit. But on the other hand, if it goes over 25,000 and Ms. Blair is required to appeal, that's going to take even longer. And, you know, I don't think I think the only solution is to send this to circuit court. As for the deposition.
Well, why don't you go ahead? You sort of segued into your motion regarding jurisdiction. And why don't you address that further?
Your Honor, if I could just, before we segue into the jurisdictional issue, if I could just make a couple comments about the cost.
Yes. Stop. I'm ordering $6,500 in costs.
Okay.
She explicitly did not have my permission to not appear. I told her to be here. I did an order that said she didn't have the right to be here. I think it was a pretext that she was trying not to come. So you prevail. I'm not ordering 7 days jail or $7,500 fine or the other things you asked for. However, I'm ordering your costs. So you may do an order that Rosemary Blair, as a sanction for contempt, shall pay $6,500.
And Your Honor, we did put in the motion as well, because I've ran into this issue before, that, you know, when is that due and payable? So we have asked that she tender payment to undersigned counsel to my firm ILTA account within 14 days of the court's order, just so that there's a cabin dates on when it is due.
Your Honor, because of the amount, I would ask that it be 30 days.
That's fine.
And just very, very quickly, Your Honor, I don't want to get into, I understand the $6,500, but to Mr. Solis's comment about prepping twice for a deposition. When I showed up on May 26th.
You already won.
I know,
so
but
I may just make you feel better, but
I take offense to the fact that if someone thinks that I'm churning the file, I don't work like that. When I showed up to Mr. Hauser's for the first deposition, we had a very good conversation about a lot of things that he didn't know about the case. And he turns over to me a massive file that he failed to produce in response to our discovery request. So the additional amount of damages, it was not just me going through my questions again. It was, I added a significant amount of exhibits because there was a lot of documents that had not been produced before that day. I just wanted to put that on the record.
all right. Well, you can do the order. The defendant has been found in direct contempt on the 26th of May. As a sanction, I'm ordering the ship a $6,500 in costs for her failure to appear. I'm not ordering any jail sanction. We have yet to address the issue of whether she can present any evidence, but as indicated, that may not end up being here. You can do the order. 30 days from today would be July 28th. All right. Again, I stated my position on this. Maybe in hindsight, I should have just sent it upstairs right from the start, but I was hopeful I could get this case over the finish line. Mr. Soltis has come into the case on very late notice, and he went right to the pink elephant in the room regarding the jurisdiction of this court to hear the damage claim. Mr. Soltis.
Yes, Your Honor. As I presented in a hearing brief that unfortunately I was only able to file yesterday, is that whenever there, the court rule and the statute and the case law all says that the court cannot has no jurisdiction to enter orders over and above the $25,000 limit. And every one of the claims from the counter complaint that are for damages are asking for $25,000 or more in excess. And as the court, as my brief pointed out, Your Honor, you look at right at the beginning. You don't go way down the line and wait and see if they can prove it. You have to look at the beginning. And if the claims are on their face in excess of $25,000, they need to go up. And Your Honor, I also put in the fact that when there's two exceptions to the rule that attorney's fees are generally not included as damages, but that's beyond the point. But I'll just say it anyway. The two exceptions, as I noticed in Michigan, is if there is a statutory basis for the attorney fees that will allow for attorney's fees. And Mr. Hatch has pled MCL to 600.2191A, which certainly provides for attorney's fees if it becomes that way. And based upon what we hear today, that's going to be well over 25,000. So, Your Honor, I think the only issue that I think the court can address today, jurisdictionally, is the
specific performance.
Right, and the court has already done that. So when we get to specific performance, well, I think it's premature as to what happens because, there's the contract has to be followed. There has to be certain requirements, notice 90 days and all that sort of thing in a closing. We don't know if that'll happen yet. And if it doesn't, then the specific performance I think just dies because, if Mr. O'Donnell and Ms. Bowers don't specifically perform as the court has ordered, well, then they don't get the property.
Well, there's another wrinkle in this. In August of 2021, when the inspection took place and that Mr. O'Donnell and Ms. Bowers were removed from the house, that the closing date, I think, was November 30th, maybe November 1st. Anyway, it was in November. Interest rates were probably 3.8%. And the testimony I recall from earlier representations were that they had been working with a bank to secure the financing to close by the date in the lease option to purchase. There was also testimony that they'd been making monthly payments. That was disputed, just like the large payment that they contend, but they also contend they were giving her, I think, $2,000 a month. Anyway, to close the deal in August of 2021 would cost them X amount of financing costs. To close the deal in August of 2023 is 2023, it's going to be more expensive for them to borrow the same amount of money. So that is part of the damage question rather than the specific performance. Purchase price for the house was $450,000. There's also a dispute as to how much was paid in advance.
Right.
So let's assume that their representation is correct, that they've paid her approximately $120,000. Now, there have been escrow payments being made each month here, which the court is also holding. So let's assume there's $130,000 that have been paid by the defendants. That leaves $320,000 to specifically perform the contract. The problem is that earlier money is in dispute. So your statement's got some validity. How do they specifically perform the contract? I guess they could come in with $450,000 and say, I want the title of this house, and then fight about the rest of it. But it isn't as simple as it was at the time they were removed from the house. So you are specifically requesting this court to remove the matter to the circuit court.
Correct. And Your Honor, let me kind of elaborate on my thoughts on this. First of all, if there was a provision in the agreement that says they're going to buy the house at $450,000 at 6% and whatever percent, and the interest rates are above that now, or when they actually do try and buy the house, I guess, they actually exercise that option, then we will know that as a measure of damages. But the contract doesn't provide for that. It provides for,
well, you give me the money, we don't care how you get it.
right. And there's a chance that Mr. O'Donnell and Ms. Bowers can pay cash, and there goes the whole interest aspect of it. They pay cash, we don't know where it came from and we don't care. But if they pay cash, then they're not financing, and the interest rates are, I think, irrelevant. Plus, between now and then, I think the interest rates may change. In fact, I'm confident they'll change. Come on, the way the Fed's been doing it, they've been changing the rates about every other month.
All right, thank you. Ms. Wu, while you're here, would you come up? Are you going to request that I remove the case as to Mr. Verpalat as well?
That's correct. There's one claim made against him by the defendant's third-party plaintiffs for tortious interference, and that is in excess of $25 that we would ask that that be removed. I did have a conversation with Attorney Hatch prior to today's hearing. There had been a discussion of a bifurcation of the claims. I'm not sure exactly what is remaining in the landlord-tenant action, but I would agree to have that removed, or at least for my client's claims to be removed to circuit court because of jurisdictional amount.
All right, that pink elephant has been in the room since that third-party claim was filed. Again, I didn't do it on my own motion, neither party removed it. I raised it again at our last hearing, just before Mr. Hauser was, no, Mr. Hauser is still in it for Patrick Blair and Karen Stiver. All right, so again, I have a specific request to remove that, and I don't have any discretion in the matter. So, all right, we'll hear from Mr. Hatch and see what he's got to say. Thank you.
Thank you, Your Honor.
Thank you, Your Honor. I think there's a really easy solution to this, and I agree with about 70% about what opposing counsel said here. So, which is good.
Right.
So it's a good start.
It's better than zero, I guess.
It is. We would stipulate to bifurcate this case as to certain claims that exceed the jurisdictional threshold of the district court. The claims in this case are count 1, breach of contract, count 2, specific performance, count 3, violation of the anti-lockout statute, count 4, tortious interference, count 5, summary proceeding, count 6, quiet title, count 7, civil conspiracy, count 8, common law conversion, count 9, statutory conversion, count 10, trespass, and count 11, claim and delivery. So I believe the court was.
Where was specific performance in there under breach of contract?
That is count 2. It's right after breach of contract. All right. MCR 4.002, which I think the court was referencing, states if a defendant asserts a counterclaim or cross-claim seeking relief on an amount or nature beyond the jurisdiction or power of the district court in which the action is pending, the court shall either order the action transferred to the circuit court to which the appeal action would ordinarily lie, or inform the defendant the transfer will not be ordered without motion and notice to the other parties. So I think that's where you start out. But you have to specifically look to MCR 4.201. And that specifically has to do with removal of certain claims from the district court. MCR 2.401 subsection G2, claims and counterclaims, removal.
Give me a second. All right, what section are we referring to?
Subsection G2, titled removal. G2, subsection A and B.
Okay.
Subsection A states under removal, a summary proceeding action need not be removed from the court in which it is filed because an equitable defense or counterclaim is interposed. Subsection B, if a money claim or counterclaim exceeding the court's jurisdiction is introduced, the court, on motion of either party or on its own initiative, shall order in accordance with the procedures in MCR 4.002, which is the original one we just went over, removal of that portion of the action to the circuit court if the money claim or counterclaim is sufficiently shown to exceed the court's jurisdictional limit. So Ms. Blair has asked that the court just kick it all up to the circuit court. It's not how it works. So we would agree to bifurcate this case, the claims in this case with respect to count 1 breach of contracts because the damages do exceed $25,000. Count 3 violation of the anti-lockout statute, over $25,000. Count 4 tortious interference. Count 7 civil conspiracy. Count 8 conversion, count 9 statutory conversion, count 10 trespass, count 11 claim and delivery. We want to do that for a couple reasons. Number one, we want to make sure that this case is appeal proof. And also we want to make sure that if we're in district court for our money damages claim, we're capped at $25,000. We don't want that.
Well, or if I granted more, certainly it'd be subject to appeal, and nobody wants to do this twice.
Right. So those are the money damages claims. So we will stipulate under MCR 4.201, and I've had conversations with both opposing counsel before today, that we'll stipulate to count 1, count 3, count 4, and count 7 through 11. The court does not have to and should not kick up the claim for specific performance, summary proceeding, and quiet title. Those under MCR 600.8302, equitable jurisdiction of the district court. This court has jurisdiction under those claims. Specific performance is an equitable claim. It's attached to a breach of contract claim, but we're asking for equitable relief in the form that hopefully we'll be presenting here today. Summary proceedings, again, the district court has exclusive jurisdiction over, and also quiet title. So MCL 600.8302 subsection 3 states, in an action under Chapter 57, which is the Summary Proceeding Act, the district court may hear and determine an equitable claim relating to or arising under Chapter 31, 33, or 38, or involving a right, interest, obligation, or title in the lands. That's what our specific performance claim relates to. That's what our summary proceeding claim relates to. And that's what our quiet title claim relates to. So the solution, to this puzzle is simple. We will stipulate to bifurcate the case with respect to the claims that I identified, and the court should hear, because you've already entered a default, not a default judgment, with respect to count 2, 5, and 6. So we're here today, and it would be a logistical nightmare to try to transfer those claims. This court's heard this case for 6 months. We're at the finish line, so we asked to proceed with count 2, count 5, and count 6, and the time is today to proceed with those claims. So you don't need to kick the entire case up to the circuit court. The money damages can go up there. We'll have a hearing on money damages for those claims, and then the summary proceeding, specific performance, and quiet title will be handled by this court. Thank you, Your Honor.
All right. Before you respond to that, how do we accomplish specific performance? As Mr. Soltis says, if they come in with $450,000, we don't care where it came from. So I would order that, and the problem is for your client, let's just assume, as she argues, she's received 0. That's not accurate, because there's some money in escrow, probably $6,000 to $8,000. They've paid 3 or 4 months worth of payment in escrow. But absent that, they've got to come up with a whole $450,000. Then I order that they quiet title, and the summary disposition for removal is denied. And they pay $450,000. They get the house and the deed. Then your next 2 years fighting over damages in circuit court. Is your client prepared to do that?
The way that I see that's the most efficient process, Your Honor, is that we have a hearing. So the court has entered a default, not a default judgment on specific performance. Default establishes liability. A default judgment establishes damages or the remedy. So while the court has already entered default for specific performance, we need to offer proofs here today to address exactly what the court said. Ms. Blair claims she received $30,000. We will present evidence today that's incorrect. That goes into the amount that they paid under the land contract, which then goes into how do we determine the equitable remedy of specific performance. So we do need to put proofs on here today to enter a default judgment. Again, I want to make this appeal proof. Just the default doesn't do anything for us today. The court has to hear our proofs as far as formulating the equitable relief under specific performance. So, and this will be part of our trial here today, is that equitable relief is beautiful for specific performance. The court has discretion to create a lot of different remedies. So we will be asking the court to compel compliance with the closing of the transaction, the original 90 days, as set forth in the land contract, less the payments that have already been made to Ms. Blair, which we'll enter proofs with here today, and that she, it's in our complaint, but that she tender the sale and the instruments for delivery of the property over to my clients. And then that amount will be offset through set off and recoupment, which the court has the equitable remedy to do, from the amount of damages that are determined in the circuit
And
court.
see, I'm not gonna do that. At least, we won't be able to accomplish that within 90 days.
Well,
I'm willing to hear testimony regarding your contention that certain amounts were paid. Your set off in attorney fees is probably gonna be in excess of $100,000, but I'm not gonna fry that fish here. That's gonna be a circuit court matter. But you do have a leg to stand on regarding the first portion. As a practical matter, I could just remove the whole thing to circuit court. I didn't want to do that. If the matter is removed to circuit court, you might assume this is going to take 2 years. All the transcripts of all the proceedings going to have to be prepared. Judge Stutzman's going to have to familiarize himself with all these complicated claims and counterclaims and previous orders entered by the court. They've got to schedule it for hearing. There may be further depositions. It's going to take a long time and cost a lot of money. If I can accomplish the specific performance and give the buyers a certain dollar amount and date and compel Ms. Blair to tender the deed, that portion is done. They would own the house. Then you can spend 2 years fighting about the money. But I'm not going to go down the rabbit hole of all of the other stuff to offset the amount. If you want it removed to circuit court by stipulation, that will be a money question. So, Mr. Soltis, your response?
Oh, my response.
Well, first of all, he agrees to now, regarding the third party claims, my inclination is to simply remove all 3 of those right off the bat, rather than get caught up in this. The damage is clearly in excess of $25,000. But regarding Rosemary Blair's specific performance claims, he proposes to present evidence as to how much was actually tendered, so I can give a figure for the defendants to comply with the purchase price. What's your response?
My response, Your Honor, is that specific performance means exactly that. Specific performance with the lease agreement. And if you look at the lease agreement, there are provisions that even after 90 days, we won't know exactly what the amount is, because it says, in the event there is an unforeseen delay for any reason, the purchasers shall pay $1,000 monthly until financing is secured. Will they pay it? And, in my opinion, this is still a question of whether or not they will actually exercise that option. And if they don't exercise that option, they don't get the house.
Correct. But I'm going to tell them you've got to exercise the option by a certain date for this amount of money.
And they need to also follow the other requirements of this contract. Do they not?
Yes.
Okay.
Which are what?
I just told you. It's $1,000 a monthly if it isn't. If they cause damage.
Well, right now they're paying $2,000 a month into escrow by court order. And to my knowledge, they haven't missed any payment. So, all right. This is going to take us all day, but that's why we blocked out the day. I'm going to allow you to present evidence regarding the amount that you contend your clients have paid either in direct lump sum or in monthly payments. And Miss Blair is precluded from testifying in opposition to that because she didn't show up for a deposition twice. So I'm going to take your evidence essentially unchallenged. He can certainly cross-examine and argue about it, but you're right. If you could fail to appear for a deposition, then show up at the trial and give your testimony. What's the point of compelling a deposition? You just duck it by not appearing. So you can't have it both ways. So we're going to take a recess. I will, Ms. Wu, I would ask you to prepare an order removing Mark Verpalat's case to the circuit court. I will do an order. Mr. Hauser is still actually counsel of record for Patrick Blair and Karen Stiver, but I will do an order removing those matters also to circuit court. So the third party claims all have to do with money damages, and they'll be in circuit court. I will accept defendant's offer to remove all of the money claims to circuit court. And Mr. Hatch, I'd ask you to do an order to that effect.
Certainly are.
And we're going to address the three non-money aspects of the complaint: summary proceedings, specific performance, and breach. Oh, what's the third one?
Quiet title.
Quiet title, yeah, obviously it goes with that. So we'll take a recess, we'll come back, and we will start with that.
Could I just intercede a couple of things
Yes.
which maybe move this along?
Yes.
First of all, I have Mr. Coleman and Mr. Wiki present today. Obviously, you're not going to allow them to testify as to the anti-lockout and all that sort of thing. So may they be excused?
Well, I said Miss Blair couldn't testify. I didn't preclude.
They don't have they don't have information as to what amount was paid or not paid.
All right, yeah, they're here often as witnesses. They're both very competent, and they're also both very busy. So yeah, they may be excused.
Yeah,
they're welcome to stay if they wish.
Yeah, I understand Ms. Coleman has a meeting or something that he has to attend to, and I'd like to have him be able to do so.
Any objection?
No, Your Honor, and actually we would ask under MRE 615 that they be excluded because they are going to be potential witnesses in this case. They're not parties, so they need to be sequestered. They can't sit here and listen to the testimony here because I'm assuming that with respect to other claims against other parties or even Ms. Blair that are in circuit court to be removed, they may be witnesses.
All right, well, they'll be excused. These proceedings are being live streamed on YouTube, and they're available for review. Mr. Soltis, you may have been able to do that.
I have, Your Honor.
You are specifically prohibited from viewing any of the live stream proceedings on YouTube. It'll be up for maybe 30 days or so. So you're excused. You're also sequestered, and you're not to view any of the proceedings that are available on YouTube, and that may be asked later. I don't expect that you will, but I know you're both busy, and I thank you for being here, and you're both excused.
Thank you, guys.
Thank you, Your
Honor. Thanks. Your Honor, then moving on to the two other counts. For example, count, I think it's, I can't even read my own writing. Count 5 is summary proceedings. You've already ordered that Ms. O'Donnell, Ms. Bowers and Mr. O'Donnell are in the house and denied the summary proceedings brought by Ms. Blair. So I think that's already done.
I think so too.
And, you know, I'd be willing to stipulate that they can stay in the house until there is either a order of the court or they fail to go through with the option. But if they don't go through the option, we probably have to be here anyway. So that would take care of that, I think.
All right.
And the quiet title,
Well, quiet title goes with specific performance. If you're going to perform the contract, you've got to provide the title or the deed to the property.
right, but I don't think this court can order the title quieted at this point in Mr. O'Donnell and Ms. Blair, or excuse me, Bowers, because we don't know where it's gonna go with regard to the option itself. Will they pay it? Will they not pay it? I don't know. When that happens, we'll be.
I guess, or when the terms of the payment are completed, the defendant would be obligated to provide a deed to the property.
I
So,
think that's within your order of specific performance.
yes. All right, so specifically, we're gonna deal with specific performance. We're gonna try to figure out how much has been paid.
Thank you.
So, as I said, we blocked out the whole day. I went to bed early, got up early. Laura's really looking forward to this. Mrs. Blair, can you hear everything with the system?
Yes,
All
I
right,
can.
very good. I'm glad that's working for you. All
I
right,
never did before.
well, I'm glad. It's new and it's just for cases like this. So I'm glad you can hear everything. All right, let's take a recess. 9:45, we'll resume and jump off a cliff.
Thank you, Your Honor.
I'm sorry, Your Honor.
Yes.
I did have a question. Since,
Okay, turn the record back on.
Since we're having the third-party defendants be ordered up to circuit court, is my attendance necessary for the
No,
remaining?
you're
of the hearing?
welcome to stay if you wish, but for a client to pay for you to sit here, so no, you don't need to remain. And those matters will remove to circuit court. And hopefully part of what we do here may help those cases resolve as well.
Thank you, Your Honor.
All right, thank you, but you're certainly removed for any obligation here today. All right, thanks.
Thank you.
All right, let's take a break. All right, we are back. We've cleared the decks of ancillary issues. We are going to address defendant's specific performance claims, which relate to what purchase price was set and what was tendered by the defendants. Mr. Hatch?
Thank you, Your Honor. Your Honor, I think we do have one more housekeeping issue, and I promise I think this is the last one for the day. There was an order entered for the forensic examination of Miss Blair's phone. Miss Blair has failed to comply with that order. I don't want to file another motion of contempt. I think myself and opposing counsel have come to an agreement as far as a stipulation about when she will produce her phone, consistent with that order, to be examined to extract relevant data off of it. I do want to put that on the record here today so everyone is abundantly clear about when the phone has to be produced and what the location is.
All right,
So
you want to do an order to that effect?
I will, and I would just like to stipulate on the record here today, and correct me if I'm wrong, within 7 days, opposing counsel will let me know when Miss Blair is available. We set it originally at the library in Crown Point, Indiana, to make it convenient on Miss Blair. So we'll set that location and a time, and I just want to make sure there's a cabin date on it. The mirror imaging of the phone will take place within 14 days of today. So I'll work with the opposing counsel and we'll communicate, but it'll happen within 14 days.
Agreed, Your Honor.
All right, very good.
Your Honor, if I may, before we call witnesses, just a brief opening statement.
Yes, thank you.
Your Honor, this hearing is about green lights. So the first question that you probably have is, what do green lights have to do with this case? In life, green lights mean go, carry on, advance, continue. On the road, green lights are set up to give the flow of traffic the right of way. And when scheduled properly, more vehicles catch more green lights in succession. Green lights say proceed. In trial, green lights are affirmations of the truth. They're proof, support, praise, gifts, gas in the fire, attaboys, and appetites. They're cash money. See, we love green lights. They don't interfere with our direction. They're easy like a shoeless summer. Green lights say go and give us what we deserve. Now, green lights are earned, they're not given. And the purposes of today's hearing, we are going to prove by a preponderance of the evidence the relief that Joe O'Donnell and Carla Bowers are entitled to as part of this lawsuit through green lights. Before we get into proofs, I want to briefly discuss the remedies that we're asking the court to award here today, specifically the equitable remedies of specific performance and quiet title. In America, we don't believe in eye for eye justice. We're not here today to lock Ms. Blair out of her house and steal her personal property like she did to my clients. But while we don't believe in eye for eye justice, we also don't believe in saying tough luck or turning a blind eye when someone inflicts serious harms on another's life, like what happened here in this case. The American judicial system believes in accountability and consequences. And in civil disputes, our courts impose accountability and consequences through two primary vehicles: money damages and equitable relief. The equitable relief that we are asking the district court to award in this case is what is necessary to restore Joe O'Donnell and Carla Bowers to the position they would have been if Ms. Blair had not breached the land contract and had not illegally evicted them from the property. Specifically, at the close of our proofs, we will request that the court enter a judgment in favor of Joe O'Donnell and Carla Bowers against counter-defendant Rosemary Blair, ordering that Ms. Blair to perform her obligations under the land contract. Enter an order requiring Rosemary Blair to execute all of the documents and instruments necessary to sell and transfer the real property located at 11247 Lakeshore Drive in Two Rivers, Michigan, in fee simple absolute to Joe O'Donnell and Carla Bowers, free and clear of any liens and encumbrances after the parties close on the sale of the property. And enter award requiring the purchase price remaining under the land contract to be set off by the amount of damages that Joe O'Donnell and Carla Bowers are awarded against Rosemary Blair in the circuit court. So the story of this case is best explained through a timeline, which I have as a demonstrative over to my right. Is it okay, Your Honor, if I step away from the microphone and move towards the demonstrative?
Yes. Go ahead.
Your Honor, the evidence in this case will show, we're starting on the left of the timeline, that in June of 2021, Joe O'Donnell and Rosemary Blair entered into a lease agreement with an option to purchase. That lease agreement was temporary, and it was on a single page piece of paper that Ms. Blair drafted until the parties agreed to a further agreement. On June 11th of 2021, Mr. O'Donnell paid Ms. Blair two payments: a wire of $24,500 and a cash payment of $15,500.
Just a minute. Let's lock it on that for a minute, Laura, on the left lawyer camera channel.
You got it.
All right, go ahead.
My left side's my bad side, so it's okay.
My front side is my bad.
I got a face for radio. So on June 11th, there was the evidence will show that a payment was made between Mr. O'Donnell and Ms. Blair, $24,500 wire, and a cash payment of $15,500, totaling $40,000. At or around that time, Mr. O'Donnell, Ms. Bowers, and their 5 children moved into the house. They made subsequent cash payments after that. July 8th, $9,000 cash. There'll be evidence to that effect.
All right, stop, slow down. All right.
July 6th, a $7,000 cash payment from Mr. O'Donnell to Ms. Blair. There'll be evidence to that effect. July 22nd, a $4,000 cash payment from Mr. O'Donnell to Ms. Blair. July 27th, a $10,000 cash payment from Mr. O'Donnell to Ms. Blair. July 27th, a $500 cash payment from Mr. O'Donnell to Ms. Blair. The evidence will show that all of these payments were made towards the purchase price of the lake house. Now we fast forward until November 15th of 2021. That is when Rosemary Blair, Joe O'Donnell, and Carla Bowers executed the more full and formalized lease with an option to purchase, which is commonly understood as a land contract. November 15th, that date, Ms. Blair received a $600 cash payment, on November 12th, a couple of days before they signed the land contract, she received a $600 cash payment from Mr. O'Donnell, the evidence to that effect. On November 15th, she received a $14,400 cash payment from Mr. O'Donnell. That is the infamous picture over here with the $14,400 of cash payments that Ms. Blair received on November 15th at her house in Crown Point, Indiana, from Joe O'Donnell, and Carla Bowers was present as well. That is the same contract that was signed on the same day that Ms. Blair now claims in this case that she did not have capacity to sign. Ms. Blair, there's no comments from anyone during.
Okay, Counsel,
so
let me do this.
And let me do this. Just a minute. Ms. Blair, I know you got strong feelings about this and you're listening through the headphones, so you can't hear anything, but hold your comments. You can share them with your lawyer, but don't say anything that be picked up.
I'm sorry. I can't hear.
Yes, so, but don't say anything.
I won't say
Okay.
anything.
All right, very
I
good.
apologize, Your Honor. I should have asked the court to instruct and advise the party not to speak during that opening statement. So November 15th of 2021, the date that Ms. Blair claims that she didn't have capacity to sign, but she had capacity to receive $14,400 of cash, count the money, and it's sitting conveniently right on top of that land contract. She said she didn't have capacity to sign. So from January 31st of 2022, the next month, up until August of 2022, everything was fine. Joe and Carla in January of 2022 made a $14,500 cash payment to Ms. Blair. The evidence will reflect that. And now the monthly installment payments were made of $2,000 that the court previously heard testimony about. Under the land contract, they weren't required to make any payments. You'll hear testimony here today that Ms. Blair was strapped for cash, in her own words. So they went above and beyond to try to help Ms. Blair out to make installed payments of $2,000 to be offset.
Starting what month?
Starting on February of 2022 and continuing to June of 2022. So $2,000 in February, $2,000 in March, $2,000 in April, $2,000 in May, and actually $2,500 in June of 2022. Two separate payments. One was $500 cash, one was $2,000 cash. I'm sorry, there was another payment made in July. So from February of 2022 to July of 2022, there was $2,000 cash payments, 1 month, $2,500. Everything changed in August of 2022. This is the time that under the land contract, it reads that Ms. Blair, when she wanted to close or consummate the sale of the transaction, she would give Joe and Carla notice. And then within 90 days of that notice, they would close and pay the remaining balance of the land contract. You'll hear evidence today that Ms. Blair sent a text message to Joe O'Donnell on August 4th of 2022, stating that she wanted to close on the transaction. You also hear evidence that Mr. O'Donnell responded and said, let's move forward with the transaction, and was ready, willing, and able to close within 90 days and was working towards securing financing. This is the point in time when everything went wild. At that point in time, Ms. Blair got seller's remorse. She was confronted with the issue that she was actually going to have to part ways with this property.
I'm going to object, Your Honor. This is speculation and it's not relevant to the amount of damages.
Your Honor, it's a demonstrative, it's opening statement, it's not used for the truth of the matter, it's just.
It's, all right, I'll allow it, but yeah, it isn't. I'll allow it.
So circumstantial evidence between August 4th and what happens on August 12th of 2022. Ms. Blair sends the text on August 4th saying let's close on the sale of the property. She hears back from Mr. O'Donnell. We're moving forward with the sale. She understands that within 90 days, she's going to have to depart with the property. On August 12th, Ms. Blair has her own property condemned. Davies Township comes out. They condemn the property based on what was first a fallen tree in the backyard and what was next some bottle jacks or evidence under the foundation of the house that my client had no idea that were there.
Your Honor, may I have a continuing objection to this form of opening because it's not going to be
Relevant to the amount.
to the amount, and it's also not going to be followed up by evidence. So go ahead.
Some of this I'm aware of because of earlier arguments, and I also handled the condemnation case or the that zoning hearing, not realizing until later that we were dealing with the same thing, and not realizing that there were tenants in the property. But I am aware from evidence that I heard regarding the events of August 12th. I've seen all the photographic evidence, the bottle jacks, the minor damage to the deck. And in fact, so it doesn't go to damages, but it may go to why we are where we are. So I will allow your continuing objection. Thank you.
Thank you, Your Honor. And it is relevant to our claim for specific performance because under the factors under specific performance, we need to, number one, establish that there was a valid contract. Number two, establish that my clients complied with their obligations under the contract. And number three, establish that Ms. Blair breached the contract. So certainly the condemnation, the self-inflicted condemnation of the property and the eventual termination goes to an element of specific performance. So between August 4th, which was the 90-day text for the closing, and August 12th, the evidence will show that Ms. Blair had her property condemned, which is undisputed at this point as the court has handled that condemnation proceeding. And what happens after the property was condemned? My clients were removed from the property. And at that point, Ms. Blair could circumvent the summary proceeding process. She had them out of the property. So after August 12th, what happens? You'll see a letter from an attorney that Ms. Blair hired from the east side of the state of Detroit, Mr. Robert Yonker, that sent them a termination letter saying, relying on the condemnation term of the contract, saying the property has been condemned. And now under the land contract, which Ms. Blair claims that she didn't have capacity to sign, now the land contract is terminated and you must vacate the property. So she had her own property condemned and then she relied on her self-inflicted condemnation to wrongfully terminate the land contracts in September. Then what happens? In October, after she has her own property condemned, Ms. Blair resorts to self-help and changes the locks on her own property in violation of the anti-lockout statute. I understand that that claim has been removed to the circuit court, but again, that goes to the breach of the land contract. She unlawfully removed my clients from the property and then locked them out, which is a breach of the land contract. In November, Mr. Yonker sends another threatening letter to my clients, now claiming that they've abandoned the property, which is curious because they were trying to get back into the property when they were locked out. And also Ms. Blair had filed for recovery of possession. So my clients never abandoned the property, and that's why we're here today, because they want the properties back. And then December of 2022, Ms. Blair files the summary proceeding lawsuit to regain possession of the property that she already wrongfully evicted the clients from. So that's the story. That's the picture of the case. And then now we get into the damages, or excuse me, the testimony about payments that Ms. Blair received from my clients. Your Honor, as a default has been
Go
entered
ahead,
in this.
take the lock off.
As a default has been entered in this matter against Rosemary Blair with respect to all the claims asserted against her in the counterclaim. We're here today under MCR 2.603 to offer proofs with respect to counter plaintiff's claims for specific performance, which is count 2 in the counterclaim, and quiet title, which is count 6 in the counterclaim. Your Honor, as our first witness, we would call Joe O'Donnell.
Mr. O'Donnell, you may have a little trouble getting there, but if you come around the posters and face me, swear or affirm any testimony you are about to give in this matter will be true to the best of your knowledge and belief.
Yes, it is.
Please have a seat. Would you state your name and spell your name for the record?
Joseph O'Donnell, JOSEPHODonnell.
Good morning, Mr. O'Donnell.
Good morning.
Or maybe afternoon, midday. Mr. O'Donnell, what is your current address?
28 North Barton Street in Buffalo, Michigan.
And is that the address where you permanently reside?
Yes,
And do you live in the city or the township of New Buffalo?
I live in the city of New Buffalo.
And how long have you lived in the city of New Buffalo?
6 years.
And how old are you here today?
47.
And what properties do you currently own?
I have, 11247 Lakeshore Drive, 22 North Barton Street, New Buffalo, and 28 North Barton Street, New Buffalo.
Now, 22 North Barton Street and 28 North Barton Street, those are in the city of New Buffalo, correct?
Yes, they are.
Okay. And you mentioned 11247 Lakeshore Drive. Do you own that property, or are you seeking to own that property through the proceedings here today?
I'm seeking to own that property through the proceedings today.
And do you have any children?
Yes.
And how many children do you have?
I have 2 biological. I have 5 children altogether. Charlotte has 3 children.
And what are your children's names? Let's start with your biological children, and then let's go to Miss Bauer's children.
Joey O'Donnell is 12, and then Grant is 5. Those are my biological children. And then Joey Bowers is 12, and McKenna is 11, and Delaney is 10.
And I'll call him Joey B as Joey Bowers.
Joey B is what we call him.
So Joey B, McKenna, and Delaney are Miss Bauer's biological children, correct?
Yes.
And Joey O and Grant are your biological children.
Yes.
I'm sorry, can you just repeat all their ages again, please?
Yeah, it's
Start with Joey O.
Oh, Joey O is 12, Joey B is 13, McKenna is 11, and Delaney is 10. And Grant is 5, sorry.
And where do your children live? That's Joey O and Grant, correct?
Yes, Joey O lives in Ogden Dunes, Indiana with his mom, and Grant lives in LaPorte, Indiana with his mom.
But they still visit you,
Yes,
and
I'm
you
with
have,
them half the time.
okay. And what about Joey B, McKenna, and Delaney? Where do they live?
They live with their mom and me half the week. They're back and forth.
And when you say their mom, who are you referring to?
Carla.
Is that Carla Bowers?
Yes, it is.
And where does Miss Bowers live?
Oh, she lives in New Buffalo, Michigan.
And can you identify Miss Blair or Miss Bowers for the record, please?
Yeah, she's right there.
She wearing a black shirt?
Yes, she is.
Let the record reflect that Mr. O'Donnell has identified Carla Bowers to my right.
No objection, Your Honor. Hey.
Mr. O'Donnell, where were you born?
Chicago, Illinois.
And where did you grow up?
Chicago.
And did you attend high school?
Yes.
What high school did you attend?
I graduated from New Buffalo High School.
New Buffalo High School?
Yes.
Is that in the city of New Buffalo?
Yes.
And what year did you graduate from high school?
94, 95.
And did you attend college?
Yes, I did.
Where did you attend college?
Michigan State University.
Go green. Did you obtain a degree from Michigan State University? What degree did you obtain?
BA in Communications.
Is that a Bachelor of Arts in Communications?
Yes, it is.
And do you recall when you graduated from Michigan State?
Yeah, it was 2000.
And did you obtain any post-baccalaureate education?
Yes.
And what was that education?
I got a law degree.
So you received a Juris Doctor degree?
Yes.
Okay. And where did you attend law school?
Thomas Cooley.
And what campus did you attend Cooley at?
East Lansing.
And what year did you graduate?
2003.
And are you currently employed?
Yes.
Who do you work for?
Myself.
You're self-employed?
Yes.
What type of work do you do?
Pretty much everything real estate. I do construction, I do buying and selling and renting and manage properties. I do pretty much everything real estate.
So do you buy and sell real estate?
Yes.
And do you own a construction company?
Yes.
And do you do residential construction?
Yes.
Do you do any commercial?
Not necessarily, no.
Were you a realtor in the past?
Yes,
How long were you a realtor for?
about 18 years.
Okay. And you mentioned managing rental properties. Do you own and manage various short-term rental properties?
Yes, I have 3 Airbnbs I own and manage myself, and then I have a couple properties I manage for other people.
And the properties that you own and manage yourself, where are those located?
New Buffalo, Michigan.
Is that the city of New Buffalo?
Yes, it is.
Mr. O'Donnell, in your own words, can you please tell the court why we're here today?
Because we were thrown out of our house in August of last year, and we're trying to get back into our house. And I guess we're just trying to get back into our house, and it's the lawsuit we're trying to get back into.
And are you familiar with the property located at 11247 Lakeshore Drive in Three Rivers?
Yes, I am.
And can you describe that property for me?
Yes, it's a beautiful 5-bedroom, 3-bathroom, 3,700 square foot house. It's on the lakefront. It's got a semi-attached garage. And it's beautiful.
How many stories is the house?
3.
Okay. And can you just speak up a little bit?
Oh,
It's kinda
3. Sorry.
hard. And paint a picture for me of the house. Start at the front door and then go to the back.
Okay, you walk in and you pull up. It's beautiful. It's at the end of a private road, and there's kind of like a dead end. It's not a cul-de-sac. And then you walk in and the garage is to your right, and you come in and there's a great room. It's 3 stories up, all glass. It comes down, and then behind that there's a primary in the first floor, which is really nice. And then it's got 4 bedrooms, or it's got 4 bedrooms upstairs, and it's got the beach is incredible. The front yard, it's got a deck dock that go out. It's just incredible. You look out the front windows, it's just a lake, beach, yard, beach, lake.
So let's go to the back of the house. You mentioned that there was a deck, correct?
Yes.
Does that deck look out on a lake?
Yes, it does.
What lake is that?
It's Corey Lake.
Okay, and then take me from, I'm assuming the backyard then connects to the lake. So take me to the backyard to the front of the lake. What does that look like?
You walk out of the house, and then from the glass windows, there's big sliding doors that open all the way up across, and they walk out on the deck, and then you got a nice yard there, and then there's like a little rock wall, and there's a beach, and then the dock's not in now, but the dock goes out, and there's a dock deck that goes way out in front of the house. You just can see it right out front.
And how many feet of lake foot frontage, if you're aware, is on the
50.
house? And describe to me the beach. Is it one of those nasty rocky beaches, or is it?
No,
sandy?
this is actually a special property, because on Corey Lake, some sides you get like a lot of like seaweed and lily pads and stuff like that. And then this is actually like a sand side where it's really nice and smooth, and the bottom's really nice. Kids love it. It's shallow.
Would you say that it's a great family house?
Oh, it's amazing.
And are you familiar with Rosemary Blair?
Yes, I am.
Is Miss Blair in the courtroom today?
Yes, she is.
Can you identify Miss Blair for me and by what she's wearing and where she's?
Yeah,
sitting?
she's over there in the black with the earphones on.
We'll stipulate that he pointed to Miss Blair.
May.
And when did you first become acquainted with Miss Blair?
October of 2020.
And how did you become acquainted with Miss Blair?
Her property was on the internet on the Facebook page for Love Corey Lake.
Now, let me just stop you right there. When you say her property, what property are you referring to?
11247 Lakeshore Drive.
Okay. And sorry, I didn't mean to interrupt you. Keep going. You said it was on the internet.
It was on a Facebook page that was for the Love of Corey Lake, which people post stuff around the lake and everything. And it was a listing for the house for sale by owner.
So the house at 11247 was listed on for sale for the Love of Corey Lake, correct?
Yeah, Facebook page, yes.
Okay. And is that how you became aware that the property at 11247 Lakeshore Drive was for sale?
Yes.
Okay. And again, approximately when did you become aware that the property was for sale?
October of 2020.
Okay. And who was selling the property?
Rosemary Blair.
And was it a for sale by owner?
Yes.
Was anyone living in the property when it was listed for sale?
No.
At a certain point, did you approach Ms. Blair about purchasing the property?
Yes.
When was that?
October 2020.
And what did you and Ms. Blair discuss at that time?
Just the terms of, how much we pay and when we could close and this and that.
And did you offer to purchase the property from Ms. Blair?
Yes.
Okay. And when was that?
October 2020.
I'm sorry, I couldn't hear the witness. Could you speak up, sir?
October 2020.
Loud and proud. I know it's not like normal conversation, but you can speak up a little bit. And did Ms. Blair agree to sell you the property?
Yes, she did.
And when was that?
That was in October of 2020.
And was that a verbal agreement or a written agreement?
That was verbal.
And at the time you offered to purchase the property, did you know Carla Bowers?
Yes, I did.
At that time, were you in a relationship with Ms. Bowers?
Yes, we've been living together for about 3 years.
And Ms. Bowers is in the courtroom today, correct?
Yes, she is.
And you've identified her to my
Yes.
right, correct? And did you plan on moving into the property at 11247 Lakeshore Drive with Ms. Bowers?
Yes, I did.
And did you plan on using the property as your primary residence or your secondary residence?
Primary residence.
And why did you want to use it as your primary residence?
Because it has 5 bedrooms and we had 5 kids and it just fit our whole family. It was the first place that we had a chance to get our whole family together and have space.
Was there any financial benefits of having it as your primary residence as opposed to your secondary?
Yes, the taxes would be cheaper as well.
So with
The
that
tax, you get a
homestead, not homestead?
Yeah, deduction for your primary residence, which would reduce the I think by 40% or something like that.
And did you plan on having your biological children live with you at the property?
Yes.
And did you plan on having Ms. Bowers' biological children live with you at the property?
Yes.
Okay. So is it fair to say that you and Ms. Bowers and your children and her children would live at the property as a nuclear family?
Yes.
And why was that important to you?
Because we're in love and, we both, have our kids. And after the pandemic, we were stuck in a little place and we were really looking forward to having the whole family together and just being together and having a big house that's growing and just have a forever house.
And what are some of the things that most attracted you to the property?
Well, it's really unique. You're never going to find anything like this. It's like, it's all glass in the front. So you get all sunlight. It's almost like being in a fishbowl at times. It was Amish built, so it's all cedar. It's just incredible. The outside and the inside, everything is cedar. The doors are even custom made on the interior of cedar. And it's just a really special house. Everything about it. The land that it's set on, it's really close to the lake. It's closer to the lake than any other houses on the thing. And it's beautiful.
What about the location? Was it,
you can't get another location like that because the beach, there's no beaches like that on Corey Lake. There's only a couple spots in that lake that have that kind of thing. So you can't get anything like that.
Would you say it's secluded?
Yes.
Okay. Would you say it's peaceful?
Yes.
Were those aspects important to you about why you decided to purchase the property?
Yes.
What about the makeup of the house as far as rooms and bathrooms? Was that important to you about living there with your children and Ms. Bowers' children?
Yes, it was.
Okay. And explain that to me.
Well, when there's 7 of us total, and we're all together, so that's a lot of people. And, there's the girls are kind of really close in age. So for them, they don't mind sharing rooms, but we figured that for all of the ages, they kind of need their own room and their own space. And, we all kind of need our own space, so to space us out a little bit and everything else. It was just set up perfect. The rooms, there's like a level for the girls, the boys. There's bathrooms on different levels. It's just perfect.
Yeah. And how many bedrooms were in the house?
5.
Okay. So that would accommodate
everybody.
The children. Okay. Would you call the property one of a kind?
Yes.
And would you say that the property is uniquely situated to meet your needs and tastes in a home?
Oh, yes. With the garage, with the bathrooms, with the lake, everything.
Okay. And I don't mean to be repetitive, but just so the record's clear, can you just specify what those unique needs and tastes are in this home that attracted you to it?
I think we got enough of that.
Okay. And have you encountered any other properties that are similar to 11247 Lakeshore Drive?
No, I don't think you can come by. It's a pretty unique property. It's one of a kind. You're not going to see anything like that on the lake.
Have you encountered any other properties with similar features of 11247 Lakeshore Drive?
No.
And you're a realtor, correct?
Yeah.
So you look at a lot of listings. Yeah. Have you encountered any other similar properties with a comparable sales price to that of 11247 Lakeshore Drive?
No.
Your Honor, I have binders for you and also the court reporter and opposing counsel as well
That's good.
for our exhibits. Can I approach on?
Yes.
There's a judge's copy. The tab with the numbers on the bottom. And also, there's a mirror copy.
Mr. Donald, you have a copy of the exhibits in front of you, correct?
Yes.
Okay. All right, I want to direct your attention to what is marked for purpose identification as Exhibit 1. Can you flip to that for me, please? Have you seen this document before?
Yes, I have.
Can you describe what this document is in your own words?
Yeah, it's a lease agreement to the 11247 Lakeshore Drive.
Your Honor, I'm going to object to this document. The counter complaint speaks of the lease option to purchase, not this document. There's never been anything pled about this document. So it's irrelevant.
All right, I'll note the objection. I'll allow it to come in. Maybe it will help us understand this whole transaction. This is not a lease option to purchase. Well, it is. Anyway, I note your objection. And in defense of you, you just got in the case like 3 days ago. But this is admitted.
Mr. O'Donnell, is this a true and accurate copy of the original?
Yes, it is.
Okay. And you're familiar with Ms. Blair's handwriting, correct?
Yes, I am.
Okay. Whose handwriting is in Exhibit 1?
Rosemary Blair's.
And Your Honor, I think it's been admitted already, but we offer to admit Exhibit 1.
It is admitted over objection.
Thank you, Your Honor.
Mr. O'Donnell, what's the date at the top of this document?
June of 2021.
All right, I want to direct you to the bottom of the document. Who signed this document?
Rosemary Blair and myself.
And what is the date next to your signature?
July 2nd of 21. Or July, sorry.
Would that be July 2nd?
July 2nd, yes.
And did you discuss this document with Ms. Blair before you signed it?
Yes, I did.
Okay. What did you discuss?
Just that we needed something to show that we had a lease on the property and that we had everything.
And whose idea was it to draft this document?
Rosemary's.
And what led you to ultimately sign this document?
Just to take possession of the house. Have proof that I own the house, or was renting it or leasing it.
And the document mentions that it's a lease and you have the option to purchase the property at 11247 Lakeshore Drive, correct?
Yes.
Okay. What was your understanding of the option to purchase in this agreement?
That we paid her the money, and then once she expressed her terms, and we make our balloon payment at the end and take possession of the house.
Objection. This is contrary to the document, Your Honor.
Well, the document speaks for itself.
Right.
We still haven't got a purchase amount yet, but so had you moved into the house in June or July of 21?
Yes.
When did you move in?
June.
You took away my next question, Your Honor.
Okay.
And why was, well, let me go back, strike that. Did you discuss the concept of a land contract with Ms. Blair at the time you executed this document?
Yes.
Okay. And what did you discuss?
We just discussed different ways to purchase the property and how we were going to get it to her. And she told us she needed money like right away. So we discussed a way of giving her money right away and then give us a little time to close the deal. And then she needed time as well. So.
And what's your understanding of what a land contract is?
We give her a large amount off the beginning of the payment to hold the house. And then during that time, then when you make a balloon payment at the end, you don't make rent payments in between. You just make a big payment, hold the property, and make a payment at the end.
And is your understanding?
Excuse me, counsel, just if I may. Counsel keeps referring to this as a land contract.
Yeah, I've been struggling with that throughout the case. Sometimes it's on its face, it says a lease option to purchase, which is not identical to a land contract.
So I'd ask that the counsel be asked to refer to it as a lease option.
Thank you.
Your Honor, we're just establishing the basis as far as the understanding of the parties about lease option to purchase could be an ambiguous term. So it goes to the extrinsic evidence of the
Well, but we're calling it something that it isn't. So let's refer it as the lease with his option to purchase.
Okay. How about just Exhibit 1?
All right, that's fine.
Exhibit 1, why was the idea of a land contract appealing to you?
Because it gave us time to secure financing.
At the time you executed this document, had you given Ms. Blair any money towards the purchase of the home?
Yes.
How much money did you pay her?
I believe it was 24,500.
Objection, Your Honor. I think the counsel, that Mr. O'Donnell is referring to the demonstrative evidence in order to inform his testimony. I think he should.
Well, first of all, he said, I believe, but, all right. Let's back up. So at some point you gave Miss Bowers 24,000, excuse me, Miss Blair, $24,500.
Yes.
And when was that?
That was a wire transfer. What was the date on there? It was, sorry.
And I'm going to get to that.
June 11th.
You know,
June 11th of 2021.
and we'll get to that eventually.
All
right.
So, yeah.
Okay.
So from your memory, did you pay Miss Blair $24,500 on June 11th by wire?
Yes, I did.
And what did that payment relate to?
The purchase of 11247 Lakeshore Drive.
And when did you move into the property?
June of 2021.
And was that after you executed this?
Yes.
Exhibit 1, I'll call it. And who else moved into the property with you in June of 2021?
Carla Bowers and the kids.
And which are those all 5 kids?
Yes.
And did you move your personal belongings in the property with you at that time?
Yes, we did.
What did you move in?
Well, we moved in tons of stuff. We moved actually all of our stuff from our houses down here, the stuff you keep. I brought my safe stuff there. I brought my, all your valuable stuff, the stuff that you're gonna keep for our storage boxes, that all our kids' stuff in there, and the blanket, all that kind of stuff. We brought up beds. We brought up dishes.
Not to interrupt you, but was the house partially furnished when you moved in?
Yes, it was. It was when I first saw it, yes.
Okay. And was that partially furnished by Ms. Blair?
Yes, it was furnishings there that we purchased before the.
Okay. And was the fact that the property was purchased something that attracted you to the property?
Oh, yeah, because it made it made it a lot easier for us to move in. Furnishing a 5-bedroom, 3-story house is pretty hard.
And did you live in the property full-time after June of 2021?
Yes.
Mr. O'Donnell, you've reviewed all the pleadings and documents in this case, correct?
Yes.
And have you watched other court proceedings in this case on YouTube?
Yes.
Do you recall from reviewing that information how much Ms. Blair claims that you have paid her with respect to 11247 Lakeshore Drive?
Yes, $30,000.
That's $30,000?
Yes.
Do you agree with that statement?
Not at all.
So if someone were to suggest in this courtroom that you only paid Ms. Blair $30,000 towards the purchase of 11247 Lakeshore Drive, that would be a lie, correct?
Yes, correct.
I want to direct you to what's marked as Exhibit 2. Take a moment to review the document. Let me know when you're finished. Have you seen this document before?
Yes.
Did you help create this document?
Yes, I did.
In your own words, what is this document?
It's a summary of all the payments I made to Rosemary Blair for the purchase of 11247 Lakeshore Drive.
And have you gone through all the documents that support this payment summary and verify that those amounts are accurately reflected in the summary?
Yes, I have.
And do you believe that Exhibit 2 fairly and accurately summarizes the payments that you made to Rosemary Blair with respect to 11247 Lakeshore Drive?
Yes.
Your Honor, we would offer Exhibit 2 into evidence as a summary under MRE 1006.
Well, the exhibit summary is ostensibly going to be supported by the exhibits to follow, which are not yet in evidence, but assuming they will connect it, I'll allow it under that basis. Mr. Soltis?
Yes, you made the point, Your Honor, as long as it's supported by the actual documents themselves, not just the summary.
All right, so tentatively, certainly for purposes of testimony, it's admitted.
And Mr. O'Donnell, Exhibit 2, is that on a demonstrative board right next to you? Is that the same document?
Yes, it is.
Okay. All right, I want to direct you to what's marked as, for purpose of identification, as Exhibit 3. Have you seen this document before?
Yes, I have.
Okay. And are you familiar with this document?
Yes, I am.
What is this document in your own words?
It's a copy of the wire transfer I sent to Rosemary Blair.
And is this document a true and accurate copy of the original?
Yes, it is.
And did you fill out the information that's included in Exhibit 3?
Yes.
Your Honor, we ask that Exhibit 3 be admitted to evidence.
Objection.
No objection, Your
That's
Honor.
admitted.
Mr. O'Donnell, at the top of Exhibit 3, it has a box titled Wire Transfer Sender Information. Do you see that?
Yes, I do.
And who does that section identify as the sender?
Me, Joseph O'Donnell.
And the box next down is titled Wire Transfer Information. Do you see that?
Yes.
What is the date identified in that section?
June 11th of 2021.
And that section also identifies the wire amount, correct?
Yes.
And what is that wire amount?
$24,500.
And the next box down is titled Recipient Account Information. Do you see that?
Yes.
And who does that section identify as the recipient?
Rosemary Blair.
And that section also contains a box that says text to recipient, correct?
Yes.
And what is included in that box?
It's that's just this thing that says purchased for 11247 Lakeshore Drive and Three Rivers, Michigan 49093.
And did you input that text into that wire information?
Yes, I put it so they know what that wire was for.
Took my next question. So why did you insert that information?
Just so it would be known what this payment was for.
And was that money actually taken out of your bank account?
Yes, it was.
Green light. Can you do me a favor and put a green sticker next to the demonstrative? Mr. O'Donnell, I want to direct you what's marked for purposes of identification as Exhibit 4. Have you seen this document before?
Yes, I have.
And are you familiar with this document?
Yes, I am.
In your own words, can you describe what this document is?
It's a receipt from money that we paid Rosemary Blair.
And did you take this picture?
Yes, I did.
When did you take this picture?
On June 11th of 2021.
And what device did you take this picture with?
My iPhone.
Is that your personal cell phone?
Yes.
And why did you take this picture?
It's proof of the receipt of payment.
And is this document a true and accurate copy of the original?
Yes, it is.
Your Honor, we would ask that Exhibit 4 be admitted to evidence.
And where did you take this picture? In the house there at 11247 Lakeshore Drive?
This was in, I believe this was in Crown Point.
Okay, so this is Crown Point. Whose handwriting is that?
That's Rosemary Blair's.
Yeah.
All right, maybe admit it.
Your Honor, I don't see it on the,
It's, the exhibit is in the book. He's not referring to the summary at this point.
okay.
I'm not sure what it is we're gonna be talking about, because there's 15,000 June 11th. This is dated June 11th. It says $40,000 toward addendum of $100,000. We're gonna learn more about what that means, but right now Exhibit 4 is admitted.
Thank you.
Mr. O'Donnell, did you watch Ms. Blair write this document?
Yes, I did.
And what is the date at the top right-hand corner of this document?
June 11th of 2021.
And is that the date you remember seeing Ms. Blair write this document?
Yes.
And Exhibit 3 states, received $40,000 from Carla Bowers and Joe O'Donnell towards the addendum of $100,000. Balance of $60,000 to be paid later. What is your understanding of what that means?
That we'd already paid Rosemary 40,000 of the 100,000 that we agreed that we'd pay, and then after we paid the 100,000, then that would be it until we paid the final lump sum. And that this is just a receipt she wrote out after getting the payments for us, just writing it down so we could figure out we were at 40 out of 100.
Okay, let me refresh your memory. Do you remember testifying about a wire transfer of $24,500?
Yes.
Okay. Now, and that was made on June 11th?
Yes.
Okay. Did you make an additional payment to Ms. Blair on June 11th?
Yes.
Okay. What was that payment amount?
That was for $14,500.
That'd be 14,500 or
15,500. 15,500. I'm sorry.
Objection, Your Honor, reading suggested. There's no document to support that either.
But there's
Unless I
Hold
haven't.
hold on, Joe.
All right. It was leading, but I'll allow the answer.
it was 15,500.
Okay, so let's look at the $40,000 referenced in that document. You see that?
Yes.
Okay. So you paid Miss Blair 24,500 on June 11th, correct?
Yes.
Okay. Now, is there some type of a math that would take to get to $40,000?
Yeah, the 15,500 plus that amount came out to the 40. And that's why she wrote this, was to put the, show us that that's what it was, the 40, made the total 40 on that day, because she got separate payments.
Okay.
All right, how was the 15,500 paid?
Cash.
Now, this is a question I've been dying to answer since I've seen these pictures of bundles of $100 bills. Why did you do these transactions in cash?
It was at Rosemary's direction. She said that her kids were trying to, had access to her bank account, that they were trying to take her money. And she said that she only needed cash. That's the only thing that she could work with. I think I have that on a text somewhere. 'Cause I mean, after the wire, she said she couldn't do it. It took like 4 days for the wire to go.
So you had to go to your bank and get large amounts of cash
Yeah, I certainly did.
in $100 bills
Yes, I did.
because that's the way she wanted it?
Yep, that's the only way we could do it.
Did you pay Miss Blair $15,500 on June 11th of 2021 in addition to the wire we went over?
Yes, I did.
And how did you pay that?
Cash.
And what was that payment related to?
The purchase of 11247 Lakeshore Drive.
And Exhibit 4 actually references the house at 11247 Lakeshore Drive, Three Rivers, Michigan, correct?
Yes.
Okay. So as of June 11th of 2021, how much money had you paid Miss Blair relating to the property?
$40,000.
And is that consistent with what Exhibit 4 states?
Yes.
Green light. Can you put a green sticker next to Exhibit 4? All right, Mr. Vaughn, I want to direct you to what is marked for purpose identification as Exhibit 5. Have you seen this document before?
Yes, I have.
And are you familiar with this document?
Yes.
In your own words, what is this document?
It's a receipt for money that we paid Rosemary.
And did you take this picture?
Yes, I did.
When did you take this picture?
On the July 8th, 21.
And what device did you take this picture with?
My iPhone.
And is this document true an accurate copy of the original?
Yes.
And do you recognize the handwriting in Exhibit 5?
Yes.
Whose handwriting is that?
Rosemary Blair's.
And did you watch Ms. Blair draft this document?
Yes, I did.
Your Honor, we would ask that Exhibit 5 be admitted into evidence.
Your Honor, I don't think any foundation has been laid as to what this for. I mean, if the council could do that, I'd appreciate it.
Say that again.
There's no foundation as to what these figures represent.
Well, I guess we're gonna learn. He testified that this is a receipt that Miss Blair made out in his presence and he photographed it. And so for that, it's admitted. As to what it means, I guess let's hear a testimony now.
Yeah, I was just going through the authentication phase, Your Honor, and then obviously now we'll go into the testimony about the understanding of this, but I think we've laid a proper foundation for the authentication. Where were you and Ms. Blair located when this document was drafted, Mr. O'Donnell?
We were located in at Rosemary's house.
And is that in Crown Point, Indiana?
Yes.
All right, I want to direct you to the date that is written down as July 6th of 2021. What is written next to that date?
7,000.
And what was your understanding of what that means?
I paid her $7,000 cash that day.
And did you actually indeed pay Ms. Blair $7,000 on July 6th of 2021?
Yes, I did.
And what form was that payment in?
Cash.
And how did you deliver that money to Ms. Blair?
And
what was that payment related to?
the purchase of 11247 Lakeshore Drive.
Can you put a green sticker next to Exhibit 5, please? Green light. No, it's just the 6, please. All right, I want to direct you to the date that is written down as July 8th of 2021. Do you see that?
Yes, I do.
What's written next to that date?
9,000.
And what's your understanding of what that means?
We paid her $9,000 in that day.
And did you indeed pay Ms. Blair $9,000 on July 8th of 2021?
Yes, we did.
And what form was that payment in?
Cash.
And how did you deliver that money to Ms. Blair?
Hand.
And what was that payment related to?
The purchase of 11247 Lakeshore Drive.
And where were you actually located when you gave that payment to Ms. Blair?
At Rosemary's house.
Is that Crown Point, Indiana?
Yes.
Green light. Can you put a sticker next to that exhibit, please? All right, a little math equation. As of July 8th of 2021, how much money had you paid Ms. Blair?
We had paid Miss Blair $56,000.
So that amount already exceeds the $30,000 that Ms. Blair claims that she was owed in this case, correct?
Yes. I mean, she writes it down right there, from the 100,000. She has to write down.
And was all that money related to the purchase of 11247 Lakeshore Drive?
Yes, it was.
All right, I want to direct you to the bottom of Exhibit 4. Do you see where there's a reference to 56?
Yes.
And does that number align
This
with?
is exhibit 5.
Excuse me, Exhibit 5. Does the reference to 56 align with the 56,000 of cash that you paid Ms. Blair as of July 8th of 2021?
Yes, it does.
All right, I want to direct you to what's marked as Exhibit 6. Have you seen this document before?
Yes, I have.
And are you familiar with this document?
Yes.
And what is this document?
It's a receipt for money we'd given Rosemary Blair.
And did you take this picture?
Yes, I did.
When did you take this picture?
July 22nd of 2021.
What device did you take this picture with?
My iPhone.
And are you familiar with Ms. Blair's handwriting?
Yes, I am.
Whose handwriting is that in Exhibit 6?
It's Rosemary Blair's.
Did you watch Ms. Blair draft this document?
Yes, I did.
And where were you located when Ms. Blair drafted this document?
Her house.
Would that be in Crown Point, Indiana?
Yes.
And does this document appear to be a true and accurate copy of the original?
Yes.
Your Honor, we would move for the omission of Exhibit 6.
Under the same concerns from Mr. Soltis, exhibit 6 is admitted.
And what is the date at the top of Exhibit 6?
July 22nd of 2021.
And is that the same date that you recall seeing Ms. Blair draft this document?
Yes.
And Exhibit states received from Carla Bowers and Joe O'Donnell $4,000. Correct?
Yes.
Did you pay Ms. Blair $4,000 on July 22nd of 2021?
Yes, I did.
What form was that payment in?
Cash.
And how did you deliver that payment to Ms. Blair?
Hand.
And what did that payment relate to?
The purchase of 11247 Lakeshore Drive.
And whose signature is at the bottom of this document?
Rosemary Blair's.
Now, during the time of all these payments, is there any other reason that you would have been paying money to Ms. Blair other than the purchase of the property?
No.
You didn't have any other business transactions or dealing with Ms. Blair? Green light, can you put a green sticker next to Exhibit 6, please? I want to direct you to Exhibit 7, please. And Exhibit 7 consists of 2 pages, correct?
Yes.
And are you familiar with both of those documents in Exhibit 7?
Yes.
All right. What is the first document in Exhibit 7? Explain to me what that is in your own words.
This is a picture that I took of, I made payment to Rosemary in her car, and she was drawing up the receipts. So I took pictures. I took pictures of all these.
When did you take this picture?
On July 27th of 2021.
And where did you take this picture?
We met at a gas station between our houses somewhere, and it was in Rosemary's car, but we met halfway between our houses. I just paid her on the gas station side of the road.
And again, why did you take this picture?
Just as proof that I made the payment.
And what device did you take this picture with?
My iPhone.
And if you flip over to the second page of Exhibit 7, can you describe what that document is?
Yeah, it's a receipt from the payment.
And whose handwriting is the second document, Exhibit 7, made up of?
Rosemary Blair's handwriting.
And did you watch Ms. Blair draft this document?
Yes, I did.
And is the second page of Exhibit 7 the same document that Ms. Blair is drafting on the first page of Exhibit 7?
Yes, it is.
And are the documents in Exhibit 7 true and accurate copies of the originals?
Yes, they are.
Your Honor, we would ask that Exhibit 7 be admitted to evidence.
On both pages, same issue, same concern is admitted.
All right, if you turn back to the first page of Exhibit 7, which is the picture of Ms. Blair. Are you there?
Yes.
Whose car is that picture taken in?
That's Miss Blair's car. That's Blair's car.
And what's Ms. Blair doing in that picture?
She's writing the receipt for the money paid.
All right. And what's located next to the armrest in that picture?
Pile of cash.
And do you recall how much cash that was in that picture?
Yeah, it was $10,000.
And did you give all of that cash to Ms. Blair?
Yes, I did.
And what did that payment relate to?
The purchase of 11247 Lakeshore Drive.
And if you turn to the second page of Exhibit 7, what is the date at the top of that document?
July 27th of 2021.
And is that the date when you remember seeing Ms. Blair draft this document?
Yes, it was.
And Exhibit 7 states Joe O'Donnell and Carla Bowers, $10,000, correct?
Yes.
What's your understanding of what that means?
It was meant that we paid her $10,000 towards that 100,000 we were talking about, and we had a balance left of $30,000.
And did you actually pay Ms. Blair $10,000 on July 27th of 2021?
Yes, I did.
And what form was that payment in?
It was in cash.
And again, how did you deliver that payment to Ms. Blair?
I hand delivered it.
Okay. And again, what was that payment related to?
Just the purchase of 11247 Lakeshore Drive.
Whose signature is on the bottom of Exhibit 7?
Rosemary Blair's.
Green light, can you put a sticker next to Exhibit 7, please?
Sure can.
All right, I want to direct you what's marked for purpose identification as Exhibit 8. Have you seen this document before?
Yes, I have.
Okay. And are you familiar with this document?
Yes, I am.
Did you take this picture?
I certainly did.
When did you take this picture?
On July 27th of 2021.
What device did you take this picture with?
My iPhone.
And are you familiar with the handwriting Exhibit 8?
Yes, I am.
And are you familiar with Ms. Blair's handwriting?
Yes, I am.
Whose handwriting is in Exhibit 8?
Miss Blair's, Rosemary's.
And did you watch Ms. Blair draft this document?
Yes, I did.
Your Honor, we'd ask that Exhibit 8 be admitted into evidence.
Yes, it may. Your Honor, if I may, voir dire.
Yes.
Okay, thank you. Exhibit 7, and it's 2 pages, is dated July 27, 21, and that's 10,000. And then we have another payment of 500 on July 27, 2021. Why wasn't?
Because she wanted more money from me. I paid her 10,000 and she was.
Well, if I could, Your Honor, these are literally my next questions of direct examination. So, opposing counsel can hold this.
Well, I had the same question, so we're all on the same page.
It's simple. We were in the car. The 10,000. I had more money. She said, "How much money do you have on you?" And I go, "If you write me up another thing, I can give you another 500." She was desperate. I mean, she wanted more money.
So there's a kind of a meticulous way to go about this, but I promise you I'll address that in my next questions.
All right, go ahead.
And what is the date at the top of Exhibit 8?
July 27th, 2021.
Okay. Exhibit 8 states 500 towards purchase of 11247 Lakeshore Drive, correct?
Yes.
What is your understanding of what that means?
It's a receipt. I gave Rosemary another $500 towards the purchase price.
And did you pay Ms. Blair $500 on July 27th of 2021?
Yes, I did.
Okay. How did you make that payment?
Cash.
Okay. And the ultimate question, why did you make 2 separate payments to Ms. Blair on July 27th of 2021?
Because originally I thought I was just making the 10,000 payment, and then she asked me for more money, and I told her that she'd have to draft another thing if we needed more money, and then she took more money. She always wanted more money.
So in addition to the $10,000 payments, did Ms. Blair ask you for more money on July 27th? And you gave her more money?
Yes, I did.
Why'd you give her more money?
Because it just went towards the purchase price. That's what I figured. It didn't matter.
Did she seem desperate for money at that point?
Yes.
Objection, speculative.
Yes, she seemed very desperate.
Well, why did she appear to be desperate?
She told me she was desperate.
All right. No speculation. Did she say why she needed all this cash money?
She had so much going on. She always said she had stuff going on. And she's like, I got this and I got bills and I'm not getting enough money for my oil. And I'm not, she has oil money and she's got all the stuff that she wasn't getting the right checks. So she said she needed money to help her get by.
And whose signature is on the bottom of Exhibit 8?
Rosemary Blair's.
Okay. Green light, can you put in a sticker next to Exhibit 8, please? Rodano, did it seem odd to you that Ms. Blair was requesting all cash payments?
I mean, yeah, but not really. I mean, she kind of explained it to us. I mean, she told us about her situation with her kids and that she didn't trust that they were going to go into her bank account and this and that she seemed like she was, afraid to, she said her kids had access to her email. She said that, she was it was weird that we did everything on the phone and it was kind of just off, but it kind of made sense because she told me that, she didn't have a relationship with any of her children and they kind of like, they had a falling out or whatever. And
so is the fact that you're making large cash payments, did that go in your decision to meticulously document, take pictures of all this?
Oh, yes. And Rosemary knew that too. I told her that I had to take these pictures in case anything happened to either of us. We had to have proof that this was going on and that we didn't have this during the pandemic. We didn't have the option to have it all in writing the right way, I guess.
All right, I want to direct you to what's marked for purpose identification, Exhibit 9. Have you seen this document before?
Yes.
Are you familiar with this document?
Yes.
What is this document?
It's a receipt from money I paid.
Who did you pay the money to?
Rosemary Blair.
Okay. Did you take this picture?
Yes, I did.
When did you take this picture?
On the November 12th of 21.
And where did you take this picture?
At Rosemary's house.
Okay. And why did you take this picture?
As proof of the payment.
Okay. And do you recognize the handwriting in Exhibit 9?
Yes, I do.
Whose handwriting is that?
That's Rosemary Blair's.
And do you recognize the hands in Exhibit 9?
Yeah, that's Rosemary Blair holding it.
Okay. Is this document true and accurate copy of the original?
Yes, it is.
Your Honor, we would ask Exhibit 9 to be admitted into evidence.
What does it tell us?
That I paid 600. She wrote down.
Yeah, that's I'm just authenticating, so we're going to get that here in a second.
Okay, so it says 500 or 5,000 or 15,000, I guess it says.
That's all that we had left. The 14,400 was the balance of the 100,000 we had to pay. Then we hit the 100,000. So that brought the 15,000 was our balance, brought down to 14,400 at that point, I think.
All right, Exhibit 9 is admitted.
And can you again just describe to me your understanding of what this document means?
Yeah, it's just a receipt for the payment of $600.
So did Rosemary want an additional $15,000?
Yes.
And how much money did you pay her on that date?
600.
And if you minus 600 from 15, what do you get?
14,400.
And is that amount reflected in this document?
Yes.
Did you pay Ms. Blair $600 on November 12th of 2021?
Yes, I did.
What was that payment?
Cash.
And how did you deliver that payment to Ms. Blair?
Hand delivered.
What was that payment related to?
The purchase of 11247 Lakeshore Drive.
Green light, can you put a sticker up next to Exhibit 9 for me? All right, I want to direct you what's marked for purpose identification as Exhibit 10. If you take your time, and there's a couple pages here, so look at the document.
Oh, yes.
Have you seen these documents
Let me
before?
look at the other page real quick.
Have you seen these documents before?
Yes, I have.
Are you familiar with these documents?
Yes, I am.
And in your own words, what are these documents?
These are pictures of the contracts and the money I paid Rosemary Blair on the on that day at her house.
Okay. And did you take these pictures?
Yes.
And where did you take these pictures?
At Rosemary's house.
And was anybody else present with you when you took these pictures?
Yes. Carla Bowers was there.
And why did you take these pictures?
As evidence that we made the payments.
And what device did you take these pictures with?
My iPhone.
Okay. These pictures appear to be true and accurate copies of the original.
Yes.
Your Honor, we ask Exhibit 10 to be admitted into evidence.
What date is this?
It's the 14th of November, I believe.
We'll get into that's
All right.
some of the next questions. All right, I want to direct you to the first picture
Anyway, it's admitted.
in Exhibit 10. A pretty large stack of $100 bills in that picture, correct?
Yes.
Now, is Exhibit 10 all
3 pages.
3 photos? All right.
All right, in the first picture, in Exhibit 10, there's a very large stack of $100 bills, correct?
Yes.
And Ms. Blair appears to have a smile on her face in that picture, correct?
Yeah, she was happy.
Yeah, now, can you describe to me how Ms. Blair was acting on that date?
She was in a great mood that day. She had out snacks for us. She was very inviting when we came over, and she was in a good mood.
Okay. And do you recall the date that you were at Ms. Blair's house?
Yeah, it was the 15th of November of 2021.
And is that the same date that you signed the lease with option to purchase as a separate contract?
Yes.
And is that document reflected in those pictures?
Yes, it's underneath the pile of cash.
Was Ms. Blair able to effectively communicate with you on November 15th of 2021?
Yes, she was.
Did Ms. Blair appear to understand what you were discussing with her on November 15th of 2021?
Yes.
Did Ms. Blair appear to be suffering from any type of medical condition on November 15th of 2021?
No.
Did Ms. Blair tell you that she was suffering from lymphedema on November 15th of 2021?
No.
Did Ms. Blair appear to be confused on November 15th of 2021?
Not at all.
And did Ms. Blair tell you that she was being treated for any medical conditions on November 15th of 2021? Was she coughing? Was she hacking? Did she seem sick?
No, she's in a good mood.
Did Ms. Blair show any type of cognitive impairments on November 15th of 2021?
No, she was really sharp. I mean, she set up the appointment to go get this stuff notarized and everything.
All right, now either before or after November 15th of 2021, did Ms. Blair ever tell you that she had designated somebody to make decisions on her behalf?
No.
Did Ms. Blair ever tell you that she executed a power of attorney?
No.
So just describe to me overall how Ms. Blair's mental and emotional state was on November 15th of 2021.
I mean, she seemed very sharp. I mean, she was talking with us. I mean, we were at her house for a couple hours that day, easy, talking and laughing. And I mean, we went over everything. We went over all of her affairs about the house, and she turned over all the paperwork and just everything. We were there for hours and hours going over all this stuff before we went to the notary.
Okay, now compared to the other times you interacted with Ms. Blair, did anything seem out of the ordinary with her on November 15th of 2021?
Not at all.
Okay. How much cash is in each yellow band on the first page of Exhibits 10?
They come in bands of 1,000.
So are those $1,000 strips?
Yes.
Okay. And do you recall how much cash is in this picture?
Yeah, 14,400. The remainder of that. Last one.
And was that your cash that you were giving Ms. Blair?
Yes, it was.
And did you indeed give that cash to Ms. Blair?
Yes, I did.
And what did that payment relate to?
The purchase of 11247 Lakeshore Drive.
Okay. And if you turn to the second page of Exhibit 10, can you describe what's going on in this picture?
Yeah, she's shuffling the money to show it for the camera. She's spreading it out.
Is she counting the money in this picture?
Yes.
Did Ms. Blair appear to have any trouble counting your money that you gave her on the state?
Not at all.
And do you see the document under that money that Ms. Blair is counting?
Yes.
Do you recognize that document?
Yes.
What is that? We haven't gone over it yet, but what is that document?
That's the lease option to purchase.
And are you aware that Ms. Blair has claimed in this case that she didn't have the mental capacity to sign the lease with the option to purchase on November 15th of 2021?
Yeah, I heard that.
How do you feel about that?
God, that's ridiculous. I mean, she was fine. She's been fine. She's really sharp.
And if you want to turn to the third page of Exhibit 10, can you describe to me what's going on in this picture?
Yeah, I apologize. I was looking at that one before. That's why I said that. No, this is yes. This is she's spreading out the money. It's a picture of Rosemary with the money showing.
And again, how much cash is she holding?
14,400.
All right. I want to direct you to the envelope below the cash. Do you see that?
Yes.
Whose writing is on that envelope?
Mine.
Okay. Now I want to direct you to what's marked for purpose identification as Exhibit 11. So flip to the next tab. Have you seen this document before?
Yes, I have.
Are you familiar with this document?
Yes, I am.
And what is this document?
It's a copy of the money I paid Rosemary. I received the money I paid Rosemary Blair.
Now, is that a close-up of the envelope that we just went over as the third page of Exhibit 10?
Yes, it is.
And did you take this picture?
Yes, I did.
When did you take this picture?
November 15th of 21.
And why did you take this picture?
As proof I made the payment.
What device did you take this picture with?
My iPhone.
And does this picture appear to be a true and accurate copy of the original?
Yes, it does.
Your Honor, we asked that Exhibit 11 be admitted to evidence.
Exhibit 11 is admitted. It's also contained in page 3 of Exhibit 10. But the defendant testified that he made it out. It's a fair and accurate photo, what he saw.
Mr. O'Donnell, was the top of the envelope states in Exhibit 11?
Paid Rosemary Blair, $14,400.
And is there a date?
Oh, yeah, November 15th of 21.
And below that, what does it state?
The purchase of 11247 Lakeshore Drive.
And did you indeed pay Ms. Blair $14,400 on November 15th of 2021?
Yes, I did.
And how did you make that payment to Ms. Blair?
Cash.
And how did you deliver that payment to Ms. Blair?
I hand delivered it.
And what did that payment relate to?
The purchase of 11247 Lakeshore Drive.
Green light, can you put a sticker next to that for me, please? All right, another math exercise. How much money had you paid Ms. Blair on November 15th of 2021?
$85,000.
And is that the sum total of all the payments that we just went through as the previous exhibits?
Yes, it is.
$85,000 is a lot more than $30,000, isn't it?
Oh, yeah.
And did all that $85,000 relate to the purchase of 11247 Lakeshore Drive?
Yes, it did.
All right, I want to direct you to what's marked the purpose identification in Exhibit 12. Have you seen this document before?
Yes, I have.
Okay. Are you familiar with this document?
Yes.
What is this document?
It's a copy of a text I sent, or a picture of a text I sent to Rosemary.
And were you a party to this text message string?
Yes, I was.
And did you send this text message?
Yes, I did.
Does this text message appear to be a true and accurate copy of the original?
Yes, it does.
What is the name at the top of this text message thread?
Rosemary.
Who is that referring to?
Rosemary Blair.
Is Rosemary how Rosemary is saved in the contacts of your phone?
Yes.
Your Honor, we'd ask that Exhibit 12 be admitted to evidence.
Date is January 31. It is admitted.
You stole my next question. What's the date at the top of that text message thread?
January 31st, 2022.
Okay. And in that text message, you write, Rosemary, good morning. I'm finally feeling better. I feel safe coming today, or I can wait for Carla. I'll just wear a mask, whatever you would like. Anyway, I do have $14,000 cash and the taxes will be paid before due. This will make $100,000 total down on 11247 Lakeshore Drive. Did I read that correctly?
Yes, you did.
All right, what's going on around the time that you sent this text message?
Well, I was going to make the final payment to her to make the $100,000 because we'd already made the $85,000, and then this would be the final payment to bring it up to the $100,000. And I was just confirming with her, I didn't have COVID, but I was really sick and I was trying to get to her and I didn't want to get her sick or anybody sick. So I was just trying to figure out a way to pay her. And this is just the fact I was just writing her things saying I was coming to pay her.
Now 85 and 14 don't add up to 100,000.
So we're going to get into next.
Yeah.
So did you meet up with Ms. Blair on January 31st of 2022?
Yes, I did.
Okay. And where did you meet with Ms. Blair?
Her house.
Is that Crown Point, Indiana?
Yes.
Indiana? Okay. Did you pay Ms. Blair money on January 31st of 2022?
Yes.
And how much money did you pay Ms. Blair on January 31st of 2022?
$14,500.
Okay. So did you just pay her additional $500 than what's referenced in this text message?
Yes.
And how did you make that payment?
Cash.
And did Ms. Blair specifically request that you pay her $14,500?
Yes.
And how did you deliver that payment to Ms. Blair?
I hand delivered it.
Okay. And this document specifically states that with that payment, you made $100,000 total towards 11247 Lakeshore Drive.
That put the ball on her side of the court, yeah.
So as of January 31st of 2022, how much money had you paid Ms. Blair?
$100,000.
We're still 500 off, but
I think the testimony, Your Honor, was that he paid 14,500.
yeah, and 85,000 and 14,500 adds up to, doesn't add up to 100,000.
Or this and that, no.
So 99.5.
Yes.
Okay.
And I accepted his $85,000 figure. I didn't add those numbers up through November 15th. So maybe a minute and do that, but we're $500 off.
Mr. O'Donnell, if you could put a green light next to Exhibit 12 for me.
Let me take just a moment. Let me add that up. 24,500 plus 15,000 plus 7,000 plus 9,000 plus 4,000 plus 10,000 plus 500 plus 600 plus 14,000 adds up to $84,600.
I think November 15th was 14,400, Your Honor.
Oh, 400 plus 400.
What was that again, please, Counsel?
Yeah, that adds up to $85,000. November 15th was 14,400, so it does add up to 85,000.
Okay, and then with the addition of 14,500, it will be 99,500.
Yes.
All right. Is that accurate, Mr. O'Donnell?
Yeah, I believe we're paid at 100,000, but yeah, it's accurate. It's accurate.
Might have been my mistake as a rounding error.
Okay, yeah.
Okay.
All right, let me back up for a minute. Let's go back to Exhibit 11. You're probably going to get to this, but this is a question I've had since the very first day. This shows a picture of the lease option to purchase. Who drafted that lease option to purchase?
Rosemary and I did together.
Who typed it up?
We just went on the computer and got it off of like Rocket Law or whatever it was. It was Rocket Law, I believe.
And where was that done?
That was partially done at my house, and then I sent her over something, and then I think she sent me back the thing. She had her attorney or someone look at it. She sent something back to me, and then we met at her house, and I just printed this thing up, and then we just did it there.
All right, then at some point you went to a notary to have it signed?
Yeah, she called and had it set up at her bank or whatever. So when we met her at the house, we went over everything, and then we went up to the notary later on.
And that was at a bank?
I believe so, yeah. It's Rosemary's Bank.
You're stealing my thunder, Judge. Or anything.
All right, okay, go ahead.
Okay.
Now,
No, keep
just
going.
a minute, Ms. Bowers needed a break, maybe everybody else does too. Let's just take a short break, and then let's go back at 11:25, and then we'll plow on till lunchtime, but let's take a recess for everybody's benefit.
Okay, thank you.
He did the whole lease and brought it to my house, and it was not signed at my bank, but it was signed at the Winfield Township place where I live. And I don't know where the back page is there that says that.
Yeah, I don't. That's what I'm looking for.
I don't know if I have mine in the car or not.
There it is.
There it is. It wasn't done at the bank, it was done at Winfield Township. And he drew it all up. I never,
Made any changes?
and these things aren't true either. I have all my bank statements.
No, that doesn't, the bank statements aren't gonna prove. They could, but they don't necessarily.
Is the promissory note in there?
Yeah,
No,
somewhere.
no.
Okay, well, I have it. So what's the point? He never pled it.
They were both signed at the Winfield Township.
Okay. There it is.
Yeah, that was signed the same place. And one thing Matthew did ask me, if she asked me, the notary, if I knew what I was signing. And she never asked me that. That is the truth. I'm not.
Okay, well, we're not gonna win on the.
Huh?
We're not going to win on the, oh, by the way, you weren't competent. We aren't going to win on, oh, by the way, you aren't competent.
On the what? I gotta go outside. I can't hear.
I just had a couple pieces of cauliflower, which was not nearly as satisfying as a muffin or something, but trying to rein it in.
Thank you. Cold in here.
Yeah, I'm sorry.
We're crowded in here today.
Yeah, some days it gets crowded, but usually it's just me and a couple of cameras and remote people, but it's good to get back to real live trial work.
Wish I could fix it. Direct exam is the boringest part of everything. I don't, if you have a solution to that, let me know.
You have to be methodical about it. I tried over 100 felony cases in my day. I don't know how many misdemeanors. It's been a while since I've had to do it, more than 20 years. All right, we're back on the record. We were starting to address exhibit number 12. We'll plow on ahead until lunchtime.
All right, we entered exhibit 12 into evidence,
Yes.
correct? Okay, all right. All right, Mr. O'Donnell, I want to direct your attention to what's marked as exhibit 13. Is there a green sticker next to exhibit 12?
Yes, there is.
Okay, great. Don't want to miss a green light.
No, we do not.
All right. Mr. O'Donnell, have you seen exhibits 13 before?
Yes.
Are you familiar with this document?
Yes,
What is this document?
it's a text from me to Rosemary, between me and Rosemary.
And were you a party to this text message?
Yes,
And what is the name at the top of this text message thread?
Rosemary,
And who is that referring to?
Rosemary Blair.
And is that how Rosemary Blair is stored in your phone?
Yes,
And whose text messages are on the blue bubbles on the right?
those are mine.
And whose text messages are on the black bubbles on the left with the rows after them?
That would be Rosemary.
And does this text message string appear to be a true and accurate copy of the original?
Yes,
Your Honor, we would ask that Exhibit 13 be admitted into evidence.
Your Honor, I don't see any numbers on this one. I question the relevancy of this. What does it prove? I don't think it proves anything.
Well, it gave me an epiphany when I read, I am back at the slot machines by self-parking. Maybe something happened on the 9th, 10th, or 11th, and they're referencing seeing each other. So I'll allow him to testify about what it is before we rule on your motion.
It's, for purposes of foundation, you're exactly right. There's direct evidence, there's circumstantial evidence. Circumstantial evidence is just as accurate as direct evidence sometimes, and we'll prove through the testimony what the circumstantial evidence is. All right, I want to direct you to the text message that says, "I am here." Do you see that?
yes,
Okay, and there's a rose after that?
yes, sir.
Okay. Who sent that text message?
Rosemary did.
And what's the date above that text message?
March 10th of 2022.
Okay. And the next text message down, you state, "We should be there at 12:30. Sorry, running late." Is that correct?
Yes,
And Miss Blair writes back, "I am at the slot machines back by self-parking." Do you see that?
yes,
Did you meet Miss Blair somewhere on March 10th?
yes, I did.
Where did you meet her?
At the Four Winds Casino in New Buffalo.
And whose idea was it to meet at the casino?
Rosemary Blair's,
And why were you meeting Miss Blair at the Four Winds Casino?
to give her money
And what was that money for?
for the purchase of 11247 Lakeshore Drive.
And did you pay Miss Blair any money on March 10th of
Yes.
2022?
Yes, we did.
How much money did you pay her?
$2,000
What form was that payment in?
cash
And what was that payment for?
for the purchase of 11247 Lakeshore Drive.
Green light, can you put a green sticker next to? All right, Mr. O'Donnell, I want to direct you to what's marked for purpose identification as
All
exhibit.
right, well, exhibit 13 is admitted over the objection.
Mr. O'Donnell, I want to direct you to exhibit 14.
Okay.
Have you seen this document before?
Yes, I have.
Are you familiar with this document?
Yes, I am.
And what is this document?
It's a picture of the text between Rosemary and myself.
And you were a party to these text messages?
Yes, I was.
And does the text message string appear to be true and accurate copy of the original?
Yes, it does.
And again, whose name is at the top of that text message?
Rosemary's,
And who is that referring to?
Rosemary Blair.
And again, whose messages are on the blue bubbles on the right?
Those are mine.
And whose messages are on the black bubbles on the left?
Rosemary's.
Your Honor, we'd ask that exhibit 14 be admitted into evidence.
Same objection, Your
Yeah,
Honor.
this-
There's no relevancy.
Was there a meeting at Four Winds on April 12th?
That's the
Yes.
next part of it, Your Honor.
All right.
Okay. Mr. O'Donnell, what is the date at the top of the text message string and exhibits?
April 12th of 2022.
14. Okay. April 12th of 2022.
Yes.
And I want to direct you to a text message that states, "I am at Four Winds. Give me a call when you arrive. I tried to call your mailbox full like me." You see that?
Yes, I do.
And what date is above that text message?
April 12th of 2022.
And who sent that text message?
Rosemary Blair.
And the next message down, you state, "I have to stop at the bank. It should be about 20 to 30 minutes.
Yes.
Why were you stopping at the bank?
To get her cash.
And the next text message down, you say, "It was great seeing you. I hope you have a lovely day."
Yes.
Did you see Miss Blair on April 12th?
Yes, I did.
Where did you see her at?
The Four Winds Casino.
Whose idea was it to meet at Four Winds Casino?
Rosemary Blair's.
And did you pay Ms. Blair any money on April 12th?
Yes, I did. I paid her $2,000.
And what was that payment for?
The purchase of 11247 Lakeshore Drive.
Green light, if you could put a sticker next to that message or exhibit, that'd be great.
Where the objection noted, exhibit 14 is admitted.
Mr. O'Donnell, I want to, on the same document, I want to direct you to the text where it states 5:10 p.m. on April 12th of 2022. We have to stay in touch. Seeing you and how much you like Corey makes me happy. Happy Easter to your family. Do you see that?
Yes, I do.
Sent that text message.
Rosemary Blair.
And what was your understanding of that text message?
She was happy that we bought the house and that we were enjoying it.
All right, we're gonna come back to exhibit 15. I want to skip over to exhibit 16.
16 now?
Yes. Have you seen this document before?
Yes, I have.
Are you familiar with this document?
Yes, I am.
What is this document?
It's text between me and Rosemary.
And were you a party to these text messages?
Yes, I was.
And does this text message string appear to be a true and accurate copy of the original?
Yes.
And what is the date of this text message?
June 8th, Wednesday, June 8th of 2022.
And does it span over another day?
What's that?
Does it span
Hold
over
on
another
a
day?
second.
Yeah.
Exhibit 15 is 2 pages.
We're on exhibit 16. We skipped
So, yeah,
15.
We're going to
We're gonna come back.
16. I knew we were skipping, but I didn't realize it was second page.
Yeah,
All right,
sorry.
so these are texts of June 8th.
Your Honor, my exhibit 15 only has 1 page. Is there
Exhibit
any-
15
That's
shows,
16 is 1 page.
15 shows a text message and then a bank statement from First Midwest Bank.
Okay, very good. I have that.
So 16 is a text titled Rosemary, Wednesday, June 8th.
So we skip 15, and to no surprise, we're gonna have a different witness testify about that, who can lay a proper foundation. So we're at exhibit 16, which is the June 8th and 9th text messages. Mr. O'Donnell, whose text messages again are in the black bubbles on the left of exhibit 16?
Rosemary's.
Okay, and whose text messages are in the blue bubbles on the right?
Those are Rosemary's. I mean, those are mine. Sorry. The blue is me.
The blue is you?
Yes.
And what is the name at the top of this text message thread?
Rosemary.
Your Honor, we'd have asked to admit exhibit 16 as evidence.
Same thing. Go ahead and lay the further foundation.
Mr. O'Donnell, I want to direct you to the text message that states, "Good morning. Hope everything is going well. What time tomorrow at Four Winds? See you then. Things are desperate for cash. Thanks." Do you see that?
Yes, I do.
It's got a rose after it, correct?
Yes.
Who sent that text message?
Rosemary Blair.
And you write back,
Your Honor, what exhibit have I missed it?
We're exhibit 16, Rosemary, Wednesday, June 8th. Good morning. Hope everything is well. What time tomorrow at Four Winds? See you then.
you're on
Things are
15,
desperate
16.
for cash.
Oh, fair enough. I'm sorry, Your
All right.
Honor.
Again, Ms. Blair states, "Good morning. Hope everything is going well. What time tomorrow at Four Winds? See you then. Things are desperate for cash." You see that?
Yes, I do.
Who sent that text message?
Rosemary Blair.
And you wrote back, "Rosemary, I have to wait for Carla. I'll call you maybe around 2." You see that?
Yes.
And Miss Blair writes back, "Okay, I really need cash. Thanks." Is that correct?
Yes.
Do you recall meeting with Miss Blair on June 9th after this text message string?
Yes, I did.
And what date did you meet with Miss Blair?
On the 9th.
Of June?
Yes.
And where did you meet her at?
The Four Winds Casino.
And why were you meeting Miss Blair?
To pay her cash.
And what was that cash for?
The purchase of 11247 Lakeshore Drive.
And did you pay Miss Blair money on June 9th of 2022?
Yes, I did. I paid her $2,000
And what was that payment for?
for the purchase of 11247 Lakeshore Drive.
Green light. Can you put a green sticker
Yep.
next to that?
That was 16, right?
Yes. See it 15. All right, Mr. O'Donnell, in exhibit 16, twice, Ms. Blair mentions that she's desperate for cash, correct?
Yes.
Okay. Did you have a discussion with Ms. Blair about why she was desperate for cash?
I mean, kind of, yeah. She just basically told us that, I mean, everything that her money got cut off. She was getting money from like this oil money that she had from oil land she owns down in Texas, and they reduced her amount of rate. And she said her kids were, trying to take her money, and she said that she was just losing money everywhere.
So she was using you as the bank, correct?
Yes.
Were you concerned that you were giving her these large amounts of money at a casino?
No, because I mean, she's pretty believable, Your Honor. I mean, it wasn't that she didn't pretend like she was gambling there. She said she was going there to get the free gifts that they give out or whatever they give. That's why we went on I think it was on Thursdays or Wednesdays or whatever day it was. I had blinders on, Your Honor. I mean, I didn't really, it's kind of.
Well, and you live in New Buffalo, so the casino is not very far from your
Not at all,
house.
no.
So what I was gonna ask is, the city of New Buffalo, how far is Four Winds from you?
It's like 5 minutes, 10 minutes tops.
The longest part of the drive is probably the driveway.
It is, and they're getting there from
from the road back to the casino.
But for Rosemary, it's easy too, because you can get off 94 right there, and then you just top right to it's right there in the casino.
All right, I want to direct you to what's marked as Exhibit 17. Have you seen this picture before?
Yes.
And are you familiar with this picture?
Yes.
Okay. Is it the same as a demonstrative board up over here in front of you?
Yes.
And what is this picture?
It's a picture of money I'd given to Rosemary Blair.
Did you take this picture?
Yes, I did.
When did you take this picture?
On July 1st of 2022.
And again, why did you take this picture?
To prove I paid her money.
Okay. What device did you take this picture with?
My iPhone.
And where did you take this picture at?
At her car at Corey Lake. She was at the house at Corey Lake.
So when you say Corey Lake, is that the same as 11247?
Yes, at the residence.
Okay.
Question.
All right. So Miss Blair drove up to you at Corey Lake.
Yes.
And does this picture appear to be a true and accurate copy of the original?
Yes.
So it says 500.
She paid me that before. We just broke that down.
628, 22, 500, and then 2,000 on 7/1.
Yes.
Your Honor, we'd ask that Exhibit 7 be admitted into evidence.
17 is admitted.
Your Honor, if I may do brief part here.
Certainly.
Your Honor, can we just can we save cross-examination till the?
Well, he can voir dire on the photo, so I'll allow it.
What does the 500 on June 28th, 22 represent?
Payment. She came to me for money all the time. So all the money, all the payments I made to her just came off the purchase price.
Yeah, we're getting into the next questions I'm going to ask. So I can only ask the cadence of my questions. I can only ask one question, one fact at a time. So.
All right. So did we put a sticker on the 2,000 and 500?
Do we greenlight the?
I haven't gotten there.
Okay.
We could just short circuit this. Do you see the $500 at the top right hand corner of the envelope?
Yes.
Okay. And what's the date next to that?
June 28th of 2022.
Okay. Did you make a $500 payment to Ms. Blair on June 28th of 2022?
Yes, I did.
How did you make that payment?
Cash.
Okay. What was that payment related to?
The purchase of 11247 Lakeshore Drive.
And again, is there any other reason during this time that you would have paid Ms. Blair any money other than towards the purchase of?
Not at all. No.
And then $2,000 Rosemary 7/1/22. You see that reference?
Yes.
Okay. Did you pay Rosemary $2,000 on July 1st of 2022?
Yes, I did.
How did you pay that money?
Cash.
Okay. What did that payment relate to?
The purchase of 11247 Lakeshore Drive.
Can you put 2 green lights for me?
Yeah, certainly.
And whose handwriting is that, Mr. O'Donnell, on that bank envelope?
Oh, that's my handwriting.
And probably a stupid question, but what's in that bank envelope?
It's $2,000 cash.
Not a thank you card, not an IOU?
No. She wouldn't accept those.
All right. I want to direct you back to Exhibit 2. And I do want to put on the record, I made a mistake. I added wrong.
So as of July of 2022, how much money had you paid Ms. Blair?
July of, wait a minute, hang on a second. Oh, I paid her 112,500.
But do you remember a testimony that we were off of
So
$500?
12,000, yeah.
Was that my mistake?
I believe so, yeah, but that's okay.
$500, I'm sorry. And is 112,000 now revised, the amount that's reflected in the summary that's exhibited?
Yes, it is.
And did we literally just walk through all of the evidence that you have that justifies and shows that you made payments to Ms. Blair adding up to $112,000 as of July 1st of 2022?
Yes, it does.
And again, what were all those payments related to?
They were for the purchase of this property, 11247 Lakeshore Drive.
Okay. All right, I want to switch gears and talk
Well, let me
about.
stop for a minute. Exhibit 2 is tentatively admitted based on the premise that you would tie it up with the exhibits listed, which has been done. So Exhibit 2 is admitted.
Thank you, Your Honor. All right, Mr. O'Donnell, I want to switch gears and talk about the contract that you entered into with Ms. Blair, so if we can turn to what's marked as Exhibit 18. Have you seen this document before?
Yes.
Are you familiar with this document?
Yes.
Okay, what is this document?
It's the contract we signed for the purchase of property.
And is it titled lease with option of purchase?
Yes.
And what property does this land contract relate to?
11247 Lakeshore Drive.
And does Exhibit 18 appear to be a true and accurate copy of the original?
Yes.
Your Honor, we ask that Exhibit 18 be admitted into evidence.
No objection, Your Honor. No objection. It's admitted. It's in pleadings and several different. It's in the original. It's in the original pleading, but it's admitted here for purposes of this.
All right, Mr. O'Donnell, I want to direct you to page 6 of Exhibit 18. On page 6 is a signature block that says landlord in all bold text. Is that correct?
Yes.
And whose signature appears to be under that heading?
Rosemary Blair.
And did you witness Ms. Blair sign that document?
Yes, I did.
Where did Ms. Blair sign this document?
At the Notary Public.
And where was the Notary Public?
Crown Point, Indiana.
Was that Ms. Blair's bank?
Yes.
Whose idea was it to sign this document at her bank?
Miss Blair's.
And did she tell you why she wanted it signed at the bank?
Just she knew the people there, and she said it was free, I believe.
Did she want to notarize?
Yes, she wanted to notarize.
Okay. What is the date next to Ms. Blair's signature?
November 15th of 2021.
And is that date the same date as these demonstrative with large stacks of cash that went over previously?
Yes, it is.
And again, did you have any concerns about the mental capacity of Ms. Blair? Okay. Did the notary express any concerns?
No, everybody was fine, and she.
And the next signature block down is the heading states tenant in all bold. Do you see that?
Yes.
Whose signature is under that tenant heading?
That's my signature.
And what's the date next to your signature?
November 15th of 21.
Okay, is that the date that you signed this document?
Yes, it is.
Okay, and where were you at when you signed this document?
At the Notary Public.
Okay. Crown Point, Indiana?
Yes.
All right, the next signature block says tenant again.
Yes.
Whose signature appears under that heading?
Carla Bowers.
And did you witness Ms. Bowers sign this document?
Yes, I did.
And where did Ms. Bowers sign this document?
At the Notary Public.
Okay. What's the date next to Carla's signature?
November 15th of 2021.
Okay. And were you living at the house at 11247 Lakeshore Drive as of November 15th of 2021? Yes. Okay. I want to turn back to page 1 of Exhibit 18. First paragraph states, lease with option to purchase is effective on November 15th of 2021. You see that?
Oh, I'm sorry, I skipped it. I gotta go back to the hand 1 second. Go, yes.
So lease with option to purchase is made effective on November 15th of 2021. Do you see that?
It says November. Are we under term?
No, under lease with option to purchase, the first paragraph.
Oh, okay, sorry. Yeah, I got it. Yep,
Okay.
yep.
Your Honor, this has already been admitted it speaks for itself for him to go through each and every section. I don't know, is it?
Well, hopefully we aren't gonna do that, but he's identifying what it is, so let's see where we go.
Yeah, I think there's relevant sections of this. Again, specific performance requires that our client fully perform with the obligations under the contract. I have to offer proofs. I'm not gonna go through every single word, but we need to offer proofs and some testimony. And also admit into evidence. I guess the other thing we could do is.
Well, 18 is admitted, but,
Opposing counsel would just stipulate that that Mr. O'Donnell, Ms. Bowers fully comply with the requirements of this contract.
I'd like to hear the testimony. I'm new to it.
Okay.
I guess you can have it both ways, so, all right, we'll slog through it. We've got 15 minutes before lunch.
And the first paragraph, I'm sorry, November 15th of 2021, the first paragraph, is that the same date that you signed this document?
Yes, it is.
Okay. And the first paragraph states, lease with option to purchase is made between Rosemary Blair and Joseph O'Donnell and Carla Bowers. Is that correct?
Yes.
And what property does this document relate to?
11247 Lakeshore Drive.
And is that property identified in this document?
Yes, it is.
Okay. All right, I want to direct you to the heading that's titled premises in all bold caps. You see that?
Yes.
Starting on line 4, 1, 2, 3, 4, it states this agreement is entered into between the parties and is essentially a purchase agreement. Do you see that?
Yes.
What's your understanding of the term of the agreement?
It was just, this is like where we came up with the land contract idea. It was just that, we were going to pay the $85,000 down, and then we were going to have time, and we weren't going to make any rent payments or anything until we had the final balloon payment due in the future.
And is that consistent with what your understanding of a land contract is?
Yes, it is.
So while it's maybe titled off of Rocket Mortgage lease with option to purchase, did you intend this to operate as a land contract?
Yes, we did.
And line 5 states the parties have paid Rosemary Blair $85,000 of the $450,000 purchase price. Do you see that?
Yes.
And what is the total purchase price according to Exhibit 18 for the purchase of the property?
$450,000.
Okay. And is that the amount that you and Ms. Blair discussed and agreed to purchase the property for?
Yes, it is.
All right, so the document states that you paid Rosemary $85,000, correct?
Yes.
Okay. Ms. Blair signed this document?
Yes, she did.
Okay. And had you actually paid Ms. Blair $85,000 as of November 15th of 2022?
Yes, we had.
Can you think of any reason why Ms. Blair would claim that she was only paid $30,000?
No, I can't at all. Essentially lying.
And she signed a contract to the effect that she was actually paid as of that day $85,000. Is that correct?
Yes, it is.
And we just went over the various payment documents that support the $85,000 that you paid as of November 15th of 2022, correct?
Yes.
Okay, look at line 6. It states the parties agree that Joe O'Donnell and Carla Bowers will have a reasonable time to secure the remaining $365,000 for purchase. Do you see that?
Yes.
All right. So is 450 minus 85, 365?
Yes.
Okay. So what's your understanding of that term?
That when the balloon payment came due, we'd pay her the 365, and then we get title of the property.
Okay. And now I want to talk about what triggered the balloon payments. Line 8 states, once Rosemary Blair informs Mr. O'Donnell and Ms. Bowers she's ready to close on the purchase, or to close, the purchasers shall have 3 months, 90 days to close. What is your understanding of that term?
Basically, once Rosemary got everything in order and she was ready to, she gave us the green light to close on it, then we could, we had 90 days to get the financing ready and to set the closing date and take care of the, buy the property, come up with the $365,000 and pay her the property.
So is it accurate to say that once Ms. Blair notified you that she wanted to close on the property, that you would have 3 months to pay the remainder of the purchase price?
Yes. And if it went over that, I'd have to pay $1,000 a month.
Okay. All right. We're going to come back to Exhibit 18, but I want to quickly skip to Exhibit 19. Have you seen this document before?
Yes, I have.
Are you familiar with this document?
Yes, I am.
What is this document?
It's text messages between Rosemary and myself.
And were you a party to these text messages?
Yes, I was.
Okay. And again, are your texts on the blue bubbles on the right?
Yes.
And are Miss Blair's texts on the blue bubbles on the left?
Yes.
Excuse me, the black bubble.
Black, yes.
Does Exhibit 19 appear to be a true and accurate copy of the original?
Yes.
Your Honor, we'd ask that Exhibit 19 be admitted into evidence.
Objection?
No objection, Your Honor.
It's admitted.
What's the name at the top of this text message thread?
Rosemary.
Who's that referring to?
Rosemary Blair.
And I want to direct you to the attention to the text message Ms. Blair sent you on August 4th of 2022 at 8:41 p.m. Do you see that?
Yes.
And that text message, Ms. Blair states, per your text of August 3, 2022, you state you have the money to close today. I want to close ASAP. Thanks, Rosemary. Did you state that you had the money to close that day, or did you?
I said we're ready to close whenever you want, yeah.
Did you ever say that I've got the money to close right today, or did you tell her that you had the money to close?
I didn't have the money. I don't think I would have told her that if I didn't have the money right then. So
I'm sorry.
Leading suggestive, the document speaks for itself.
Well, it isn't clear. She says you have the money to close today. Of course, it didn't change the terms of the agreement. And you say, thank you, I have my attorney working on. Is that correct?
Yes.
Then she says, have your attorney call my attorney intake number. Was that presumably something to pay it to?
Yeah, these attorneys won't respond to you or anything. You call them and they don't.
This is some regional strange kind of a thing. All right, so she says, I'm ready to close. You say, thank you. And then at the end, you say, hopefully it will be next week. That's your response?
Yes.
And was this the first time that Ms. Blair informed you that she wanted to close on the sale of the property?
Yes.
Was this the first time that Ms. Blair provided you with written notification that she wanted to close on the sale of the property?
Yes.
Is this document what triggered your balloon payment of 90 days to close on the sale of the property?
Yes.
And as of August 3rd of 2022, how much money had you paid Ms. Blair towards the purchase of the property?
$112,000.
Not $112,500, correct?
No, yeah.
And as of August 3rd of 2022, how much of the remaining purchase price did you have to pay within 90 days?
It was like 335 or something, or no, 300, I forget.
That'd be 338.
338, yeah. Okay.
And how did you intend to pay the remainder of that purchase price?
Just a standard loan.
By the conventional loan?
Yeah, just conventional 30-year fixed loan.
And were you in the financial position to secure $338,000 of financing within 90 days of August 4th? Okay. And you intended to secure that through a
bank, just through the bank.
Okay. Through a conventional loan?
Yes.
Okay. And what was the term of the loan that you intended to secure?
Be 30-year.
And as of August 4th of 2022, did you have sufficient collateral to secure a loan for $338,000?
Yes, I did.
Okay. You got two properties in New
Yes,
Buffalo,
we
correct?
both did. Yeah, I have two properties. Yes, yes.
Do you have other investments and other assets?
Yes.
So that would be sufficient collateral for $338,000.
Yes, I do.
And then Ms. Bowers has.
She also, yes.
Has assets, correct?
She was forced to buy a house for 42 weeks later, so yeah.
So would you have been ready, willing, and able to close on the sale of the property within 90 days of August 4th of 2022? And did you actually intend to close on the sale of the property?
Yes, we did.
Okay. All right, let's turn back to Exhibit 18. I want to direct you back to the section that is titled premises in all bold. All right, line 11.
What page are we on?
Oh, sorry, excuse me, page 1. Under premises, line 11. Do you see where it states, this agreement includes all real and personal property, including all boats, toys, and furnishings located at 11247 Lakeshore Drive, 3 Rivers, Michigan 49093?
Yes.
Okay. What was your understanding of that term?
There was lots of boats and toys at the house, and there's like just beach stuff. There was everything, and that it was all going to be included with this deal. Like when we bought the house, it was all coming with the house. She was selling it as a package.
So addition to the dirt in the house,
There was 5 boats. There was a pontoon, there was a ski boat, and then there was a paddle boat, and there was a canoe, and there was a little Hobie cat.
okay, let me write that down. So in addition to the dirt in the house, this mentions the furnishings located at the property.
Yes.
Was it your understanding that the furnishings located at the property at that date would be part of the purchase price of the house?
Yes.
Did you discuss that with Ms. Blair?
Yes.
Okay. And then it talks about boats and toys. Let's talk about boats. What boats is this section referring to?
It's referring to, there was a pontoon boat, and there was a ski boat, and there was a paddle boat, and then there was a canoe, and there was a Hobie cat.
Excuse me, Your Honor, I think all this testimony is important for the conversion part of the complaint, but not.
Where are those items now? Do you have possession of them?
No.
All right.
You took my question away.
All right, well, he's right. These go to damage. Certainly not artfully drafted, no VIN numbers or anything, but your understanding was the purchase price was going to include all of this.
Yes.
And Your Honor, part of our request for specific performance would be to require Ms. Blair to fulfill the terms and obligations of the contract, which would be to give back or to tender possession of the items of personal property and the boats. And we're going to get into detail about the boats here in a second. So it does go to conversion.
Let's take a recess.
Okay. Thank you.
Thank you.
We'll resume at 1 or shortly thereafter. If they go out for lunch, it might take a few minutes past 1. Dining options, you've been here to Centerville. We got Yoder's, we've got McDonald's, we've got the Royal Cafe. I don't know if the restaurant across the street. So, and the new place, the Chill Bean, right on Main Street, is highly regarded, right across from the courthouse. All right, we'll stop the. All right, we're gonna break at 2:30 to do a brief criminal matter, but we should be able to deal with that. Let's go on the record. We are back on the record in the specific performance hearing in the matter of Rosemary Blair versus Joseph O'Donnell and Carla Bowers, file number 221862LT. All the parties that were here this morning are here after our lunch and recess. We have a couple other things we need to take care of this afternoon, but we were in the direct examination of Mr. O'Donnell by Mr. Hatch when we were discussing Exhibit 18, which is the original lease option to purchase. Mr. Hatch.
Thank you, Your Honor. Mr. O'Donnell, if you could flip over to Exhibit 18 if you don't already have it in front of you. And do you recall going over parts of this document before, which is the lease with option to purchase prior to lunch?
Yes, I do.
Okay. And I want to direct you back to the section titled premises on page 1. See that?
Yes.
Okay. And again, line 11 states that all real and personal property, including all boats, toys, and furnishings located at 11247 Lakeshore Drive, the agreement should include the sale of that, correct?
Yes.
And again, for purposes of the record, what boats, from your understanding, were included with the sale of the property?
There was a ski boat, which is an old hydro stream, and there There was a pontoon boat, and there was a paddle boat.
Just a minute. How big is this?
The
ski
pontoon
boat?
was an 18.
No, the ski boat.
I think it's a 16-footer.
Inboard, outboard?
It's outboard.
Size motor?
I think it's got a 75 on it.
All right. And it's a hydro stream?
Yes.
Not familiar with that brand. All right, the pontoon?
That's a 18-footer. That one's a Sun Tracker party buoy or barge.
Size motor?
That has a 25 horsepower on it.
Okay.
And then you testify that there was a paddle boat, a Hobie cat, and a canoe, correct?
Yes.
Okay, and a Hobie cat is like a sailboat?
It's a sailboat that's got a little canvas in the middle that you sit on.
It's like a tiny catamaran.
Yeah, it's a smaller cat. It's like a 14-foot Hobie cat or something like that.
And the paddle boat is like one of the ones that I used as a kid where you got to paddle
Four people,
it,
yeah, side by side,
plastic.
you got the little stick.
Okay.
Those are fun. You paddle out to where you go, then you have to turn around and paddle back. Usually into the wind, so people that own them don't use them too much. The guests come and use them. They mostly sit there upside down on the beach. All right, and then we have a kayak or canoe.
Do you remember what brand the canoe was?
No.
It
was a huge one. I mean, it was probably, at least a 12, 14-foot canoe.
Yeah. And those boats were located on the property at the time you entered into the land?
Yes.
I want to direct you to what is marked for purpose of identification as Exhibit 20. Have you seen this picture before?
Yeah. Yes.
Are you familiar with this picture?
Yes, I am.
Can you describe in your own word what this picture is?
It's a picture of Carl and I out on the Hydro Stream boat cruising around Corey Lake.
Okay. And is that the Hydro Stream speedboat that you referenced earlier in your testimony?
Yes, it is.
Okay. And when was this picture taken?
The summer of 2021.
Okay. And does Exhibit 20 appear to be a true and accurate copy of the original?
Yes, it does.
And do you recognize who is driving the boat in that picture?
That's me.
Okay. You got a big old smile on your face?
Yes, I do.
Okay. Who's next to you on the boat?
Carla, ours.
Did you ever let Carla drive the boat?
I can't drive to answer that.
No.
It's a hard boat to drive. But.
Your Honor, we would ask for the Exhibit 20 to be admitted in evidence.
I'll get you there in a minute.
And again, this was the HydroStream boat that Ms. Blair agreed to sell you as part of the lease with option to purchase.
Yes,
correct?
it is.
And are you currently in possession of the HydroStream boat?
No.
Do you have any idea where the HydroStream boat is?
I have no idea. It had a trailer too that's missing as well.
Okay. Do you know what year the HydroStream boat was?
I think it was I believe it was like an 86 or 87 or something like that.
A 75 horsepower engine?
Yes.
Okay. And was it in good working
It
condition?
was in excellent condition, yes.
And the interior was in good
Perfect,
condition?
just redone. Yep.
Do you wish that it was are you familiar with Malibu boats?
What? Oh, yeah.
Do you wish that it was a Malibu boat? I know somebody else with the Malibu boat.
That's an inside joke, but
And again, you don't know where the boat is located, correct? Okay. All right, I want to direct you to Exhibit 21. Have you seen this picture before?
No. Oh, yeah. Yes, I have. Sorry.
Have you seen this picture before?
Yes, I have.
Okay. Are you familiar with this picture?
Yes, I am.
Did you actually take this picture?
Yes, I did.
Okay, so you've seen the picture.
Yes, I
before.
have.
And does Exhibit 21 appear to be a true and accurate copy of the original?
Yes.
And is that one of the boats that Miss Blair agreed to sell you as part of the lease with option to purchase?
Yes, it is. That's a pontoon boat.
And is that the Sun Tracker pontoon boat?
Yes, the 18-foot. Yep.
Okay. And it was 18 foot in length?
Yes.
Okay. And it had a 25 horsepower engine on it?
Yes, I believe so. Yes.
Was it in good working condition?
Yes.
Okay. And did you drive that boat previously at Corey Lake?
Yes.
Okay. And the interior of the boat was in good condition as well? Your Honor, we would ask that Exhibit 21 be admitted into evidence.
no objection. Admitted, and again, you don't know where it is.
Next question. So you're not familiar with, you don't know where the
No clue.
Pontoon boats.
No.
Were these boats in the water when the condemnation inspection took place?
Yes, the speedboat was, and the pontoon boat was at the lift getting ready to be put in, and they both disappeared. The one was taken out of the water, the trailer was taken off the property. The trailer was on the property and the boat was in the water, and they took the trailer in, and they took the boat, and then took the pontoon boat from the, they had it storage.
Pontoon boat was in
It
storage?
wasn't in storage, I'd taken out. It was across the street from the public launch there, Corey, by the Happy Landings.
Yes.
My friend owns that storage unit over there, so he let me just park it over there. It was uncovered, it was ready to go in the water. It was supposed to go in the water like that week.
Okay.
Did you authorize Ms. Blair or anybody else to
No.
take these boats? Okay. Have you demanded that Ms. Blair return these boats to you?
Yes.
And has she refused?
No, yes, she has refused.
All right, I want you to turn back to exhibit 18. And I want you to turn to page 1. And on page 1, there's a paragraph in bold that's titled term. Do you see that?
Yes.
And under that paragraph, it states that the lease begins on November 12th of 2021 and terminates on December 30th of 2022, correct?
Yes.
Did you reside at the property at 11247 Lakeshore Drive until the end of the lease term?
No.
Why not?
Rosemary had us kicked out.
All right, I want to direct you to paragraph, excuse me, exhibit 18, the paragraph titled lease payments, which is right under the paragraph we just were looking at. You see that?
Yes.
And that section states tenant shall pay landlord monthly installments of $0 per month. Do you see that?
Yes, I do.
What was your understanding of your lease payment obligations under the land contract?
We'd already paid our lump sum down, so we had 0 payments until the end of the maturity date of the balloon payment.
So that wasn't a mistake?
No, that was not a mistake.
That was intentional?
Very intentional.
And did you discuss this payment term with Ms. Blair?
Yes, I did.
And did she agree to this payment term?
Yes, she did.
And despite this, did you pay Ms. Blair some monthly lease payments after January of 2022?
Yes, we did.
Okay, and why'd you do that?
Because she asked for it. She basically said that she'd take it off the purchase price. She was desperate as usual for money, and she was always coming at us. And it didn't matter to us at that point because we wanted to help her out, and we figured it was just coming off our total. So it didn't,
Probably never expected you to be here today.
No, not at all.
And you weren't required to make those payments on a land contract, correct?
Nope.
Objection, Your Honor. Counsel could refer this to as a lease option instead of a land contract.
Yes,
I
that's
think-
a sticks in my craw too. This is a lease option to purchase. They wanted to call it a land contract, they could call it that. So we'll call it by its correct title.
Understood. Apologies, Your Honor. I'll either say the exhibit number or the lease option to purchase.
Thank you.
So you were paying those monthly payments, just kind of trying to help Ms. Blair, right?
Yes.
Okay. I want to direct you to page 3 of exhibit 18, entitled default. Are you there?
Yes.
Okay. Can you read that paragraph into the record for me, please?
Yes, defaults. Tenant shall be in default of this lease if tenant fails to fulfill any lease obligation or term by which tenant is bound. Subject to any governing provision of law to the contrary, if tenant fails to cure any financial obligation within 30 days or any other obligation within 30 days, after written notice of such default is provided by landlord to tenant, landlord may elect to cure such default at the cost of such action shall be added to the tenant's financial obligations under this lease.
All right. And on the 4th sentence down, it references written notice of such default, correct?
Yes.
Did you ever receive a written notice from Ms. Blair or anyone else claiming that you were in default of any of your obligations under the lease?
No, we never were.
All right, I want to direct you to page 5 of Exhibit 18, entitled Remedies Upon Default.
I'm there.
Are you there? Okay. And that paragraph states, if tenant defaults under this option to purchase agreement or lease agreement, then in addition to the other remedies available to landlord in accordance with Michigan law, landlord may terminate this option to purchase by giving written notice of termination. Is that correct?
Yes.
All right. And if you go down 2 more paragraphs, there is a section entitled notice.
Yes.
Correct. So we just went over that, this references written notice, and then this paragraph provides how you provide written notice, correct?
Yes.
And that paragraph states, notice under this lease shall not be deemed valid unless given or served in writing and forwarded by mail, postage prepaid, addressed to the party at the appropriate address set forth below. You see that?
Yes.
Okay. And what is the tenant's address set forth below?
11247 Lakeshore Drive, 3 Rivers, Michigan, 49093.
And who are the tenants referenced above that address?
Joseph O'Donnell and Carla Bowers.
Did you ever receive a written notice of termination at 11247 Lakeshore Drive?
No, we did not.
Did you ever receive a written notice claiming that you were in default of any of your obligations under this lease at 11247 Lakeshore Drive?
No, we did not.
I want to direct you to the paragraph on page 6 that's entitled Entire Agreement Amendment. Do you see that?
Yes.
All right. Again, you did a good job before. Can you read that paragraph into the record for me?
Yes. Entire agreement amendment. This lease contains the entire agreement of the parties, and there are no other promises, conditions, understandings, or other agreements, whether oral or written, relating to the subject matter of this lease. This lease may be modified or amended in writing if the writing is signed by both parties.
Are you familiar with what an integration clause is called?
Yes.
And what's your understanding of the effect of that paragraph on any prior agreements or arrangements that you may have had with Ms. Blair?
That this is the main guiding document right here.
And is your understanding that this document supersedes any prior
Yes,
arrangements?
yes, unless we amend this, or this is it, yeah.
And did you and Ms. Blair ever amend the lease with option to purchase contract by a writing signed by both of you?
No.
I want to switch gears now and talk about the condemnation. If you could turn over to what's marked as purpose of identification as Exhibit 22. Before we go there, let me finish with this. We just reviewed Exhibit 18, which is the lease with option to purchase, correct? Is it your understanding that you fulfilled all of your obligations with respect to Ms. Blair under that contract?
Yes.
And you were never provided any with any written notice of default by Ms. Blair under that?
No.
All right, if we look at Exhibit 22, have you seen this document before?
Yes.
And are you familiar with this document?
Yes, I am.
What is this document?
It's a picture of the condemnation notices on the house at 11247 Lakeshore Drive.
And were you provided with this picture at some point in time?
Yeah, this is given in discovery to us.
So in discovery, this lawsuit was produced?
Yes. I think Doug Coleman gave this to us.
And what is the date at the bottom right corner of the picture in red?
It's August 15th of 2022.
Does Exhibit 22 appear to be a true and accurate copy of the original?
Yes, it does.
Your Honor, we ask that Exhibit 22 be admitted into evidence.
Any objection?
No objection, Your Honor.
What date was the property at 11247 Lakeshore Drive condemned?
It was condemned on August 15th.
Give me the date again.
August 15th.
And August 15th is shortly after Ms. Blair sent you that text message saying that she wanted to close on the property, correct?
Yes.
Like a week after?
Oh, yeah, it was less than a week. I think it was. Yeah, it was on that Friday. Yeah, it was a week later.
So shortly after,
yes,
you notified Ms. Blair of your intent to close on the sale of the property.
I think it was the following Monday. To be honest with you, following Monday or Tuesday or whatever it was.
How are you notified that the property was condemned?
We were there, and they told us that it was condemned. They kicked us out. Doug Coleman and the other guy kicked us out.
And Mr. Coleman would be the
zoning police guy,
zoning administrator.
Yeah.
For the Fabius Township?
Yes.
And were you told the reason why the property was condemned?
Yeah, they said that there was some loose bottle jacks underneath where the door slid.
And that would that be loose bottle jacks under the foundation of the property?
Yeah, somewhere. Yeah, in the corner down there.
So before August of 2022, did you have any idea that there was some loose bottle jacks under the
No.
property? Did you have anything to do with the condition that led to the property being condemned?
Absolutely not.
Okay. Suffice it to say that you didn't put those bottle jacks underneath
No,
there?
I did not.
And before the property was condemned, were you aware that there was any structural issues with the house?
No.
Were you forced to leave the home after it was condemned?
Yes.
Who forced you to leave the property?
The sheriff, Doug Coleman, and the other guy that was over there. There's 4 people out there that day.
Okay. Would that be Mr. Wiki, who is the building inspector?
Yes, yes. Doug Coleman, the sheriff, and then there's some contractor kid out there.
And was Ms. Bowers forced to leave the property?
Yes, she was. She was in bed.
And were your children forced to leave the home?
Yes.
And who specifically told you had to leave the home?
Doug Coleman.
Okay. How'd that make you feel?
This is one of the worst days of my life. I mean, it was horrible. I mean, I couldn't believe it. And then she was sleeping and she couldn't believe it either. And then
So let's just break that. When you say she, Ms. Bowers?
yes, Carla was, she was sleeping still. And then they broke out this red sticker in front of me. I couldn't believe it. I mean, the guy got there, he just climbs under the house and he's like, oh, there's this thing over there. Nobody knew. No one even went under that house. And then he comes out and I knew it was Rosemary the whole time. I mean, nobody else knew that house.
Objection.
And
He doesn't know what
Just a minute.
Miss Blair
Just a
knows.
minute, just a minute. It doesn't carry any evidentiary weight, but he suspected her. I'm aware of some other things. Somewhere in between these dates was some sort of conflict between him and Mr. Verpalat, and a PPO was issued somewhere between August 5th and August 15th. I'm not sure how that plays into this, but I don't know what you know, but you felt that Miss Blair had something to do with this. Is that correct?
yes.
All right.
Did you feel that Ms. Blair was the one that reported her property to be condemned?
Yes, I know she did.
And again, your kids were in the property when this occurred, correct?
They weren't there at that moment. They were on their way there. Yeah, and they had to leave, but move all their stuff out.
That's 5 children? Okay. Did that impact your relationship with your children?
Oh, yeah.
How so?
Well, they had to go back to their mom's house and I explained to her, I just had to explain to everybody, no one believes you when something like this happens to you. And I had plans with my kids to teach them how to go, be in the water, to swim. Grant's just learning how to swim now. I mean, I had plans the whole summer. My family was coming up to visit me. Carla's family was coming into town. I mean,
Were you going to enroll them in 3 or schools?
no, I hadn't decided with my sons. I don't have a choice with Joey. His mother has him in Notre Dame Elementary School in Long Beach, Indiana. So he'll stay there. And then I believe Grant will be going there too. The other kids may have been going to Three Rivers. We hadn't put them in school yet. We didn't. And we were just moving in. We had gotten them yet, Your Honor.
Okay.
And you had to have the difficult conversation with your, almost, let me strike that. August is the prime of summer, right?
Yes.
Okay, so it was not the most ideal time to be evicted from your house, wrongfully evicted. And you had to have the difficult conversation with your children, trying to explain why you got drug up and kicked out of your property, right?
Oh, yeah, yes. After, they witnessed, Mr. Verplock, coming and screaming obscenities under our property and screaming at me. And this all led up to this, and then this happens a week later. It's no coincidence these guys are, you know what I mean? And then I have to explain that to my kids and their friends who came up. The girls had 2 of their friends from Buffalo up with them. And they were in the water playing when that Verplock came over screaming at me from the fence, from that fish guy's fence line. And then that weekend, Rosemary must have gotten in touch with him because then they had my house condemned the next week. And I had my hearing with Mark Verplock that Thursday in front of Judge Milton here. And I couldn't go to that because I was thrown out of my house.
I don't know what Mr. Verpalath has to do with the damages in this matter.
Probably not in this case, but at any rate, it's clear that sometime between when you said we're ready to close and this date, and for my part, I was involved in the zoning component of this, and much of this had already happened before I was even aware of it. For any part I had in it, I'm embarrassed. But you're right, Mr. Soltis. It doesn't have anything to do with damages.
We can move on, Your Honor.
All right.
So suffice it to say, Mr. O'Donnell, this was a stressful time in your life.
Oh, it still is. I mean, this is still going on. I mean, we can't fully get back into the house yet because we have neighbors blocking. I mean, yes.
Right. But August was not the most ideal month of your
No,
life, correct?
not at all. No, it's horrible.
Where did you go after the property was condemned?
I had nowhere to go. I mean, I just went and stayed with my buddy in Traverse City for a few days. I didn't have a place in Buffalo. All my places were rented at that time, and my other place wasn't habitable yet. And
So you're kind of thrown out in the street.
I was couch surfing, to be honest with you, pretty much.
It's a little bit different than living in a 5-bedroom house on Quarry Lake.
Objection.
Oh, yes, it is.
Is couch surfing different than living in a 5-bedroom house on Quarry Lake?
It was a horrible experience. I had to go back to some way I lived 30 years before that. You know, it was like high school.
Where did your children go after the property was condemned?
They had to go back to their mom's house.
They didn't get to spend the rest of the summer at Quarry Lake?
No.
They haven't been able to spend summers back there since, have they?
No.
What did you do with all your personal belongings that were in the house after you were kicked out from the condemnation?
Some of them stayed there and some were moved. I mean, some we had to move, some we were too big to move, and we didn't have time to get some of the stuff out of there. We had to leave it. They told us to get out of there. It was a danger and it was going to fall down and, you know, and then that night when we initially did it, then someone said that we could come in there and get our stuff out. So we were like, okay. They said, you know, we couldn't spend the night there. And then we came back and no, they kicked us out. The cops kept on coming back and Rosemary called them probably 15 times that night on us.
Objection.
Maybe 20.
Unless no foundation that he knows what happened and did Miss Blair do anything. He can't just say, oh, by the way, she did this.
Fair enough. Some of this was in evidence in the zoning case, but they did go back to try to get stuff and got removed once again. Again, it doesn't go to damages, but it goes to what happened in their life.
So in addition to your own personal life, in addition to your children's life, did being kicked out of the property affect your relationship with Ms. Bowers?
Yes.
Explain that to me.
Well, this is our dream house. We got this together. This is kind of like our marriage. Like we came into this together. We both went in half on everything. You know what I mean? And like, we were kind of proud of ourselves. You know, we had this beautiful house and everything. And then this all happened. And this was so unexpected and such a surprise. She didn't believe me. I didn't believe, you know, I didn't know what was going on. We had no clue. I didn't trust myself anymore. And like, she had to go back and she was freaking out. We were both, I mean, we didn't know what to do. You can't ever expect something that was ever going to happen to you.
So after this event happened, is it fair to say that there was some trust issues between you and Ms. Bowers?
Of course, yes.
And again, I'm not sure that we need to get into this to determine the money, but it affected his relationship. I understand she went back to somewhere and he went somewhere else.
You know, to tie up this chapter, did you feel pretty depressed?
Yes, I was.
Okay. Well, Your Honor, he keeps doing this and I keep objecting. It doesn't have anything to do with damages. You know, I'd ask the court to ask him to move on.
I think, yeah.
I think,
but it's part of the whole picture. This is just as he described. He's living there. He's ready to close the deal. It's summer. The sun is shining. He's got a boat in the water. And the zoning police show up and summarily remove him from the house without any warning or notice. So yeah, I guess I'd be depressed too.
And Judge, I mean, it goes directly to our claim for specific performance, which is equitable relief. I want to paint the picture. This wasn't just, you know, we made an oopsie event. This completely changed the dynamic of Carla and Joe's life. So I feel like he has the opportunity to explain. I mean,
I understand all these dynamics. That the damage judge may not have all the background in this case that I do, but he'll or she will learn soon enough. So I think you made your point. But so we'll go ahead and get to your next exhibit.
I'll move on. All right, Mr. O'Donnell, I want to direct you to what's marked for purpose identification as Exhibit 23.
Oh, before we leave that, my recollection was, I guess that'll go to damages. You had some other things, boat toys at the house, like a wave runner or that sort of thing.
Snowmobile, snowblower, all that, float mat, all that stuff was in the garage, was taken out of the garage.
So I guess that goes to damages, but you also lost a wave runner, a snowmobile.
There wasn't no wave runner. It was just a snowmobile a snow blower, I believe 2 ladders, there was,
Here, let me just, if I could, John, I can clean this up real quickly.
I guess I don't need to get into that. I thought there was another watercraft. Anyway, that'll.
Yeah, we hit the big ticket items, but I think the rest of the personal property will save for.
All right.
Statutory conversion claims. Sorry, I didn't mean to interrupt the court. Did you have
That's
any
fine.
questions? Mr. O'Donnell, if you could turn to exhibit 23, please.
I'm sorry.
23.
Thank you.
And have you seen this document before?
Yes, I have.
And are you familiar with this document?
Yes, I am.
What is this document?
It's a letter from Rosemary's attorney to us.
And does this document, and this document is addressed to you, correct?
Yes, me and Ms. Bowers.
And does this document appear to be a true and accurate copy of the original?
Yes.
Your Honor, we would ask that exhibit 23 be admitted into evidence.
Yes, it may. Now, this is not to the address at Quarry Lake. This is to an address in New Buffalo.
Yes.
Whose address is that?
That's my rental unit.
Yeah, it's on the tip of my tongue. This letter is dated September 9th of 2022, correct, Mr. O'Donnell?
Yes.
And that's approximately how long after the property was condemned?
About a month.
About a month, okay. And this letter is from an attorney named Robert Yonkers.
Yes.
Have you ever spoken with Mr. Yonkers?
No.
Okay. And this letter was sent to your address at 22 North Barton Street in New Buffalo, Michigan, correct?
Yes.
And under Exhibit 18, which is the lease with option to purchase, do you recall the address where written notices were required to be sent?
Yeah, it was 11247 Lakeshore Drive, 3 Rivers, Michigan.
So this purported termination of the lease with option purchase was not sent to the correct address.
No, it was not.
22 North Barton. Were you even living there at that time?
No.
Is that one of your rental properties?
Yes, it is.
So not only was it not sent to the right address, it wasn't even sent to an address that you resided at. Is that correct?
Yes.
The subject line of the letter references lease with option to purchase for 11247 Lakeshore Drive. Do you see that?
Yes.
And in the first sentence, Mr. Yonkers' letter states, Rosemary Blair has asked us to contact you regarding the above referenced lease with option to purchase. Do you see that?
Yes.
Okay. So that indicates that Ms. Blair had a conversation with Mr. Yonkers about the condemnation.
Yes.
Correct? And the next line, Attorney Yonkers' letter states, Rosemary Blair informs us that the property has been condemned by the city of Three Rivers. Correct?
Yes.
No, that's not technically correct, is it?
No, it was condemned by the Fabius Township.
Fabius Township, okay. But regardless, that shows that Ms. Blair had a conversation with Mr. Yonkers about the condemnation, correct?
Yes.
Okay. And again, did you have anything to do with the conditions that led to the condemnation?
Absolutely not.
The next line in Mr. Yonkers' letter states, this is to advise you that Ms. Blair is exercising her option pursuant to the term of the agreement to terminate the lease. This is 20 days notice pursuant to the destruction or condemnation of the premises clause on page 2. Do you see that?
Yes.
Okay. And is your understanding that the destruction or condemnation of the premises clause on page 2 is referring to Exhibit 18, which is the lease was not going to purchase?
Yes.
And if you actually go back to Exhibit 18, page 2, there's a section titled Destruction or Condemnation of Premises, correct?
Yes.
So it appears that Ms. Blair is trying to use her own self-inflicted condemnation of the property to terminate
Yes.
your lease with
I'm
option to
going to
purchase.
object, Your Honor. There's no testimony that this is self-inflicted. This was done by Fabius Township, and if the township representatives, Doug Coolman and Joe Wicki were to testify, Your Honor, they would say that the reason.
Objection, Your Honor. I'm not going to allow Mr.
Well,
Sotis
my
to
recollection of the testimony from the zoning hearing, I looked at my notes earlier, preparing of this, was that Miss Blair reported it. I don't remember exactly what the testimony was, but he is pointing out the obvious. I'm not sure what they would testify to, but clearly the tenant did not report this. There was I have pictures in the file, which I could bring up. Apparently at some point there was a storm that summer, a tree fell, and there was about $50 worth of damage to the deck. Someone, my recollection was, he said it was Ms. Blair, called for the inspection. But Ms. Blair is using the condemnation through the letter, so that is clear. Self-inflicted, I'm not sure, but it certainly wasn't inflicted by Ms. Bowers or Mr. O'Donnell. The landlord caused the inspection to occur. So we'll just leave it at that.
Thank you, Your Honor.
Mr. O'Donnell, prior to this letter, had Ms. Blair ever expressed to you that she wanted to terminate your option to purchase the property?
No, she had not.
Prior to this letter, has Ms. Blair expressed to you that you were in default of the lease with option to purchase?
No, she had not.
Prior to this letter, had Ms. Blair expressed to you that she wanted to terminate your lease of the property?
No, she had not.
Were you shocked when you read Mr. Yonker's letter?
Oh, yes, I was.
And as of September 9th of 2022, were you still intending to purchase the property from Ms. Blair?
Yes.
And at that time, were you working on securing financing to purchase the property?
Yes.
And at that time, did you have the financial capability to secure a loan for the remainder of the purchase price?
Yes.
All right, we're rounding home base here. So after the property was condemned, did you return to 11247 Lakeshore Drive and try to get back into the house at some point?
Yes.
And approximately when was that?
October of 2022.
End of October, beginning of October?
End of October.
Yeah. And do you recall the actual date that you returned?
On the 15th, I believe it was.
Okay, so middle of October.
Yes, middle of October.
Okay. And as of around October 15th, had you been served with a lawsuit seeking to evict you from the property?
No, I had not.
As of the middle of October, have you been served with a judgment or order from the court evicting you from the property?
No, I had not.
As of the middle of October 2022, had you been served with a writ of restitution from the court?
No.
And around October of 2022, were the locks changed on the house?
Yes, they were.
Okay. And then did the change of those locks prevent you from accessing the interior of the house?
Yes, they did.
Okay. And as of October 14th or middle of October, did Ms. Blair ever provide you with a key or unlocking device to access the home after the locks were changed?
No, she did not.
Okay. And in fact, before this court entered an order allowing you to go back and stay at the property, had Ms. Blair ever provided you with a key or unlocking device to access the property?
No, she did not.
All right, I want to direct you to Exhibit 24. Are you familiar with this document?
Yes.
Okay. What is this document?
This is a thing that we got through discovery, but it's when Rosemary had all the different locksmiths come out and change the locks.
And who provides you with this document?
Rosemary's discovery.
And Ms. Blair produced this document. Yes. Are you familiar with Rosemary Blair's handwriting?
Yes, I am.
Whose handwriting is that in Exhibit 24?
Rosemary's.
All right, I want to direct you to the top of the document where it states, first lock change 10/14 of 2022. You see that?
Yes.
Is that around the same date that you visited the house and the locks have been changed?
Yes.
Okay. And did you attempted to access the property when you were locked out?
Yeah, I did access the property. That's when I discovered that the snowmobile had been stolen the first time. And I called the state trooper that night. I believe that was the night I called the state trooper the first time I found out I was locked up.
Well, let's go to the next line down. It says second lock change November 11th of 2022. Do you see that?
Oh, yeah. Yep.
Did you go back to the property around that time?
Yeah, I did again. I went back I think I went about the same time every couple of weeks. So yeah, I went back on the 15th or 14th, I believe, of that month too.
And did you attempt to gain access to the property at that point in time in November?
Yes, I did.
Okay. And would that have
That's
been,
actually the event that I met the state trooper that night. And that's when I discovered that was actually the November.
all right, let's break that down. So in November, did you meet the state trooper out at 11247 Metro
Yes.
Drive?
Yes.
And was that to try to gain access to the property?
Yes, and to report the theft of the snowmobile.
And how did you gain access to the property in November of 2022?
I just drilled the keyhole out.
And was the state police officer present when you drilled out the locks?
Yes.
Did he try to prevent you?
No.
Did
He was there when I put another padlock up there when I left to re-secure the door to make sure, because there's still a lot of stuff in there before they took the rest of the stuff out of there.
Did you show him the lease with the option of purchase at that time?
Yes. And Carla came up that night too, to verify, because she was trying to get us put in jail that night. She was calling that guy, telling him to arrest us, and she called like 3 different departments to have us arrested.
So when you were,
Your Honor, Carla has no connection, I don't think, to damages. I don't even know who she is.
well, that's
Carla is Miss
Carla
Bowers. She's a tenant. She's under the lease. She's a party to the lawsuit.
Oh, Miss Bowers.
Yes.
Okay. I'm sorry, I didn't quite catch who he was talking about.
Okay.
And the police are present when you drill out the locks, correct?
Yes.
Okay. They didn't stop you?
No.
I want to direct you to the bottom where it says Joe's total bill is $214. Do you see that?
Yes.
Okay, so next to the first lock change says $107, correct?
Yes.
Next to the second lock change says $107, correct?
Yes.
And then that equals $214. Is that correct?
Yes.
So Miss Blair, it appears that she's attempting to
Bill me to
charge
me out.
you to when she locked you out of the house.
Objection, Your Honor.
It says Joe's total bill.
Yes.
This is not an attempt to charge him.
It says
But-
Joe's total bill.
Well, it just says what it says. I'm not sure what it means, but
I
she
don't know.
didn't.
So does it appear that Miss Blair was intending to charge you for locking you
Oh,
out of your own
yes.
house?
Yes. 100%.
She ever send you a bill?
No, but should we stop other stuff when she was talking to her attorney and everything?
All right. So it says what it says, but he never got billed for it.
No further questions this time. We pass the witness, Your Honor.
All right. We've been at it for about 35 minutes. I guess that's all right. Are you ready to continue?
Yeah, let's go. That's
Mr.
fine.
Soltis, you ready to go?
Ready to go?
Is cross-examination. You're still under oath. He is allowed to ask leading questions. He had plenty of them in direct, but he's allowed to ask them in cross. Just answer the questions the best you can. You're still under oath.
Mr. O'Donnell, if you turn to Exhibit 1 in the book.
I'm there.
Okay. Would you agree with me
Just a
that?
minute. This reminds me, I did not admit Exhibit 24.
Oh, I'm sorry, Your Honor.
That is admitted. I'm sorry, Mr. Soltis.
Thank you. In this document, there's no amount for the lease payment per month, is there? Of any nature?
No, this is a temporary thing. She just wrote in her car real quick, so we'd have proof to go in the house and get utilities, do whatever.
Okay, no down payment mentioned in there?
No,
No closing date?
no, this is just a lease.
Okay, but how long, is there a lease term?
No, we knew that we were coming up with the
Okay,
official. lease.
Just a
She did
minute,
this temporary.
Sure,
just
answer my
a minute,
question,
yeah.
if you would, please.
Don't argue with him.
Oh, sorry. No,
The question can be answered yes or no. If he wants further explanation, he'll do that. This is a different kind of examination. This is from opposing counsel. He's gonna ask you straightforward questions and try to give straightforward answers. Don't explain unless you're asked to. If you need to explain, Mr. Hatch can come back on redirect.
And it doesn't say when the option is to be, when the purchase is going to be optioned or the option is going to be taken care of. Now, you said you had a verbal agreement back in 2020?
Yes.
Okay. And that was never reduced to writing?
No. I mean, yeah, no.
Okay, thank you. Now, turning to the actual lease option. Is exhibit
18.
Yeah, you probably know that better than I do. Now, this is a rocketlawyer.com document. Did you access rocketlawyer.com to obtain a copy of this?
Yes.
Okay, so you're the one who got this agreement.
Yes.
Okay. And you filled in the parts of the document that were probably empty.
We went over it together. She was on the phone with me the whole time. We were sending pictures back and forth.
She was on the phone, but you were right at the computer with the document? Is that how it went?
Initially, then we just brought it over to her house to review it.
So you prepared this document, in other words?
Yes.
Okay. Have a lawyer look at it?
No.
Okay. Now, the document provides that you have certain obligations. And I address your attention to page 2, maintenance, which is in bold, and below that, taxes. Okay.
I see it.
You
Yes.
see it? Okay, thank you. And have you ever paid taxes on this property?
Yes, I have.
When?
I believe it was 2021.
Did you pay?
I paid the property taxes, $5,000.
2021?
I believe so. I don't know if they were 2020 taxes or 2021 taxes. I'm not sure.
2022 taxes? Have they been paid?
No, we were kicked out.
2023 taxes?
Still kicked out.
Well, you've been back into this house a number of times, but when did you come back permanently? When was that?
I don't understand the question. I'm sorry.
Well, you've been living in the house since when?
I still don't. What do you mean? What are you talking about?
Well, after my order that said you could go back in, when did you go back into the house?
We're not really back in yet. All the pipes were busted, so we've been working on the house for 2 weeks, and then we had to go put it needs a new furnace. It needs a new. I mean,
the pipes froze.
Oh yeah, all of them were. The furnace was out. She didn't have the furnace on. The cap was off the furnace. The furnace was toast. We got in there. She left the place. It was destroyed.
So I wasn't aware of this. So the pipes froze, then they thawed out. So did the house flood?
No, it did not, luckily. And there was some water damage, but it was mostly contained in the bathroom walls. We had to knock out 2 of the bathroom walls. We fixed the cracked pipes in the walls, and then we had to fix under the tub. And I think there's 15 different breaks in the basement and the crawl space under the house. Almost every elbow, but either blew off or cracked. It was a big mess. I mean, my guys were down there for 2-3 days, almost full time.
So the bottom line is, after Judge Middleton said you could go back into the house, you haven't.
It's not habitable yet.
Oh, that doesn't answer my question. You haven't lived back in the house.
I'm sorry. I don't understand your question though. How we can't live there? I mean, how can we go back in if we can't live there?
Well, you can say, I don't live there. I
That's
haven't
what I
lived
tried
there.
saying. That's what I said. We don't live there.
Okay.
I thought I said that.
Where do your kids go to school?
Joey O goes to Notre Dame Elementary in Long Beach, Indiana.
With his mother.
Yes, Grant goes to Christian, and he's in kindergarten at Christian in LaPorte, Indiana. And Joey Bowers is at New Buffalo Elementary School, or he's at the middle school. And Kenna's going to be at the middle school next year. Laney's at the elementary school. And like I said, Grant's at the report.
Okay. In other words, your kids are going to the New Buffalo schools by and large, not all of them, but some.
Mine are going to Indiana schools. Her three are going to go.
Oh,
to
Miss
Buffalo.
Bowers is going to Buffalo. And where are you living at these days?
Right now, I'm at 28 North Barton Street, New Buffalo.
Okay. Are you renting or do you own that place?
I own it.
Okay. Is this one that you were going to fix up and sell?
No,
No, you just planned on,
I just rent. I don't sell. I don't sell my own property.
okay. So you're living there now. Okay. Now, one of the portions of the lease option provide that, and I'll give you the exact place. Page 4. Towards the top of the page, option to purchase.
Mhm.
No, never mind, that's the wrong one. Oh, option consideration. Go down a little bit. Can you find that?
Yes.
And am I correct in reading it says non-refundable option consideration in the amount of $5,000 paid by the tenant as consideration for this option to purchase agreement? Am I good so far?
Yes.
Shall be credited to the purchase price at closing if the tenant timely exercises the option to purchase.
Yes.
If the tenant doesn't exercise the option to purchase, the tenant shall forfeit the non-refundable option consideration. Is that part of the money that you have given Ms. Blair?
No, I don't think so. Yeah. 5,000 is confusing. I'm not sure where that one comes in. Yeah, that was just, if she just got kept $5,000, but didn't terminate the contract, right?
But have you given her that money?
The $5,000?
Yes.
Yes, that's part of the.
So it's part of that money that we see on that blackboard or that whiteboard?
I'm not sure.
Well, why not? Why aren't you sure, sir?
I can't tell you. I'm not positive about that. I think. Yeah, it should be. Yeah, it is.
Okay, can you point out where it was given?
It would have just been included into the funds. I mean, we probably just wrote this into the contract. It's $5,000 towards the end of the contract. You know what I mean? Like we just assumed this. This was no money was never really paid. It was just in the amount of money that came to her through deposits and everything else. And we just wrote that number down. So it'd be fair if something happened. She'd have $5,000 at the end. So it would be fair.
Okay.
That's what I believe. I mean, that's the fairness thing. I mean, that was.
Well, if you don't close the option here, she should keep that $5,000, correct?
Yes.
Okay, thank you. Now, you have a habit, it's a good habit, I think, of taking pictures of the cash that you gave Miss Blair.
When it was available, yes.
I mean, we've got pictures here and so forth, and your counsel has asked you to put green dots in there.
You can't break cameras out at the casino, though.
Well, what if you say that you gave money on January 31st?
Yeah.
14,500 cash.
Yes.
Exhibit 12.
Yes.
Can you turn to Exhibit 12?
You got it?
Yes. It's 2 pages. Oh, it's exhibit 12, sorry. Exhibit 12, did you say?
Yes.
Yes.
What it says up on this screen here. Exhibit 12. I'm looking at exhibit 12, which appears to be a screenshot of a text conversation. Am I?
Yes.
Okay. Anywhere in there that says you giving her $14,500?
No, it says right there, the 14,000, and we gave her 14,500. I wrote it down wrong. I was texting her. I mean, it's a pretty common mistake.
Oh, so that's a mistake.
Not a mistake. I mean, yeah, or a omission, one of the two. I'm not sure. I mean, I paid her 14,500. I mean, I have the proof of the payment.
What, you got a picture of that?
I have something with the cash on there. I took the cash out from my account. Yeah.
Well,
I don't know where it's at.
in your summary, there's a blank for the exhibits.
Oh, okay.
So there is no exhibit indicating that you did in fact give Miss Blair $14,500 on January 31st, 2022.
Objection, Your Honor, mischaracterizes the testimony. He verbally testified after the
Yes,
text
but
message.
I guess there's no photograph of a receipt or the cash, that 14 or 14.5 that you gave Miss Blair. And that says January 31st. You don't have a photograph of that. Now, did you give it to her inside the casino?
No, this cash I gave to her at her house.
Okay, but you don't have a photo of that?
No. You know why? This time we were both wearing masks when I came into her house. I couldn't even bring a camera. I met her at her front door to pay her on this time. And this is when she had the contract.
Okay, you're not asked a question.
Oh, no, I was just sorry, I was talking out of my head.
Okay.
Just because there may have been COVID doesn't mean you couldn't have brought your camera along and taken a picture of the money. You could have done that, couldn't you, sir? If you gave Miss Blair $14,500 on January 31st, 1922, or 2022, excuse me, there would have nothing that would have prevented you from putting that cash somewhere and taking a picture of it.
Yes, it
Objection,
would.
Your Honor, Forum Foundation calls for speculation.
He can answer that.
I was in the hospital the next day. That's how sick I was. When I said I was sick here, I went and got a COVID test before I came over. I was ready to throw up on myself that day when I showed up with that money to pay her. I walked in her door.
Again, that didn't answer the question. You could have taken a picture if you'd had the presence of mind or made the
Yeah, I
extra
wasn't
effort to
sick
do
yet.
that.
Okay, so you didn't.
No.
Okay. Now turn to Exhibit 13. Okay, is that a group of text messages?
Yes.
And the top date is March 9th, 2022?
Yes.
Any indication that there was $2,000 cash given to Miss Blair on March 9th, 10th, or 11th?
No.
Any photos of that? Did you ever take a photo?
No, I was at the casino.
Okay. You could have taken a picture before you went into the casino if you were.
I have things with the money taken out of the bank. I have receipts from the ATMs to the bank.
Again, that didn't answer the question.
I didn't know what he meant.
All right.
No, I did not. I did not. No, we were at the casino. You can't break out phones in the casino.
Right, but my question was, before you walked into the casino, knowing that you were going to give Miss Blair $2,000, you could have sat in your car and taken a picture of the money. Could you not have?
Objection, Our Forum Foundation calls for speculation.
He can answer the question. Don't fight it, just answer.
I mean, I
You
suppose, yeah, I
have.
could have, yeah. I mean,
Yeah,
yes.
all right, that's all he's
Okay.
getting.
Then let's turn to Exhibit 14. I think that's also a group of text messages. The top one is April 12th, sorry, of 2022. You are claiming that you gave Miss Blair $2,000 on April 12th, and that you basically backed that up by referring to exhibit number 14. Exhibit 14 doesn't have any indication of any money being given, correct?
Correct. Yes.
Okay, I'm sorry. You may have to speak up.
Sorry, I'm sitting back.
That's okay. And once again, you didn't take a picture of it.
of the money?
Not the cash, no.
Okay. Turning to exhibit number 15. Let's see, that's also seems to be a text messages.
Objection, Your Honor, this exhibit's not admitted into evidence and.
Well, he can still ask him about it.
Well, it's
I was no part of this one.
It's beyond the scope of direct, Your Honor. We skipped this one. This is going to be for Ms. Bowers to testify.
So there's no issue with beyond the scope of direct. He can examine as to anything. But at least the text messages, is this? Oh, this is Carla. So yeah, it's not you. I got it.
Okay. Okay,
Let me clear up the objection. Lack of personal knowledge, lack of foundation.
Okay.
fair enough, Your Honor. I'll withdraw that. Okay, turn to exhibit 16 then.
Yeah.
Which is on the board there. As you gave Ms. Ms. Blair money on June 9th of $2,000 cash, and you use exhibit 16 as a reference for that? That's on the board there, isn't it?
What's that? I was looking at this. What are you talking about? I'm sorry, you lost me there. Where were we at? Can you repeat that?
If you look at the board,
Can you repeat the question? I tried, you lost me.
Okay, slow down. I'm not trying to
Okay. I'm
do
just
anything
asking
but
you to
ask
repeat
you
the question.
questions. You look at the board there and you got exhibit 16, right?
Yep.
You got a green dot,
That's it, dude.
and that green dot is supposed to represent you giving Miss Blair $2,000 cash on June 9th.
Which I did.
Well, take a look at exhibit 16 again. Any mention of money there?
Desperate for cash. Need cash now.
Does that say $2,000?
Oh, no, it doesn't say 2,000. There's mention of money though, cash.
Oh, okay. Does it mention that you gave her money?
It says thanks.
Okay. And did you take a picture?
No.
Okay. So there's quite a few of these that you never took a picture of, and there's nothing in the exhibits to indicate that you gave that money to Miss Blair, but you want the judge to count it, don't you?
Objection, Your Honor, assumes facts not in evidence that.
Well, he can just answer yes, even though you didn't take a picture of it. You want me to consider that as money paid. Is that true?
Yes, of course.
Okay. Now, at some point in time, and I'll ask you to focus on November 15th, 2021, where you say you gave Miss Blair $14,400.
Yes.
Did you ask for some of that money to go back to her?
What do you mean?
Get returned. Did you ask money to go back to you?
Oh, you said go back to her.
Oh, I'm sorry, go back. I apologize. In other words, out of that 14,000, did any money go back to you?
No.
Was it another time when money came back to you from money that you gave to Miss Blair?
Money never came back to me.
Oh, so every time you gave her some money, she kept it?
Yes.
Okay.
Do you have a checking account, sir?
Yes,
And you were giving Ms. Blair, according to your testimony, significant amounts of money at various times. Why didn't you use the checkbook?
she wouldn't take checks to her bank. She would not use the bank system. She made that very clear to Carla. Then.
Well, you would agree with me that a canceled check would have been the best evidence you could possibly get.
Not better than a picture.
Outside of a picture.
Yeah.
When you did take the
Yeah,
pictures.
yeah.
Okay. Now, when you say you were ready to purchase, were you working with a bank or a credit union?
Yes.
What was the name of the bank or credit union?
I think it was First American Heritage.
And where are they located?
I think that branch is out of like California or something like that.
Do they have a local office?
No.
Okay. Did you apply for a loan?
Yes, and Carla applied too as well.
Okay. Did you separate loans or both of you combined?
I never finished my application process. I was in the beginning of my application process, but I didn't follow through with my final application because I didn't want to get the ding on my credit yet. But I had everything lined up just to that point.
Okay, so you never made the application.
Well, I made an application. I didn't fill through with it. I mean, I can show you the stuff. Yes, I don't know how to answer that. Yes, I talked to the guy. I was in time with him. He got all my information. We were back and forth on everything. He wanted to get the hard run of my numbers and everything. I waited up because Carla was going to go through with her stuff. And then I was waiting on her to see who would get a better deal. We thought Carla would get the better deal. So we're going to go with her.
So you didn't then sign documents that says, I will pay First American Heritage whatever amounts of money they give me for a mortgage?
Not yet, no.
Not yet?
Well, we didn't have the opportunity to get the mortgage. She wouldn't sell us the house. How do we get the mortgage if we don't have the house to buy?
You said you were ready.
We were.
Well, ready means you have, approval from a bank or a credit union.
Objection to form, Your Honor. I don't know if that's a question or if it's testimony. It also makes.
Well, he didn't have the cash in hand, but his testimony was he had started the process and he certainly had time to complete it before all things went sideways.
Carla had done it. She'd done like the actual app. We didn't both have to get a.
All right. So you and Carla were working on financing for the purchase.
Yes.
But had not completed it or got a confirmation.
Is that true, what the judge said?
I had not gotten a confirmation. I believe Carla did.
Okay. And how much were you asking for the loan? Or what you would have been at, or miss?
It was like 355 or something, or what was it? I forget what the balance was, or the 335 or whatever it was for the balance. I believe it's 330. I gotta look somewhere to find out. I don't have it offhand. 335 or something.
Okay.
What's 112 minus 450?
Okay, we can do the math. And what, is there an interest rate that you were given, or?
I
didn't
believe
get
you
that
have to ask
far?
Carl about that. I don't remember what that was.
Okay. And you never got approval for the loan, did you, from the?
Carla did.
I understand that, but my question is, did you?
No, I said that.
Okay, thank you. Now, when the folks from Fabius Township came out, and I'm going to refer you to your counsel's exhibit. I'll find it so that we're all on the same page. Number 23. Is it 22? Thank you. You got it?
Yes.
Okay. You see the red placard,
Yes.
and you can read it. It's condemned, dangerous, keep out, so forth. Was that placed on your house? On the house at
Yes, it
Lakeshore
was.
Drive? Okay. Did you see that?
at any time?
Yes,
Okay. Did you take that condemnation notice in red off?
no,
No? Did anyone, did Ms. Bowers or somebody else do it on your behalf?
I didn't witness anybody do it, no.
But
It did get removed. It's not one of them did, the one off the front, but not the one off the side.
Okay, one of them got removed. And you don't know who removed it? Okay. And you notice that the green notice of violation is a couple days later, I think August 15th. Am I reading that correctly, you think?
Yes.
Okay. And
Objection, Your Honor, mischaracterizes the testimony. Or excuse me, mischaracterizes the exhibit. I think that date is 8/15 for both of them.
I believe it is too.
And also, I'm trying to give opposing counsel some leeway here. I don't see any relevance about whether these notices were taken off, what that has to do with specific performance. So I'd like maybe some clarification about where we're going with this line of questioning.
well, counsel brought it up about how these things were so stressful and horrible and so forth. And I wanted to get into that a little bit because obviously one of the red placards was removed. And I want to know if he knows why there is a green placard after that.
I don't see.
I believe they're both the same date.
I don't see a logical connection between the stress of being.
No, he
kicked out
can
of the
ask.
property.
You went down that path. I'll let him wander down it a little bit himself. It's not gonna help me any, but it might make you feel better, so go ahead.
Was there a question? I'm not.
I'll withdraw my objection.
Thank you. Now, you indicated that you went back into the house even though the locks had been changed,
Yes,
okay? And the exhibit that your counsel provided was exhibit 24 that indicated that on October 14th, Mr. Fish had changed the locks. Is that, you think I read that right?
yes,
And you testified to your counsel that you got in there on October 15th, the next day.
I believe so, yes.
Well, you drilled the lock or did you bust a window? How did you get in?
Oh, to get in the garage? I just
Well-
drilled through the lock.
Okay. Did anybody give you permission?
I have my house.
I see. So the answer is nobody gave you permission.
I don't need permission. Oh, yeah, no one gave me permission, sorry.
Thank you. And the locks were changed another time. Did you go back in after that?
Yes, it did.
Okay. Anybody give you permission?
Myself.
Okay, fair enough. In other words, you kept breaking in and the locks kept
I
changing.
kept going into my house.
You didn't need anybody's permission. You were there under color of lease. The lease had not been terminated by a court order, by me, or by a writ of eviction. There was a pretext of a condemnation, and the condemnation had been lifted. So at the point the condemnation was lifted, you had the availability to go back into your house. The actions of the defendant very clearly violated the landlord-tenant lockout law, which we had made a finding. It's also part of the default. So don't go down the path. You had every right to go into the house on those dates under the color of your lease option to purchase. And you didn't need permission to go in there.
Well, one of the questions I think the judge asked, and I'll ask it as well, is do you ever receive a bill from Miss Blair for the changing of the locks? Okay. And that was maybe 8 months ago, at least. Okay, thank you kindly. Nothing further, Your Honor.
All right. This is,
Sorry, brief
all right,
redirect.
you got 5 minutes. I've got to do that criminal matter at 2:30.
Okay. Is it a good time to break down? and
Let's
maybe
break.
redirect
Everyone use the
afterward?
restroom. I'll get the jail lined up and the public defender lined up, and we'll take care of that matter.
Thank you.
All right, thank you. You're good to go.
Okay.
All right. Well, you can ask. We'll see whether.
I just didn't know who I'm answering. Like, if you asked me, like, did you pay it? I'm like, no, I didn't pay it.
The beautiful part of my job is that I don't have to answer questions.
Okay, yeah, no, I didn't know if I forget. It's
All right,
not-
anyway,
That's-
I wondered whether there was a propane tank that perhaps ran out of propane or.
No.
In filling counsel in, previous counsel were involved in the matter at that time. There was a hearing set in January. And the matter was adjourned as I think Mr. Hauser came in. And then it got adjourned again by stipulation of the parties, I think a couple of times. And then we had I think we had a snow day. One of the days, and then we had a tornado day, but this was supposed to be dealt with right after the first of the year, and for a combination of reasons, it was not. Any further questions for this witness?
Yes, just briefly, Honor.
Mr. Soltis, you had an issue?
Well, my objection, Your Honor.
Which was, which I granted, we don't.
I can move on.
I'm curious, but I don't need to know that for this purpose.
Mr. Soltis went through with you, Mr. O'Donnell, on page 4 of Exhibit 18. There's a section titled Option Consideration. You see that?
Yes.
And that states non-refundable option consideration in the amount of $5,000 paid by the tenant as consideration for this option purchase agreement shall be credited to the purchase price at the closing if the tenant timely exercises the option to purchase. You recall Mr. Soltis asking you some questions about the $5,000?
Yes, I do.
Look on that demonstrative in front of you. What date was the lease with option to purchase?
It's on November 15th.
Okay. Did you make a payment to Ms. Blair?
Yeah, $14,400.
Okay. So was part of that payment the $5,000?
Yes.
For the option?
Yes.
And that states that it shall be credited to the purchase price, correct?
Yes, at the end.
So it's not like it was an addition to the purchase price, so it was going to come off the $450,000.
Yes.
And it says, if the tenant timely exercises the option to purchase, do you see that?
Yes.
So do you recall your testimony when Ms. Blair sent you a text message on or about August 4th stating that she wanted to close on the property?
Yes.
Okay. And then do you remember responding to that text message with confirmation that you intended to close on the property?
Yes.
Okay. And how long did you have to close on the property?
3 months.
Could you have even closed on the property after August 4th?
Objection, speculative, Your Honor. He didn't finish up the application with Heritage, so he doesn't know if they would have approved it or not.
Well, was it your intention to close within those 3 months and?
Oh, yes,
finalize?
it was.
Would you close on a property that you were wrongfully evicted from?
No.
So if someone kicked you out of the house, why would you close within 90 days and pay her more money?
I wouldn't
after
give
she
her
kicked
more money, no.
Okay. So because of Ms. Blair's breach, you didn't have the opportunity to timely close on the option of the house. Is that correct?
Yes.
All right. You remember going through a lot of Mr. Soltis's question about there's no pictures of some cash payments. Remember that? Okay. And one of them was January 31st. That was a larger cash payment of $14,500, correct?
Yes.
Okay. And the rest of the cash payments were $2,000 installments, correct?
Yes.
Okay. Just because you didn't take a picture of the cash that you paid Ms. Blair doesn't mean that you didn't pay her the cash.
Objection, and I think that's this court's decision, not Mr.
Yeah, he
O'Donnell.
he testified that he gave her the money, and he testified that he didn't take a picture of it. And so it goes without saying, just because he didn't give a picture doesn't mean he didn't pay it. So he alluded to other evidence like bank records or something, but none of that is in evidence. But yeah, that's a question that doesn't even need to be answered, because his answer is going to be yes.
You have permission to approach the witness?
Yes.
Mr. O'Donnell, this is
$5 of cash. You see that?
Yes.
I'm not taking a picture of it. Can you pick it up?
Yeah.
Just because I didn't take a picture of that, does that mean that I didn't pay you?
No.
Okay.
I can't keep.
Okay.
There is a picture of it. It's on video HD quality.
Oh, yeah.
But I didn't take a picture of it.
Yes.
And Mr. O'Donnell, on your phone, do you have a picture of $14,500 of cash?
Yes, in my lap.
And is there a way to tell the date that that picture was taken?
Yeah, the photos you take on an iPhone give you a digital tag on them. They tell you the time, location, and date kind of photos.
Could you bring that picture? Can you make that available so that the court and the opposing counsel could see that? So
Yeah.
I sure could. That's right here. Okay. You got our permission to approach?
Yes.
Show this photograph.
Oh, absolutely.
There's my COVID test for it. And there's the cash.
We can all look at.
I'll let the judge take a look first.
Monday, January 31st, 10:30 a.m., low battery. It shows some, looks like hip hop videos of stacks of $100 bill.
That's not how it is, Your Honor.
I think it's closing up on me right now.
Oh, low battery. Let's go like that close.
You asked me why I
Oh,
didn't
I'm
think I
sorry.
could
Oh,
take pictures,
geez,
but
I hate these phones. I don't know how to work them.
Let's go back to it here. Can you go back to that picture?
try it.
Mr. O'Donnell, this picture is large stacks of $100 bills of cash, correct?
Yes.
How much money is in there?
This one is 10,000 in that bundle.
How much is on the bundle on the left?
I believe that is 4,000
4,000 or 5,000?
or 5,000.
Somewhere around there, correct?
Yes.
And what's the date that this picture was taken?
January 31st, 2022 at 10:30 a.m. Let's see what it's taken.
Is that the money that you gave to Ms. Blair on January 31st?
Yes, it is.
I am. There's a couple options here. I don't have a physical copy of the exhibit, so we can either ask the judge to take judicial notice of it, or we can supply a copy afterward. But we would ask that be exhibited, all right, admitted in evidence, Your Honor.
All right, we'll call that exhibit 25.
And I would object to that, Your Honor. We had all the exhibits here and suddenly this one appears out of the blue. It doesn't have any indication of the actual amount, and it doesn't have any indication that it was given to Rosemary Blair.
All right, over the objection, he can email it to you, you can print it and make it part of the file.
Thank you, Your Honor. You were asked some questions about a loan application that you started in August of 2022, correct?
Yes.
And that loan application was for the remainder of the purchase price for the property?
Yes.
That was through First American Heritage, correct? So what was the date that Ms. Blair sent you the text message to close on the property?
August 4th.
And what was the date that you were kicked out of the property?
I think it was August 12th?
Around August 12th?
Yes, I think it was 12th or 15th. I forget what it was.
Does August 15th make?
Yes.
Well, let me refresh your refresh your recollection. You go to exhibit 22.
It's 15th.
Is that a condemnation notice that we went over previously?
Yes.
What's the date on that?
August 15th.
Okay, does that refresh your recollection?
Yes.
Okay. When were you kicked out of the property?
August 15th.
Okay, so August 4th and August 15th. There's not a lot of time to submit and be approved for a loan application during that period of time, is there?
Objection, Your Honor. I don't think this witness has that knowledge as to whether or not a loan could have been finished and approved within that time frame.
Lay a foundation, Your Honor.
We don't need to go dance on that ballroom floor. Obviously, you're not gonna have $338,000 loan in 9 days. So it just speaks for itself. The notice was on August 4th. And that was a Thursday. The zoning citation was August 12th.
That's what I thought, yeah.
So that's one 6 business days.
Mr. O'Donnell, after you were kicked out of the house on August 15th, do you have knowledge that Ms. Bowers applied for a loan to purchase the property?
Yes.
And why did she apply for that?
I'm here to say, Your Honor, Ms. Bowers is here to testify.
No, I'm not offering it for the truth of the matter, sir, Your Honor.
All right, you can answer.
She had to buy another house to live in. She needs somewhere to live.
Did
She bought a house for $469,000.
Do you have personal knowledge that she applied for a loan to purchase a different property?
Yes.
Okay. Because you're dating Ms. Bowers, correct?
Yes.
You guys discuss your personal finances?
Yes.
And that was to buy a home after she was kicked out of 11247 Lakeshore Drive, correct?
Yes.
Do you know whether she was approved for that loan?
She was.
Okay. Did she buy a house with that loan?
She did.
What was the amount of that loan?
$469,000.
So that loan exceeded $350,000, or excuse me, $338,000 that you guys owed under the land contract, or excuse me, under the lease with the option to purchase. I apologize.
Yes.
Okay. At a certain period of time, are you aware that the condemnation was lifted by the court
No, we
for
were
the
never
property?
notified.
Well, but are you aware that at some point in time there
Yes.
was? Okay. After the condemnation was lifted, were you ever informed?
No.
Did Ms. Blair ever tell you you're welcome back in the property?
No.
What did she, instead of welcoming you back in the property, what did Ms. Blair do?
Call the police on us.
At a certain point, did she actually file a lawsuit for eviction of the property
Yes.
for you? And that was a property that she was already in possession of, correct?
Yes.
No further questions, Your Honor.
I may, Your Honor.
Yes.
Mr. O'Donnell, you had to find out that the condemnation was lifted at some point in time.
In court.
Okay, and so the court told you that.
In December. Yeah.
Okay, in December, you knew that the condemnation was lifted.
Yes.
And you could have gone back in there and.
No. He wouldn't let us.
Well, he testified, he tried to go in November and October, and the doors were locked, and she called the state police. So he attempted to go back in after the condemnation was lifted, but was unable to do so.
But if it was lifted in December, Your Honor.
No, it was lifted before December. It was lifted, I believe, in September.
Your Honor, I believe that your order of September 6th says that nobody should be in the house.
Yeah, and at some point it's lifted. September 6th. Cannot be occupied. Consented to by the plaintiff. There's no mention in here anywhere of a tenant being in there. That was, and I was unaware there was a tenant in there. I feel, as I said, embarrassed. Ms. Blair is dealing with this as the property owner. There's no knowledge by the court that there's a lease option to buy. And I don't have the actual zoning file in front of me. I can't tell at what point it was lifted. I have a note of it somewhere. I think it was earlier than November.
I think it was done through a consent judgment, Your Honor, and Roxanne Sieber was the township's attorney.
Yes, I think that's the September 6th one that says no.
That was the September 6th order that Miss Blair consented to. Somewhere I have a timeline, so. Well, I know where I can find it.
Well, Mr. O'Donnell, let's do the best we can under the circumstances. At some point in time, and I think it was in December, the court said lifted the order saying nobody could be in there. Do you agree that it was about that time?
We weren't given notice.
Did you ever ask Miss Blair if she could go in? If you guys could go in?
She wouldn't respond to our contacts, any of our correspondence.
And did you go in of your own accord
Where's that?
into the house?
Yes.
Okay, so you know, you say that you may have not been told by the court or Miss Blair that you were able to go back into the house, when in fact you did go back into the house at periods of time.
For possessions,
Okay,
to get our stuff.
and at that point in time, had the utilities been shut off?
No,
No.
no.
Okay. And did you ask for the utilities to be put back in? Put back on?
When?
When you went back into the house?
No. Why would we? I don't know what you're talking about. They were never off. I don't really have it. I never went in there when they were off. Utilities?
Okay.
They shut off the garbage. She shut off the garbage.
But the utilities were on, the heat was on?
Yes.
Okay.
The lights were on. Everything was on. Water was on.
Okay. Furnishings in there?
Yes.
You could have stayed there if you wanted.
What are you talking about? She was gonna have us arrested. The cops are out there every night. I don't understand. I'm sorry. I'm not trying to be rude here. I don't understand you. I don't understand what you're trying to say.
Well, if we knew when the order was lifted, I guess that's the key here.
I can't tell from the file that I'm in.
Doug said in that first hearing, I swear he said November something.
I have a note of it somewhere, but I can't find it.
I mean, why the judge is looking at that, Mr. O'Donnell? Were you there at a hearing where Mr. Coleman testified?
Yes.
And when was that hearing?
The first hearing was in, I don't even remember, to be honest with you. I forget the date of the first hearing.
Approximate date, fall, winter?
It was just January, maybe she filed in December, so maybe January, December 20th or something. Your first court date maybe in December. She sent me something on December 20th when I got the lawsuit thing, and whenever the court was after December 20th, so it's probably January, I'm guessing. Ron, do you know?
Well,
There any question?
I'm just kind of waiting here.
The first hearing was set for January 6th. The defendant was served with a notice hearing on January 3rd. I can't answer the date easily on what date it was lifted. First set for January 6th, then it was going to be February 1st, then it got adjourned when Mr. Hatch got in the case. Then it got set for April 27th. I don't know the answer to that without suspending the record and going on a search. I thought it was in the zoning case, but there's very few notes in that file because it's a civil infraction.
Okay, well, Your Honor, I'll do the best we can.
All right. Consent order resolving the municipal infraction was September 6th.
Right.
Court accept the building official determination that the house was subject to being occupied due to structural damage. So there was no order that the court found that it was not to be occupied until September 6th. Then they were given opportunities to do other things. Now, this was all in the name of Rosemary Blair. There's no notice anywhere that any of this stuff was given to the tenants. And I can't tell, maybe I can see it in here. Because there was a subsequent inspection that it passed. It does refer to the tenants in his report, which I got at a later date. It's 84 pages long. I'm hoping to get to the bottom. I can't seem to speed it up. Darn it. Page 40.
I don't know if it'll work on there. Control N. I don't know if it'll bring you down to the bottom.
No. Move me back. 84. As I was leaving, I was advised there's a court hearing tomorrow at 8:16. This hearing is apparently a personal protection order where O'Donnell has placed a PPO against one of the neighboring property owners. Now, that report is dated 8:15, and there's no subsequent follow-up. I'm sorry, I don't have the answer in that file. Mr. O'Donnell, were you aware that after the original condemnation, Mr. Coleman and others went out there and made changes and so forth, and the condemnation was taken off?
No,
You weren't there?
no,
You didn't ever
No.
talk to Mr. Coleman about it?
no,
You ever see the stickers go away?
no,
Stickers still there today?
I don't know, no, I don't see.
Oh,
where that-
here it is. Douglas Coleman. On November 16th, I received photographs and a message from Matt and Van Dam at Cruising to Construction. They had made the repairs that would stabilize the grass wall from a state of collapse. Matt has advised once they stabilize the grass wall, they will send the township photographs and they have the township's permission to remove the condemnation. At this point, the dwelling is no longer deemed condemned on behalf of Fabius Township. I have contacted the property owner and advised her the dwelling is no longer considered condemned. She may now enter the dwelling and move forward with her plans. So the condemnation was lifted by Officer Coleman on November 16th of 2022. Thank you, Your Honor. Took me a long time to get there, but by November 16th, Mr. O'Donnell, the pipes wouldn't have frozen by that time, would they?
No,
Objection to form calls for speculation. You can answer. Well,
He's a builder, he
personal
says.
knowledge.
it's not freezing on November.
Well, he's just gonna answer no, because they won't, so why object? Just let him answer it, and then we'll move on to the next question. No, the pipes wouldn't have froze by November 15th last year, would they?
No,
And the furnace wouldn't have just gone kaput by that time over that, was it 2 months maybe?
I don't think so, I don't know.
When did you go back into the house after November 16th?
Probably a couple, about a month later, October or something, I forget. I was in there November, October, I was in there a few times.
And was there furniture there?
There was some.
Yeah, and the lights and the utilities all seem to be working,
For the most part, yes.
and you could have moved in there if you wished.
No, because how could we move in there when they have the police coming after us?
Did the police come after you after November 16th?
Yes. On November 15th, they came after. She called them on me on November 15th.
And after November 16th, did they come?
Yes, October, they came out again.
November. Did Mrs. Blair ever advise you that the condemnation had been lifted on the premises?
No, she did not.
Did Officer Coleman ever advise you as the
No, he did
tenant?
not.
So you didn't know the condemnation
Not
had
until
been
we were in
lifted,
court with you, Your Honor.
which was January 6th.
Yes,
And by that time, you knew it had been,
we heard about that day in the court.
okay. Did you move in after that?
We weren't allowed to.
I prohibited it. After that time? I said nobody was to go in there after, till we sorted it out. Very good, Your Honor. Anything further? Nothing further.
Nothing further with this witness, Your Honor.
Am I done?
Yes,
Yes.
you can step down, thank you.
Thank you.
Yes.
All right. Do you wish to call Ms. Bowers?
We do, Your Honor. As our second final witness, we will call Carla Bowers.
Good afternoon. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief. Thank you. Please have a seat, state your name, and spell your first and last name.
Carla Bowers, CarlaBowers.
Ms. Bowers, I know you have a little bit of a hearing problem, so if you can't hear me, feel free to speak up and let me know. Okay, thank you. Ms. Bowers, what is your current address?
221 South Berrien Street in Buffalo.
And is that the address where you permanently reside?
Yes.
And how long have you lived at that address?
I closed on that property on September 30th of 2022.
And do you own the house at 221 South Berrien Street?
City.
And where did you reside before you moved to 221 South Berrien Street?
Well, when I purchased that property, I was with my parents in Crete, Illinois, because before that we were living at the property in Quarry Lake, 11247 Lakeshore.
And after you were kicked out of the property at Quarry Lake 11247 Lakeshore Drive, were you forced to go live with your parents?
I didn't have anywhere else to go, yeah.
And how old are you here today?
41.
And I'm sorry, let me back up. When did you purchase the property at 221 South Berrien Street?
The closing date was September 30th, 2022.
Okay, so in between the time of August 2022 and the end of September, you were living with your parents in Illinois, correct?
Yeah. I'm scrambling to find something to move into, yeah. Because I mean, I didn't want to stay there with 3 kids.
And you have 3 biological children?
I do.
Okay. And you're familiar with Joe O'Donnell, correct?
Yeah.
Okay. And do you treat Mr. O'Donnell's children as your own?
I do.
And does Mr. O'Donnell treat your children as his own?
He does.
Where were you born?
I was born in Harvey, Illinois. Grew up in Crete, Illinois.
Crete, Illinois?
Yes.
Your Honor, I know Miss Bowers is soft-spoken. Maybe if she got closer to the microphone, that might help, because I can
Perhaps,
barely
yes,
hear
thank
her.
Loud and proud. You grew up in Crete, Illinois.
I did.
And where did you attend high school?
Crete High School,
And what year did you graduate from high school?
1999.
And did you attend college?
I did.
And what college did you attend?
Moraine Valley Community College in Palos Heights, Illinois.
And did you obtain a degree?
Associates in nursing.
And are you a registered nurse?
I am.
What states are you licensed in?
I am a travel nurse, so I am licensed in Illinois, Michigan, Indiana, and Virginia.
And how long have you been licensed as a nurse? 2019.
And you're an RN?
I am. And what areas of nursing do you specialize in?
I'm on the medical oncology floor right now. I do ortho, neuro, cardiac, post-surge. I float throughout the hospital.
Right.
Where are you
Medical-
presently employed? Where are you presently?
So I actually am employed with Aya Healthcare. They're based out of California. It's a travel nursing travel agency, but I am currently at Lakeland, which is now Corwell, and St. Joe, Michigan.
All right.
You stole my next question again. All right, I want to direct you what's marked for purpose of identification as Exhibit 15 in the book in front of you. Can you turn it up, please? Have you seen this document before?
Yes,
Are you familiar with this document?
I am.
And what is this document?
Is there 2 pages?
We'll just talk about the first page.
This is a text message between Rosemary and myself.
And were you a party to this text message?
Yes.
Can you hear her?
Yes.
Okay.
You speak up maybe a little bit more. And does this text message appear to be a true and accurate copy of the original?
Yes, it does.
And what is the name at the top of the text message thread?
Rosemary?
And is that how you store Miss Blair on your cellular device?
Yes, it is.
And whose text messages are in blue bubbles on the right?
Those are mine.
Okay. And whose text messages are in white bubbles on the left?
Rosemary.
Your Honor, we ask that Exhibit 15 be admitted into evidence.
Your Honor, first of all, Exhibit 15 seems to be more than one page.
That's true. We haven't gotten to the next part
We
yet.
haven't gotten anywhere there. As to the first page, there's nothing about money or anything like that. Seems like just a conversation. And so I have no question of it. I don't believe there's any.
Well, at that point, you're going to go to Rosemary's and drop something off. Is that correct?
Well, it says that I'm at the bank in Crown Point.
Mhm.
Are you home? Is it okay to stop by and drop this off in a few minutes?
All right.
So Your Honor, I'm gonna go with this text message where I went with all the other text messages, which
Yeah.
is establish a foundation. and
Well,
then
go
ask the
ahead,
witness.
and then we'll hear your motion. But there's also other stuff that
And
appears to.
the second page, we're not offering into evidence, Your Honor. It's just the first page that we're offering into
All right.
evidence.
So this is a text message that you sent to Rosemary and she responded.
Correct.
All right, for that purpose, it's admitted.
And what is the date at the top of this text message, Ms. Bowers?
May 4th, 2022.
And I want to direct you to the text message where you state, "Hi, Rosemary, it's Carla. I'm at the bank in Crown Point. Are you home? And is it okay to stop by and drop this off in a few minutes?" Do you see that?
I do.
What were you referring to in that text message?
The $2,000 that I paid her, and if I had hindsight that this was going to be an issue, I would have said, I'm going to drop off $2,000, but I didn't know that this was gonna take place, so I didn't do that.
And did you actually meet up with Ms. Blair on May 4th of 2022?
Yes, I did,
Where did you meet Ms. Blair?
at her home in Crown Point.
And did you pay Ms. Blair any money on May 4th of 2022?
I paid her $2,000 towards the purchase of 11247 Lakeshore Drive
And how did you make that payment?
in cash, in person.
And you handed the money to Ms. Blair?
I did.
And again, what was that payment relating to?
The purchase of 11247 Lakeshore Drive.
Green light, can you put a sticker up next to Exhibit 15 on there for me? Ms. Bowers, you were sitting in the court and you heard Mr. O'Donnell testify here today, correct?
Yes, I did.
And that testimony generally had to do with Rosemary Blair and the events that surrounded 11247 Lakeshore Drive, correct?
Correct.
Is there anything that Mr. O'Donnell said that you have personal knowledge of that you disagree with?
No.
Now, I want to get into, there's been some questions here today about why you and Joe gave cash payments to Rosemary. Did you have discussions with Rosemary about the cash payments you were going to make for the purchase of the property?
Yeah, we did.
And what did Ms. Blair tell you about those cash payments?
She said that her and her children were estranged. She did not have a relationship with them, and I guess they had a falling out over some property in Texas. She was getting money from that land out there, and they were essentially, I guess, taking money. They had access to her bank account, they had access to all her records. So everything she wanted to do was in cash.
So was it Ms. Blair's request that you pay her cash?
Yes, it was.
Okay. And you guys comply with that request?
We didn't have a reason not to at the time. We had a relationship with her. Yeah. So we had no reason to believe that this was ever going to be an issue.
Let's talk about your relationship really quickly with Ms. Blair. Do you see a picture in front of the podium right here?
I do.
Can you describe to me what that picture is?
I believe that was one of the first couple days or something that we were at the home at Corey Lake. That's me, my son Joey, Joe's son Joey, and my daughter McKenna and Rosemary. And we're standing, that's like right kind of in front of the front door, taking a picture. She actually stayed there, I think, that weekend with us and just hung out and enjoyed the house and the lake, and there was a relationship there.
Yeah.
So
And would that be around June of 2021?
yes, it was.
And whose arms does Miss Blair have? Her arms, or whose arms is she wrapping her arms around that picture?
That's Joey-O and McKenna.
So that would be Joey O'Donnell?
Yes.
And that would be McKenna, your biological child.
Correct.
So at that point in time, it's suffice it to say that you had a good relationship with Miss Blair, correct?
Yeah.
Fast forward 2 years, did you ever expect that you'd be here today?
Not at all.
How does it make you feel that you're here today?
Frustrated, disappointed, angry.
Well played.
Your Honor, that's an appropriate commentary.
I'll retract my statement. I apologize. All right, we're rounding home base with you now too, Ms. Flowers. I want to talk about the mortgage that Mr. O'Donnell testified that you got for your property in New Buffalo. Again, what's the address of your property in New Buffalo?
221 South Berrien Street in New Buffalo.
Okay, and why were you forced to buy that home?
At that time, I was scrambling for, the kids were starting school. I mean, school begins after Labor Day. I mean, I ended up closing after that, but they needed a home. I needed a home. And I was working in St. Joe, Michigan. We were supposed to be at Torrey, and I ended up in New Buffalo. That's where Joe was. The kids, I mean, we had a little bit of a background there, so that's where we ended up. But.
Okay. So did you have to purchase that property for replacement housing after you kicked out Quarry Lake?
Yeah.
Is that because your children were attending the New Buffalo schools?
I enrolled them last minute there, yeah.
And you obtained a mortgage. Is it correct that you obtained a mortgage to purchase that property?
I did.
And what date did you obtain that mortgage?
The closing date was September 30th, 2022.
Okay. 2022?
Yeah.
Sorry, I didn't hear you. And what was the amount of the mortgage?
469,000.
So within the 90-day time frame after August 4th of 2022, you were able to obtain a mortgage for $469,000.
I was,
correct? Yeah. And does that $469,000 exceed the amount that you and Mr. O'Donnell were going to pay on the remaining purchase price of the lease with option to purchase?
No, it does not exceed the amount. What do you mean?
Objection, Your Honor, I
Like
think
in addition
there's a
to
little
that?
coaching here.
Let me restate the question. Does the $469,000 exceed?
Oh, the three, yes, yeah.
Yeah, so you had a remaining purchase price that you were going to owe for closing on the Quarry Lake home, is that correct?
Correct.
Okay. That was $338,000?
Correct.
And does the $469,000 exceed the
Yes, it
338?
does.
So were you able to obtain financing to pay off
Yes, I
the Quarry
was.
Lake? Pass the witness.
Ms. Bowers, when did you vacate the Quarry Lake house?
Well, when I was kicked out on August 12th, I think was when they actually came in and to the bedroom where I was sleeping and got me out of bed and said we had to leave.
When did you start the process to obtain a loan?
For the house that I'm in now.
Correct.
Sometime in August, I mean, right before the kids ended up going back to school, so probably beginning of September and August sometime.
You're not sure?
I mean, I'll probably go on my phone and look and see when the application was turned in.
Okay.
Yeah.
Where did you obtain your mortgage? From whom did you obtain your mortgage?
I ended up going through United.
Wholesale mortgage?
I'm sorry?
United Wholesale Mortgage? Never mind, that was just a guess.
No, it was a different one. I can't remember actually. United Federal, I think.
Okay. Is that a bank credit union or a credit union? Okay. Where are they located?
There's branches all over.
Okay. What branch did you do your loan approval from?
I think it was Stevensville.
Okay. And when you left the house, was Mr. O'Donnell still there or was he already gone?
Like the exact moment I left the house.
Well, kind of
Did we
like.
leave together? I mean, I don't remember. I had to go to work that night. So I
Okay.
think I just ended up going in early.
Well, when you came back, did you pack up and then go? Were there Mr. Donald?
Well, I had to
O'Donnell had
leave.
already gone or?
Well, like I said, I had to go to work that night. So I went to work. I didn't have time to pack up all my stuff. So I did end up coming back. They kicked us out again. I didn't have time to get my stuff. And then I ended up going back with a truck and getting everything at a later date. I believe in September.
Mid-September?
I think October, because that was after I purchased the home.
So you moved all your stuff out of the Quarry Lake home into the Berrien Street?
Yes.
Okay, good. Berrien Street
Well, I
home.
think I got a storage unit for some of it, but yeah.
Okay. And when you vacated the Quarry Lake home, did you ask that the utilities and electric and all that sort of thing be
So-
taken out of your name?
Yes.
Okay.
Can I expand on that?
Well, when did you ask for them to be taken out?
So the electric, I believe, was through October and the gas was through November. It was still on in my name through those dates.
Now, do you live with Mr. O'Donnell now?
No,
And he lives at on Barton Street?
he's at 28 North Barton Street. I'm at 221 South Berrien. They're like 2 minutes apart from each other.
Then they're not the same house or whatever.
No, they're separate addresses.
And when you say you went to live with your parents for a bit, did Mr. O'Donnell go with you?
No, he was at other residences. He was like you said, like couch surfing. I think he went up to Traverse City for a little bit and he was like with other friends.
Okay.
But I had kids. I mean, I couldn't couch surf with kids. You know?
And the kids are going to the New Buffalo schools
Yes,
right
they are.
now, yeah, good. You heard Mr. O'Donnell say that whenever he gave Miss Blair some money, except with certain exceptions, he always took a picture of the cash or her with the money or something like that. Did you think to do that?
No, I didn't actually.
Okay. Okay, fair enough. I have nothing further, Your Honor. Any further?
Nothing further, Your Honor.
Ms. Bowers, you can step down.
Your Honor, I would request just a brief closing statement. I don't know if now is a good time for maybe a mid-afternoon break, and then I don't expect closing to go more than 10 or 15 minutes.
That's fine. I don't know if Mr. Soltis wants to present anything, but he's prohibited from.
Well, Your Honor, am I permitted to at least comment on the evidence that
Oh,
has
certainly.
been presented?
Certainly.
Yeah, and I'm ready to go whenever.
All right,
the court-
let's take a short break, about 2:45. Maybe we'll get where we need to be.
I'm sorry.
Quarter
what
to
time to-
4. Quarter to 4.
Quarter to 4?
I'm
Okay.
gonna go back in time.
Thank you.
Exhibit 15 is admitted.
So this place is, they need to turn this air.
Well, we have two options, too hot or too cold.
Right, it's always that way.
Yes, and when you're up here in a long black dress and no air, it gets awfully hot. So I have about zero control over the temperature in here, and I apologize. All right, let's go back on the record. I didn't think to ask. Are you either Karen Stiver or Patrick Blair? You're just, yeah, either of you. So those parties aren't here.
Yeah, those are the parents of Carl Bowers.
Oh, okay. Well, you're certainly welcome to be here as a spectator. All right, we finished the evidence portion of this hearing regarding specific performance. I have 25 exhibits and a day's worth of sworn testimony. Mr. Hatch, what would you like me to know?
Thank you, Your Honor. In June of 2021, Joe O'Donnell and Carla Bowers moved into the lakefront property at 11247 Lakeshore Drive with their 5 children to live the American dream as a single nuclear family. Over the past 2 years, Rosemary Blair has done everything in her power to turn that dream into a nightmare and ruin their lives. Today, on June 28th of 2023, almost 2 years to the day after they first moved into the property, we ask that the court give Joe, Carla, and their family their lives back by holding Ms. Blair accountable for her actions. First and foremost, I want to sincerely thank the court for its attention and listening to the testimony here today, and on a broader scale for its patience in dealing with this case over the past 6 months. Closing argument is not the time to rehash everything that has occurred before trial, but I think the court would agree with me that this case has turned into something that it should have never been. Ms. Blair could have entirely resolved this dispute by owning up to the mistake that she made when she unlawfully kicked Joe, Carla, and their children out of the property in August of 2022. Had she simply let my clients back into the property and moved forward with the sale of the house, none of us would be here today. Joe and Carla's life together would have never been uprooted. Their relationship would have never been plagued with stress and mistrust. And most importantly, they would have never had to explain to their children why they lost their home. But that resolution would have required Ms. Blair to do something that she has shown time and time again that she is incapable of doing: playing by the rules and admitting that she was wrong. As the undisputed evidence is shown here today, Joe and Carla entered into a valid and enforceable contract with Ms. Blair to buy the property at 11247 Lakeshore Drive. Between June of 2021 and July of 2022, Joe and Carla paid Ms. Blair a total of $112,000 towards the $450,000 purchase price of the property. Then in August of 2022, when Ms. Blair indicated she wanted to close on the sale of the property and collect the remainder of the purchase price, Joe and Carla worked to secure financing and were ready, willing, and able to consummate the sale of the property within 90 days. But everything changed in August of 2022. At that time, Ms. Blair turned into, quite frankly, a bad decision-making factory. She got seller's remorse when she was confronted with the reality that she was going to have to part ways with the property that she owned forever. To get out of the land contracts Ms. Blair executed with Joe and Carla, she had her own property condemned and then turned around and attempted to use that condemnation as a means to terminate the land contract, the lease with option of purchase. She then hired a lawyer to send threatening letters to Joe and Carla demanding that they vacate the property. And at the same time, she took matters into her own hands by unlawfully locking them out of the property. And after she locked Joe and Carla out of their home, she stole countless items of their personal property, including boats, beach chairs, rafts, grills, coolers, speakers, life jackets, and even a snowmobile and snowmobile. Ms. Blair is a deeply troubled person, violently unafraid that there are consequences for her actions. And in her relationship with Joe and Carla, she was downright cruel. She has lied to the court countless times, claiming that she was only paid $30,000 towards the purchase of her home. She apparently forgot about the other $82,000 of cash that she was paid by Joe and Carla when she was, in her own words, desperate for cash. She has also come up with ridiculous positions that bear no semblance to the truth, such as her claim that she lacked the mental capacity to execute the lease with the option to purchase, which is the same lease with the option to purchase that she relied on to kick Joe and Carla out of the property. What Miss Blair did in this case was an act of profound cruelty, not just to Joe and Carla, but also to their children. Thankfully, the court can provide a remedy for that wrong that have been inflicted upon Joe and Carla through its equitable powers of the grant of specific performance. There are 4 elements to a claim of specific performance, all of which have been proven here today by a preponderance of the evidence. In fact, more than a preponderance of evidence, I would attest by clear and convincing evidence. The first element is a valid and enforceable contract between the parties. Here, Joe O'Donnell, Carla Bowers, and Rosemary Blair entered into a valid and enforceable written contract for the sale of 11247 Lakeshore Drive, and that contract was admitted into evidence as Exhibit 18 and has a inclusionary term integration clause that said is the final contract and supersedes all prior negotiations and agreements between the parties. That is the binding agreement between the parties here today. The second requirement is compliance with the contract by the party seeking specific performance. You heard undisputed testimony here today that Joe and Carla comply with all of their obligations under the lease with the option to purchase and were never defaulted by Ms. Blair. The third requirement is a breach of the contract. Now, it's already been established through the default that Ms. Blair breached the lease with option to purchase by, among other things, removing Joe and Carla from the property without lawful cause and locking them out of the property in violation of the Michigan anti-lockout statute. And finally, the fourth requirement is that the subject matter of the contract is unique. The Michigan Supreme Court has held, and I quote, "In cases concerning breaches of real estate contracts, land is presumed to have a unique and peculiar value, and contracts involving land are generally subject to specific performance." That is Henry Smith Trust 480 Mich 19, a 2008 case. And you also heard the undisputed testimony from Joe O'Donnell here today that the lake house was uniquely situated to meet the needs of his family and Carla's family and their unified family, and he has been unable to find another capable property at a comparable price. So all of the elements of specific performance have been met, not by a preponderance of the evidence, but by clear and convincing evidence here today. So I'm going to go back to what I started out with in opening statement. And I told you at the close of our proofs, we were going to request specific items of specific performance from this court. We asked that the court enter a judgment in favor of Joe O'Donnell and Carla Bowers and against counter-defendant Rosemary Blair, ordering that Ms. Blair to perform her obligations under the land contract, the lease with option to purchase. Second, we ask that the court enter an order requiring Rosemary Blair to execute all of the documents and instruments necessary to sell and transfer the real property located at 11247 Lakeshore Drive in Three Rivers, Michigan, in fee simple absolutes to Joe O'Donnell and Carla Bowers, free and clear of any liens and encumbrances after the parties close on the sale of the property. And we also ask that the court enter an order requiring the purchase price of $338,000 that's remaining under the lease with option to purchase to be set off through set off and recoupments by the money damages that Joe O'Donnell and Carla Bowers are awarded potentially in the circuit courts with their claims against Rosemary Blair. Also, we would ask that the court order under specific performance that Ms. Blair return some of the larger ticket items of personal property, such as the HydroStream boat and the pontoon tracker pontoon boats that you heard Mr. O'Donnell testify about here today, so they can enjoy the lake house. And Your Honor, I know we spoke about the equitable remedy of specific performance and whether the court can order a set off for the remaining of the purchase price. And the case law states that you can. Set off is an equitable remedy, and this is out of a Michigan Court of Appeals published case, Walker versus Farmers Insurance Exchange, 226 Mishap 75, a 1997 case. Set off is an equitable remedy, so an equitable remedy that the court can grant in addition to specific performance that may occur when two entities that owe money to each other apply their mutual debts against each other. So Carla Bowers and Joe O'Donnell are responsible for the remaining purchase price of $338,000 under the lease with option to purchase. Miss Blair will potentially be responsible as a debtor to pay Joe O'Donnell and Carla Bowers damages under their claims that have been removed to the circuit court. So we would ask that as part of the request for specific performance that the court order a set off for the remaining price. And specific performance, the case law allows and encourages the court to grant such a remedy, Your Honor, because the big picture for specific performance is to put the parties, the non-breaching party, in the position that they would have been had the breaching party performed its obligations under the contract. So simply requiring Joe and Carla to pay the remainder of the $338,000 from today is not going to put them in the same position as they would have been had Ms. Blair consummated the transaction. Ms. Bowers has bought another house that she has paid a price that she will probably take a loss on today. And they are not in the financial position that they were before to necessarily, I'm not saying they couldn't do it, but it would be difficult to leverage their assets to get another $338,000 loan when they've had to spend that money to secure replacement property. And Ms. Bowers has had to purchase another house with it as well too. So it's not just as easy as say, hey, come up with another $338,000 because they're in a different position than they would have been if Ms. Blair would have performed the contract. The other option, Your Honor, is to possibly escrow the payments with the court for $338,000 until the circuit court decides the damages that will be offset by the $338,000. Not preferred, but if the court wants to go down that route, then that would make sure that they're not going to spend the next 20 years of their life chasing down to try to collect against Ms. Blair for the amount that they have to set off if they're set off in recoupments. So with that, Your Honor, I appreciate your attention here today and nothing further.
All right, let me address that. One option is to order specific performance of the lease option to purchase. And the remaining price was $365,000. And plaintiff has established proof that $112,000 was paid, not $500. $365,000 minus $112,000 equals $253,000.
Your Honor, just to be honest, I think that the purchase price was $450,000.
Yeah, it's 450. Oh yeah, you're right. I'm double dipping.
Yeah, minus the 112.
450 minus the 112.
So I think that would be a 338.
Which is the figure we were using.
Yeah, please double check my math because I missed the $500 payment.
338,000 minus 2 additional escrow payments of $2,000. So there's $4,000 in escrow, which would be $334,000. One option is for the defendants to tender a certified check for $334,000 and you tender the deed to the house. That seems pretty straightforward, but as Mr. Hatch indicates, then there's going to be a hearing regarding damages. And then they're in a position where they need to try to collect what I expect to be substantial damages, well in excess of $25,000, possibly in excess of $100,000. So they're asking for a set off. So rather than chase you for the money, reduce the amount that they owe by their damages. Mr. Soltis made a good point early in the case that we aren't going to know what the figure is until we know what the damages My option, they pay $334,000. They get the house, gives them free, clear, simple title right now. But then they may never recover their damages. The defendant may or may not have the money. She could possibly declare bankruptcy and wipe the debt out. So the wiser course is to use damages as an offset of the purchase price of the house. But as Mr. Soltis says, that's going to take quite some time. So they're going to be in a limbo position in the meantime. Although they do have a color of a lease. There's also the issues of the property taxes. I don't know when the taxes were last paid. The defendants haven't paid them, and I suspect Mrs. Blair hasn't paid them. And taxes on a $500,000 lakefront home are not insignificant, particularly if it's not homesteaded. So there's going to need to be some provision on who pays the taxes. And the lease option to purchase says the purchaser pays the taxes. Mr. Soltis, you've been doing a remarkable job considering how short of a time you've been in this complicated case. What are your thoughts on the matter?
Well, Your Honor, I generally agree with you. How about that? There's 3 counts that haven't been brought up to circuit. One is the summary possession. I think the court has already addressed that. And if not, then I will stipulate that Mr. O'Donnell and Miss Bauer can stay in the house until there is either a court order saying otherwise, or they don't exercise the option. So I don't think that really needs to be litigated.
All right.
The other aspect is quiet title. Quiet title, obviously, Your Honor, I don't think can be addressed until we know if they are going to exercise their option. And right now, that's still up in the air. So I think it would be premature. Now, with regard to specific performance, that's the key, I think, today. And I think this court can order that Ms. Blair follow the agreement. So if the O'Donnell and Bowers tender the 300 and you say 334,000. I don't think they've proved all of that, but you're the judge. That she should, turn over the deed and things like that. Now, counsel has asked for all the liens, and that's contrary to the agreement. The agreement in the title section says landlord agrees to, and this is page 4, accept title to premises subject only to a lien for taxes and assessments. Well,
what section are you in?
I'm on title on page 4.
Yeah, we've never inquired. We've been under the assumption that Miss Blair owns this property free and clear. I don't know whether that's true or not. I don't know if she has a note on it that she has to pay. But they are agreeing not to purchase it subject to any other note or lien, so except for taxes.
And Your Honor, I can tell you this. Miss Blair keeps telling me, and I believe her, and I think I may end up filing a motion for reconsideration that she's been paying the taxes, that not Mr. O'Donnell has been paying the property taxes. So
Well-
I think we can get that, we can flesh that out,
All right.
but it won't happen today. And there's also the problem with the option consideration. There's $5,000. That money I don't think should be given to Mr. O'Donnell and Miss Blair at this point in time, because once again, we won't know if they are going to exercise the option. Will they come up with the money? Maybe yes, maybe no. Like you said, they could file bankruptcy. All kinds of things could happen. And so I think that money should be held in escrow perhaps by the court until we know for sure. If they do exercise the option, they get the 5,000. If they don't, then that should go to Miss Blair. So those are the things that they've been talking about with regard to the lease. Now, we really haven't had any evidence of the financial condition of Miss O'Donnell, or Mr. O'Donnell and Miss Bowers. So for them to say, well, we can't do it, and we're not unable to, well, Your Honor, maybe yes, maybe no. We don't have any evidence of where they stand, their profits, loss, and so forth. I do take umbrage with the idea that counsel says, well, they're going to, Miss Bowers is going to lose money on her house. Not too many people are losing money on their houses these days, I assure you. I mean, they keep going up and up and up. So if she does sell the house and makes a profit, good for her, but that, shouldn't be held against Miss Blair. So I guess, Your Honor, I'd say order specific performance, I think, as you've already adjudged. Order the parties. You can order, you don't have to order Mr. O'Donnell and Miss Blair, Miss Bowers rather, but you can order Miss Blair to follow the language and terms of the agreement. And then let's see where it goes. If she does, if the option is exercised, great.
The problem is, this is gonna take a long time. Miss Blair, this has been a long legal process for you. You've been through 4 lawyers. It's very frustrating. We're not done. Mr. O'Donnell and Miss Bowers, this completely upended your life. Everything was going fine. It was COVID summer 21, but people were outdoors during the summertime. August 4th, you're living in your house, your toes are in the water. 9 days later, somebody comes and tells you have to move out and everything's turned upside down. I don't know what happened between that date and the date that the zoning enforcement officers came. I have speculated about it, but I don't know what happened. Something changed. You had a good relationship with the seller. You'd given her inordinate amounts of cash, which is very unusual. You've given explanations for why it was done. Your banker must have thought you were crazy coming in there every few days asking for stacks of $100 bills. Over 100, over 10,000, they're supposed to report it to the IRS. And at any rate, I do find that they have proven beyond clear and convincing evidence that they gave her $112,000, even for the things that were not photographed. But the 14,000 was photographed. So I believe she got that amount of money. I never understood in the pleadings why there was a contention that she didn't, but that's going to be offset. you raise a very good point regarding the $5,000 lease option purchase default. I remember what clause that was in.
That's page 4, about 2/3 of the way down.
Yeah, option consideration. All right. I order specific performance that Rosemary Blair comply with the terms of the lease with option to purchase dated November 15th of 2021.
And Your Honor, I hate to say this in the middle of your hearing, but we'll probably need a date by which that order begins, because obviously we want to be able to say, okay, this is, this is the 90 days.
Well,
So
the problem is we aren't going to be able to do it within 90 days because there's the whole issue regarding set off.
Okay.
Like I said, in the ideal world, they would tender a check for that amount of money within the next 90 days, and they would take fee simple title to the house. That's one way to do it. Then they have to go through the damage hearing and get a judgment. So it puts them in a position where they have to borrow money to cover that cost and then spend additional money to collect that money from Ms. Blair. Mr. Hatch and the defendants are saying, look, let us have our hearing regarding money damages and we'll offset that against the price of the house. That's why it's going to take longer than 90 days. It'll take longer than 90 days to get the transcript prepared. So I have a wording in mind,
okay,
but she has to comply with the lease option to purchase. Mr. Hatch, you're going to do this order, so we'll make sure we're all on the same page. Defendants shall be credited with $107,000 of payment. $5,000 of the option consideration shall be held in escrow. To be applied to the sale if completed. Or return to the plaintiff if not. Defendants shall be entitled to application of all other escrow funds. Which is currently $4,000, but shall another payment's due in just a couple of days. They've been pretty good about making their payments in a timely manner. I'm going to continue the escrow order in this court. $2,000 per month. I'm going to order that the defendant purchaser pay the 23 property taxes. The defendants shall be entitled to a set off against the purchase price of damages to be determined by the circuit court. Once that figure is established, defendants shall have 90 days to execute the sale. To the extent the property still exists, plaintiff shall return the Four Winds ski boat,
Sorry, I don't, hydrojet ski boat,
hydrojet.
hydrostream.
I got Four Winds Casino.
That's exactly.
That is where it came from.
Stream ski boat.
And the Sun Cruiser,
No, what?
Sun Tracker.
Sun Tracker, yeah, that's the sailboat.
No, that's the pontoon boat.
Oh, okay.
The Hobie Cat sailboat. Paddleboard, paddle boat. Canoe. As well as, I think this property has been dissipated or it's gone, but the snowmobile. What brand is it?
That was I think it was Kawasaki.
What's a small wheel?
Snowmobile.
Oh, snowmobile, I'm sorry.
Snowmobile and a snow blower. And other personal property as requested. If it still exists, I think that somebody told me they saw the snowmobile.
It was a Polaris, Your Honor.
A Polaris. Or that shall be added to the damage claim. That's within 30 days. Defendant shall otherwise comply with all the terms of the lease option to purchase. I don't need to know this, but I want to know it. Do you have an estimate on what the plumbing repairs are after the property froze?
Probably somewhere around 3,000.
All right, so it's not exorbitant, but you're going to be responsible for restoring the habitability at this point. This is going to be your house.
Yeah, but that doesn't, the furnace is shot. I don't think.
Sorry, I didn't hear that.
He just said the furnace is also run, but again, I think that'll be part of the damage.
So either you can just leave it vacant, pay $2,000 a month for a property you may not be able to access, or effect those repairs yourself and make it part of your damage claim to be able to use the property. I'm familiar with this property. My cousin used to live across the street from it. There are some Airbnbs just down the street. A family that my son knows from Parkbridge, Illinois, rented a house a few houses away from this and had a wonderful family time. People like me that live here in St. Joe County with all of our lakes take for granted what other people don't often get to enjoy, which is lakefront life. It's about as good as it gets in the summertime. All right. Have I omitted anything that should also be in the order?
I don't believe so, Your Honor. I just, so there's gonna be three orders that I will prepare. The direct contempt for $6,500 within 30 days of today, which I believe we addressed at the beginning of today.
That's not offset against the purchase price. That's just
paid straight out, right? Yeah. And I'll have it be paid to my firm's IOLTA accounts, just so we don't have any issues about how it gets delivered, if that's acceptable to the court.
Yes.
Order number 2, removing all claims to the circuit court that we put on the record today. And then the court's ruling opinion and order today. I think I've got all of that down, and if not, I will be sure to go back and listen to the recording today to confirm. And would you like me to submit that under the 7-day order?
That would be fine. We'll have Mr. Soltis an opportunity to look at it.
Okay. And nothing else from us, Your Honor. Thank you very much.
All right, thank you. Anything further, Mr. Soltis?
No, I think you've covered it all, Your Honor.
All right, we did accomplish this in a day with a couple of criminal interruptions here and there. Thank you all, and we'll be in recess. Have another full day tomorrow with another 40 or so cases to address.
Is it too loud? It's fine.
Can you hear me, Ms. Blair?
Yes, thank you.
All right, very good, thank you. All right, we are on the record, and we're going to return to the matter of Rosemary Blair versus Joseph O'Donnell and Carla Bowers. Ms. Blair is here with her lawyer, Mr. Robert Soltis. Also present is Mr. Daniel Hatch on behalf of Joseph O'Donnell and Carla Bowers. We've also got interested parties. Does anybody else need a microphone set? Okay. All right, I believe we have 2 matters to address. A motion for contempt regarding the defendant's decision to stop making the escrow payments, and the defendant's motion to release the escrow funds to the defendant. This case was well pled, gentlemen, and I do appreciate that. I have a portion of the file. The rest of it's in a box. It's all been scanned in, but I spent the last part of yesterday and part of this morning trying to refresh my recollection on everything. So, Mr. Soltis, you have the contempt motion, and Mr. Hatch, you have the motion to release the funds. Mr. Soltis, I'll defer to you first.
Thank you, Your Honor. We have another contempt motion. You referenced the escrow, and we also filed for the taxes not.
Oh, yes, yes. Now, it was represented that the taxes would be paid by the time of this hearing. Has that happened?
That they're not paid, Your Honor.
All right.
I spoke with my client this morning, and I can shed some color on why that is, but I don't want to interrupt Mr. Soltis from
All
presenting
right.
his
Well,
motion.
then that issue is still on the table as well.
Well, I think the contempt motion's pretty simple, Your Honor. The order of July 31st, 2023 said Mr.
O'Donnell and Ms. Bowers were to pay the 23 taxes. Those have not been paid. And then court also, in the same order, said that Ms. Bowers and Mr. O'Donnell need to escrow $2,000 a month. Obviously, in September of last year, Mr. O'Donnell and Ms. Bowers just decided not to pay anymore. And so from October to the present, that's 8 months, $16,000. And Your Honor, if for any reason O'Donnell and Bowers didn't agree with your order, they had many, many ways to do that. Number one, they could have asked for a motion to reconsider. MCR 2.119 in parenthesis F. Had to be filed within 21 days. That ship has sailed. Motion for relief from judgment. MCR 2.612. 1 year. Ship's also gone. Motion for new trial. MCR 2.612, and that's a 21-day requirement. So any of those things could have been done, and they weren't. Nothing was done. They didn't pay. They just didn't do what the court ordered. And the court gave them exclusive possession, O'Donnell and Bowers. And I believe that the court's order purpose was to give them incentive. And that is to basically have skin in the game by paying the $2,000 per month. They haven't done that. They haven't paid the taxes. And if I'll get to Mr. Hatch's motion after he has a chance to discuss it with the court. But bottom line is, these were supposed to be done. And Your Honor, with regard to the taxes.
All right, well, let's assume for the sake of argument, that your argument is compelling they just stopped. Mr. Hatch contends that somehow it got swallowed up by the order granting specific performance, but at some point they just stopped. Now, he did file a motion for distribution of the assets. I think that was in February, and I apologize, we're not hearing that until now. So yes, it's a violation of the court's order. So if we assume that to be true, what's the remedy?
Well, the remedy is certainly not to give Mr. O'Donnell the $24,000 escrowed already. That money, first of all, should be used for the taxes, because obviously the taxes aren't paid, then there's foreclosure, possibility of losing the house, and the 23 taxes, according to the county treasurer, is presently $10,428.52 for 2023. Now, 2024 are due as well now, and but the 23, that's the amount.
You had it in your pleadings, but what are the 24 taxes?
24 taxes are presently $8,993.87. And that would be a total of $19,422.39.
Okay. All right, anything you wish to say further about it?
Not right now.
All right, let's do this one first, and then we'll do your other motion.
Certainly. Good afternoon, Your Honor. Dan Hatch on behalf of Joe O'Donnell and Colin Bowers. May it please the court. I think, Mr. Soltis, we all agree that the 2023 taxes have not been paid, and the escrow stopped at a certain period of time. As we put in our response, the number one, contempt is a willful, intentional act or omission that is made on behalf of a party to the case. This was not willful. This was not intentional. The underlying issue here is that I think that to no fault of the court, or no one caught it at the time that the judgment was entered, there's conflicting provisions in the June 28th, 2023 order or judgment that was entered by this court after the bench trial on our specific performance claim. The order requires, I'll say to the court, it's at paragraph 10, it requires the parties to comply with the lease with option to purchase contracts. The lease with option to purchase contract that the court ordered specific performance of, it's attached to both of our response to Mr. Soltis's motion and my own motion to release escrow proceeds. It's page 1, lease payments. Tenant shall pay to the landlord monthly installments of $0 per month. There are no lease payments under the lease with option to purchase for specific performance. So there was a May order from this court for escrow of $2,000 per month. That was before we had the trial. That has continued. I think that as part of the judgment for specific performance that just got missed, and it's my fault. Mr. Soltis's fault. I mean, everyone's fault for missing that. But really, there's conflicting provisions. Also, with the lease with option to purchase contract at page 2, it states landlord shall pay all real estate taxes, which may be levied against the premises. So again, the court's order for specific performance with the lease with option to purchase requires Ms. Blair to pay the property taxes. I think the bigger issue here, Your Honor, is that what has transpired since this court held a trial on this case and did an efficient and effective job about basically putting out a silver platter to the circuit court is really a travesty. The claims were supposed to get transferred to the circuit court. Mr. Soltis filed a meritless motion to overturn everything that we did in the district court that Ms. Blair didn't like. He did not do it as an appeal. The circuit court has no jurisdiction over that. It was a very simple response to the motion, which is, number one, you did have jurisdiction to do what you did in the district court. And second, the circuit court has no jurisdiction to hear, in essence, this untimely appeal. That has been pending for 617 days in front of the circuit court.
Well, 617 days as of the date of your brief. So it's, or is that as of today's date?
That's of today's date,
okay,
from the date that Mr. Soltis filed it. So
okay,
September 7th of 2023 is when Mr. Soltis filed the motion. The case was transferred in July. So in essence, there's been no action in the circuit court. My clients are hanging off in the wind. They're carnage to the system in the sense that we're waiting for a damages judgment from the circuit court, and the circuit court is not acting on that. There's continued delays. There's continued gamesmanship on behalf of Ms. Blair. My clients have a judgment, a specific performance, and we're waiting for a damages award to be heard and issued by the circuit court, and that just hasn't happened yet. So during this entire delayed proceeding, now the order of the escrow of $2,000 a month conflicts with the lease with option to purchase. I mean, in essence, as Mr. Soltis argues, it could just go on indefinitely, forever. $2,000 that my clients are paying when they have no legal obligation to pay that, or the property taxes. The property taxes, I have encouraged my clients, not because they're required by the lease to option to purchase, but we don't want the home, the collateral, to go into foreclosure. So they've been working with the treasurer's office over the past week to try to pay those property taxes. Here's the issue. It is a non-homestead property because it's in Ms. Blair's name. It should be in my client's name.
oh boy,
It's double the amount of the property taxes. So the $10,800, my clients went there with a check to pay the property taxes, and they say it's not $5,800, it's $10,800. So this all goes back to the issue that Ms. Blair evicted my clients from the property without cause, will not tender possession of the property or title to the property when we were ready to do it. And this whole mess was caused by Ms. Blair violating the lease with option to purchase. So again, there is no intentional, willful dereliction of this court's order. I think that we need to sort out the issue between the lease with option to purchase, the specific performance of that. And we need some clarity for the court about who is required to do what and why. And that's why the taxes are not paid and the escrow payments are not paid. And we'll argue, I'm sure momentarily, about why we're asking them to be released. Nothing further unless the court has questions.
No, thank you. Some of this may be because of this court's naivete or optimism on how fast this would be taken up in the circuit court. And then looking at it, the amount of built-in delay has been much more than anybody expected. You argue in your pleading, the O'Donnell should not be required to pay $2,000 of rent per month to escrow, while this dispute is needlessly delayed due to no fault of their own, particularly because the contract orders specific performance does not require them to pay any rent.
Your Honor, do you mind if I address that issue?
No, right now I'm in the time frame. So the matter was subject to orders in this court in July of 23. And the matter was removed to the circuit court. The court did make a ruling on the specific performance. There were a number of other issues which were by stipulation and fact agreement of the court, all removed to the circuit court because circuit court has jurisdiction of those types of equitable claims. So the first hearing was set for September 29th. Okay, now we didn't even get to any of the issues that were removed. It was argument regarding Mr. Soltis's motion for lack of subject matter jurisdiction. So the court hasn't even ruled on that yet. If he grants the motion, I don't know what happens. If the district court didn't have jurisdiction and the circuit court does, if he denies the motion to deny, he still has to decide all the other issues regarding the damages. So the original hearing was set for September 29th. Because of a scheduling conflict, I don't exactly know what it is. The matter was adjourned to October 10th. And I remember the day the pipes burst upstairs in the courthouse, and through no fault of anybody's, the hearing on October 10th was canceled due to a burst pipe. The matter was adjourned to December 14th. And for reasons I don't understand, then it got adjourned to January 5th. So it was set for January 5th of 2024. So we're all the way from July to January for different circumstances. And then according to the pleadings, the parties appeared for the motion hearing on January 5th. At that time, the circuit court had not reviewed the motion papers and ordered the parties to submit supplemental briefs, set a new hearing date for March 28th. So you still didn't get your hearing, either of you. So now it's set for March 28th. And I can identify, it's hard to get dates. So then you come back for March 28th and the circuit court doesn't take the matter up it orders the parties to go to mediation. And I never ordered mediation because I didn't think it was going to work, and it didn't. So the parties went to dispute resolution and made their effort, and they were unable to resolve it. So they informed the court on May 24th that mediation didn't schedule the matter. So it got adjourned all the way from May 22nd of 2024 to February 20th of 2025. I'm not sure what caused that lengthy delay. So then there was a hearing regarding Mr. Soltis's motion on February 20th. And the court took the matter under advisement on February 20th. So I guess as of today's date, 617 days after the motion was filed, we still don't have a ruling. I checked with the clerk. The ruling's not forthcoming. There's some other things that he's working on. And as I said, even if he denies the motion, you still have to take up all the issues that were removed to circuit court, not the least of which is the damage hearing. And you just raised an issue that none of us saw. I talked about interest rates going up dramatically from the time when this contract was to be entered until now. And none of us had the presence of mind to realize this was a non-homestead property. Mrs. Blair lives in Crown Point, Indiana, and this property's in Michigan. The O'Donnells also have an address other than this. The O'Donnells, as I understand it, wish to make this their primary residence. So, and this is a LT case. This is a landlord-tenant case, not a general civil case. And so I made a ruling on the specific performance, and I ordered, as I often do, escrow payments. And Mr. Soltis was right. It puts some skin in the game for the defendant. But under my naivete, I didn't think it was going to take 3 years to get to that point. We're not there yet, and it doesn't appear we're even close. I also ordered that they pay the taxes. Now, the payment, and it's in the pleadings, was under the assumption that if the specific performance was granted, those proceeds would be applied to the purchase price. So essentially, if the O'Donnells prevail, they were making a monthly payment each month. And if they prevailed, then that money went to Miss Blair as part of the purchase price for the house. If they did not prevail, then there were some decisions that had to be made about what happened to that money. But the purchase price was $450,000. The damages, I think, would argue to be offset the purchase price. So, for example, if Judge Stutzman found that the O'Donnells were $50,000 in damages, I just pulled that number out of the air, that would reduce the price by $50,000. So in September of 2024, our clerk, Tabitha Wedge, our district court administrator, spoke to that escrow payments. They made 12 payments of $2,000 each for $24,000. As the district court is no longer has jurisdiction in this case, the $29,000, the original $5,000 down payment, the 12 $2,000 payments were transferred to the circuit court for escrow payments. So it was after September, it was at that point your client stopped paying, is that correct?
I believe
I
so.
think it was September was the last payment.
I have a ledger from the district court, and that's what I really can't understand. I tried to have my clients get all of the payment history, but I don't know if he has made payments to the circuit court, because at a certain point,
No,
the
I
escrow
don't,
got.
I think once you got this letter, the payment stopped.
Okay.
I don't believe payments have been made to the circuit court. So there's even a question, Mr. Soltis, whether I have the authority over this. But right now, it's sort of a lose-lose proposition pending a decision in the circuit court. If the O'Donnells were to rent this house, I don't know, in this rental market, it would rent for $2,000 a month. If they were to purchase the house, I don't know what their plans were. I think when the interest rates were very low, I think their plan was to borrow the money and pay at 3.5% interest. Now that interest is much higher than that, I'm not sure what their plan was, but I'm not sure their payment would be $2,000 a month if they were to take out a 30-year mortgage. So it's expensive. It's well more than the rent was, because the rent was zero, based on the theory that at some point this property would go forward. But Miss Blair gets no benefit of this $2,000 a month. The $2,000 a month that was paid went into it's in the treasury of St. Joseph County. So she gets no benefit of it. She doesn't have the benefit of the use of the property. I'm assuming that the O'Donnells are paying the utilities and using the property. But I thought, all right, we'll get a hearing in September or October and this will be done. But without, as Mr. Soltis indicated, without consent of this court or the circuit court, they just stop paying. That is willful. And I wasn't even aware they had stopped paying. Again, things have been transferred to circuit court, and the circuit court clerk didn't call and say, hey, they didn't make their escrow payment. Had it been here in district court, our landlord tenant clerks, there are actually 3, maybe they have a hand in this. One of them, Lisa, was all over this during the time of it, and she was really on top of it. She probably would have come and said, hey, we didn't get the escrow payment, but it was transferred to circuit court. So I do find it's a willful violation of the court's order. The taxes are more complicated. As a practical matter, I don't know whether this would be a homestead property for the O'Donnells or not. It is not. These taxes are expensive. And nobody wants this house to be foreclosed on. So I find there is a willful violation of the court's order. The question is, what do I do? I have not discussed this with Judge Stutzman. The case is before him. And I did discuss it, sort of bounce some ideas off Judge Pattison, my district court benchmate. And I don't know that I come to the answer to that question. I do know we need to get the taxes paid. Now, to throw a further wrinkle in this, you're asking me to release the escrow funds to you, to the defendant, Mr. O'Donnell, and that was never my intention, that he'd pay 12 months of escrow and then I just give it back to him. Mr. Soltis makes a suggestion that perhaps you use the escrow funds to pay at least the 2023 taxes. But frankly, I don't think this matter's gonna be resolved by the end of this year, which means the 2024 taxes, we have $29,000 in escrow, and we have $19,000 worth of tax that needs to be paid. If the O'Donnells prevail and my order stands, but for specific performance, they get the benefit of having had their taxes paid. If for some reason Judge Stutzman views it differently, and then Miss Blair has the benefit of having had her taxes paid. As a practical matter, the O'Donnells are living in it. They've been in there in 2023, 2024, had the benefit of the enjoyment of this house at Quarry Lake. And presumably will have the same enjoyment in 2025. If it stops raining. And Miss Blair is frozen out of her property. I don't know what progress, if any, was made at mediation. You don't have to answer that. It's a rhetorical question. But, you know, if you were this far apart, maybe you got this far apart, but you didn't get to here.
I'll just add, Judge, there was progress. There was 2 other defendants in the case that those claims were settled with. So I would say we made progress in the sense that.
So it wasn't Mr. Verpalat and Karen Stiver
and Patrick Blair.
We're all, okay, well, that's some benefit. Mr. Hatch, what's your response to Mr. Soltis' suggestion that this escrow funds be used to pay the taxes?
Your Honor, I would just go back to the bigger issue that under the court specific performance order, Miss Blair is required to pay the taxes and she's required to receive no benefit of no lease payments.
That's not true. My order says the defendant is to pay the taxes.
That's correct.
The lease or that screwy purchase agreement said she's to pay the taxes, but my order said that the defendants are to pay the taxes.
And I think that lies, and again, I absolutely respect the court's order, that lies the confusion between one of the paragraphs. Paragraph 10 says, defendant counter plaintiff shall otherwise comply with the terms of the lease with option to purchase. So you look to the terms of the lease with option to purchase and it says, Miss Blair is responsible for the taxes and receives. And remember, my clients have already paid her $107,000 that this court has found.
Yes.
So, and then you juxtapose that with the other parts of the court's order. It says there's a $2,000 per month escrow payment. But again, that came from an order in May before the June order of this court, where we hadn't gone over and the specific performance wasn't awarded. So it's just, there's conflicting provisions, Your Honor. And I understand, again, everyone wants to respect the court's order. But under the lease with option to purchase, she is required, which the court order specific performance was, she's required for the taxes and gets no rents. I think everyone here wants the taxes paid. But my clients at a certain point, they have been so caught up between paying $112,000, litigating what I would say is probably the most expensive landlord-tenant case, not because of this court's fault or anyone's fault here, but because it was bifurcated the circuit court. We've been waiting. I mean, they have paid a significant amount of attorney fees to just regain possession of their property.
Well, I saw that clause in there where it said the court had not reviewed the pleadings, directed the parties to brief the issue. I thought, well, I wonder how much that cost.
We came 3 different times to the circuit court on a what I would say is a baseless motion. And if that motion gets granted, it's going straight to the Court of Appeals. So the circuit court does not have jurisdiction to hear
The way it works is that if someone doesn't like what the district court does, you appeal it, and there's a court rule, it's 700 that says, here's the time limit, so when you need to do it, and you go to the circuit court under an appeal. There's a specific form you have to do. It's an appeal that's like the Court of Appeals, but from the district to the circuit court. Mr. Soltis didn't do that. He just filed a motion to vacate all of the orders that negatively affected Ms. Blair. So again, more time, more delay for a baseless motion. We've got our order from this court that this court put in a very nice package to the circuit court, and nothing has transpired since that time. So they paid $107,000 to Ms. Blair to get the property that they were entitled to in the first place. They have tens of thousands of dollars. I don't even want to tell the court how much in attorney fees that they have at this point in time. And they have got no justice in the circuit court. Like I said in our brief, justice delayed is justice denied. At a certain point, I think it's Ms. Blair's contention that I'll just wrap them up and kill them through attrition, through the process of the court. And if they're required to pay more property taxes that she's required to pay under lease with option to purchase and keep paying rent payments that she's not entitled to, that might happen. Because at a certain point, they're going to say, we paid $107,000, we're paying all these attorney fees, we now have to pay property taxes that we were never going to pay in the first place, and an additional $2,000 per month in infinity until the circuit court makes a decision. And if they make the wrong decision, it goes to the Court of Appeals, and then they keep paying the escrow payment. So it's an impossible predicament.
Well, my vision would be if they prevail in my specific performance order, the property taxes would be reduced from the sale price under your damages claim in circuit court.
I think that's,
so it's not like they're paying now. If they pay the property taxes and they prevail, they get credit on the purchase price for the taxes. If Mrs. Blair pays the property taxes, then that would not be credited against the sale.
That's correct.
And so it's like, who pays now? But we haven't even got Mr. Soltis's motion decided. I think there's 8 issues that are before the circuit court, the equitable issues that were part of this claim. And those are tough things. I guess maybe Judge Stutzman's thought that perhaps the parties could come to some settlement had merit, but they haven't. And it's expensive to not do that. And that's sometimes what happens. The court moves so slowly, and I'll put myself in there with the court, that it is easier for the parties to just work something out. And it's expensive. All right, so why should I give the money back to your clients?
There is a provision in the order, Your Honor, that says the defendant counter plaintiff shall be entitled to application of the escrow funds currently held by the court. That is because, and I think the way this all transpired was, my vision is that there was an order in May of 2023 before this case was tried before this court on a bench trial. And it makes sense. I mean, if someone's in a property, you typically order escrow payments of monthly. So that came, and then we had a bench trial. And then the court ordered specific performance of the lease with option to purchase. I am as guilty as everybody else that when that was ordered, it conflicts with the specific performance order. Because if you look at the lease with option to purchase, they're not required to pay any rent, and they're not required to pay the property taxes.
And I was aware of both of those things. And that would be even worse if there was nothing. And the idea was the rent was zero, that she was going to pay the property taxes, and sometime within a certain date, within 90 days, they were to come up with a payment and close the deal.
Yeah.
And they were, I believe from the testimony, they were prepared to do that.
And they were ready to have their children move in, and they were going to make it their full-time residence. They had schools ready to go. All of that happened, right? And exactly what this court said, I thought this would be very quick. a transfer. We have liability established. There's a specific performance order. All the circuit court had to do was decide the damages with respect to one hearing about to offset the purchase price. That should have been that could have happened within 60 days. 617 days have transpired, and the court hasn't even entertained. I haven't taken any depositions. There hasn't been any hearing on that because Mr. Soltis filed a baseless motion saying the district court had no jurisdiction to do what it did. And again, those delays then prolonged 2,000 a month, 2,000 a month, 2,000 a month. Now 2 years of property taxes, not 2023 to 2024. My clients don't have the financial wherewithal to keep going through that. And I think that's at a certain point in time when they saw the conflicting orders between the specific performance or lease with option to purchase and the $2,000 a month, they said, well, we're complying with the order. We're not required to do this. And then everything just happened and really nothing happened. So what I would say, Your Honor, is that really there was the May order for escrow that was superseded by what I see as the specific performance order. My clients are not required. I mean, the reality is that if they don't make the $2,000 a month payment and they don't come up with the money, Ms. Blair keeps the $107,000. That's the skin in the game for them. So to be continuously contributing towards that payment, which they have no legal obligation to make under the contract, seems to be not benefiting Ms. Blair at all. She doesn't get the money. It hurts them. And there's no requirements. And then the property taxes, Ms. Blair's the landlord. It's a lease with the option to purchase. The tenant typically doesn't pay the property taxes, and it actually says in here the landlord pays the property taxes. Two more things I want to add, Your Honor.
Well, let's make that point again. Right now, their tenancy is under the color of the lease. I've granted specific performance, but it's been held in abeyance by Mr. Soltis' motion for rehearing. So they're not trespassers. They're on a lease, which granted was a screwy lease for zero rent, and she paid the property taxes. But I wanted, as Mr. Soltis said, it's a landlord-tenant case. You'll set up an escrow payment, and usually aren't this large. Rent's $900 a month. The tenant challenges the habitability of the premises. I do a $900 per month escrow order, and we resolve the case in 2 months. And I did that, you're right, in May, before we had the hearing in July.
And this is different, really. I don't mean to interrupt, Your Honor, but this is different because typically in a normal escrow order, the tenant had not already paid $107,000. They've in essence prepaid years of rent by the payments that they've already made to Ms. Blair. So again, that's another distinction. You know, they're a piggy bank here, and they paid Ms. Blair the money. She has not allowed them to be in the property. The court fixed that issue. And then now she's saying, keep giving me money and pay my property taxes until the circuit court does what the circuit court will do. And we find out how much money, if any, is owed to her under the purchase price, and to convey possession of the property and title of the property to my clients if they choose to get a loan to close on it.
Well, right now, Ms. Blair isn't getting a penny.
Right.
She's not getting the benefit of the $29,000 it was paid, and she's not getting the taxes paid. And had the sale gone through and the O'Donnells made this their primary residence, they would have been eligible for the homestead exemption, and the taxes would be much less. So we're talking, before we're done, probably tens of thousands of dollars difference. All right. I don't think the answer is releasing the money to the defendant. We've got several options for it. Mr. Soltis, what's your response?
My response, Your Honor, is talk about baseless motions.
Yep, no problem.
Mr. Hatch's motion is definitely baseless
Well, the motion to give them the money back?
to release.
Yes.
First of all, it doesn't make a whole lot of sense. Number two, there's no reference to any legal principle, case law, whatever, that would support.
Well, your brief said, I don't cite any authority because nobody cited me any authority.
Right, so there is no authority for them to get this money back. And Your Honor, we've kind of talked around it. If you have the actual lease option, which Mr. Hatch says, well, that says landlord shall pay all the taxes. And in one section it does. In another section, it doesn't. It says the tenant shall pay the taxes. And this was a contract that was drawn up by Mr. O'Donnell. And
What section you're talking about?
Maintenance, right there.
Where?
What paragraph are you referring to?
The maintenance section, I believe it's on page 2, halfway down.
Maintenance. Landlord shall have the responsibility to maintain the premises in good order at all times and perform all repairs necessary to satisfy any implied warrantability or habitability, except that tenant shall be responsible for taxes, electric, gas, water. Standard upkeep of repair. Tenant must notify the landlord within 24 hours of any condition requiring maintenance. I'm looking for the clause that says the plaintiff shall pay the taxes.
It's about 2/3 of the way down.
It's under taxes, Your Honor.
Oh, there it is, right there. Landlord shall pay all real estate taxes which be levied against the premises. Oh, boy. Yeah, it looks like they didn't really want to put taxes on that line, but they did, and so that's what it says. So you're right, in one paragraph, it says the tenant shall pay the taxes. The other paragraph says the landlord shall pay the taxes. Now, things were supposed to happen. It's mostly all in the first paragraph. This is a lease with the option to purchase. The parties have paid Rosemary Blair $85,000 of the $450,000 purchase price. The parties have agreed that the tenant's purchasers will have a reasonable time to secure the remaining $365,000 for purchase. Rosemary Blair shall also be granted reasonable time to get her finances in order. And this is what was supposed to trigger it. Once Rosemary Blair informs Mr. O'Donnell and Miss Bowers she's ready to close, the purchaser shall have 3 months, 90 days to close. In the event that there is an unforeseen delay for any reason, the purchaser shall pay $1,000 per month. So there was sort of a built-in escrow until finance is secured. This agreement includes all real and personal property and surroundings. And then down at lease payments, defendant shall pay to the landlord monthly installments of 0 on the first of each month. So it was clearly envisioned that this was going to happen quickly. It was signed in way back in November of 21. All right. Then, does anybody have an opinion whether I even have authority to deal with this? District court is no longer in jurisdiction of this case. The $29,000 have been transferred to the circuit court. And so all the damage issues are in the circuit court. Heaven forbid if we throw one more thing on the pile in circuit court. I'm not sure what that means.
Judge, in full transparency, I think that you do have jurisdiction. There was an issue with, I think the circuit court thought all of the claims were transferred up to the circuit court. By the order of transferring specific claims, not all the claims are transferred to circuit court. You retain jurisdiction over specific performance, summary proceeding, which you would have to because you have exclusive jurisdiction over it, and quiet title.
All right.
So you do have those 3 claims still down here. And that was clarified with the clerk's office because in the order transferring it, we said the specific claims that were transferred, but we didn't specify the claims that stayed down here. But I do believe that you, in full transparency, do have jurisdiction over those 3 claims and then the order you've entered in this court.
All right. Mr. Soltis, anything you wish to say? You're still there at the podium. But yes, you pointed that out, and I've probably read that agreement 20 times from the beginning till now, and
I may have missed it in the beginning too, Judge, but on closer examination, it is what it is. And Mr. O'Donnell prepared this agreement. Now, if there's ambiguity in a contract, the general rule is that it's had to be held against the drafter. In this case, Mr. O'Donnell. I'm not sure this is an ambiguity as opposed to a direct conflict. And yeah, I don't know if we should, I don't think we need to have a trial to make that determination, because then we'd have testimony and parole evidence would be appropriate. But the long and short of it is, we're just talking about your order of July 31st. And counsel says, well, because you granted specific performance, that somehow abrogated the escrow order. Well, specific performance was number 1. Down the page was the specific, was the 2000 escrow. Same order. So the long and short of it is, Your Honor, you ordered this, and apparently they believed you had jurisdiction. And second of all, they never even raised this up. They paid $2,000 a month for maybe 24 months or 12 months, and then stopped altogether. And they could have very easily come back to this court and said, hey, listen, we don't think you have jurisdiction, or maybe this is too high, you should modify it, or any kind of motion. They just let it go, and then they stopped paying. And that's what we're here for, is because you made that specific order. Just like you made the specific order that day to pay the taxes.
Well, if you hadn't filed the motion, I wouldn't have known it.
Right. And I didn't know it until I checked. And the bottom line is, Mr. O'Donnell and Ms. Bowers have not lived in the property. I mean, I don't think they can get a homestead exemption anyway, because they both have two houses as they testified in front of this court. So they're, and they've never stayed there. They haven't taken care of the property. The property is going to.
Now, I don't know any of that.
Those are misrepresentations.
Well, they certainly have right to exclusive possession of the property. And, this was real people. Their kids got put in different schools. It was very stressful on their relationship. It was, a financial hardship. She had to go back and live with her parents. And it was very disruptive to everybody's life, Miss Blair's and theirs. They simply want to complete the purchase of this house for the agreed upon price of $450,000. What does your client want?
Well, Miss Blair wants to sell the house because she's agreed to that. $450,000 minus the $107,000 that this court already held, minus whatever they would get maybe in circuit court, and the escrow money. That would all be applied, and that would reduce the amount.
All right, so you simply want a ruling from the circuit court that says how much damages are so they can complete the sale.
Well, I think everyone agreed on that.
Everyone agreed on that until Mr. Soltis filed a motion saying that the district court doesn't have jurisdiction.
Well,
Your Honor, that is a complete misrepresentation.
I haven't reviewed the motion, and fortunately, I'm not going to be the one that has to decide it. But according to your representation, you essentially want the same thing they want, is a decision from the circuit court as to how much. Miss Blair, are you 84 now?
Yes. I wished I could talk once, and I've never been able to. And I'm very frustrated.
All right, well, you're not giving testimony at this point. We're just doing argument. And yes, I know you're very frustrated.
Beyond belief.
But there's enough frustration to go around. I think we've all got plenty of it. Okay.
Your Honor, all we're asking is that you enforce the order that you made on July 31st, 2023, $2,000 a month, and they pay 23 taxes. And just to clarify, or actually tell the Honor that Mr. Hatch's representation to the court that I filed a motion that says you don't have jurisdiction. I said, no, the court, you didn't have jurisdiction over the claims that were in excess of 25,000. That's the only motion that's in front of the court of circuit.
All right, well, we'll leave that to them. Okay, I've got a solution that probably isn't ideal, but I want to keep this case moving. I was looking for just a conclusion to this thorny, difficult issue for the O'Donnells and for Mrs. Blair. I was trying to get the case to the finish line, and there was a lot of headwind we went against, but I made a ruling. And the defendant is not in compliance with my ruling. I do agree with Mr. Hatch that the court has retained the summary disposition, summary proceedings portion of this. So this may be kicking some of these issues can down the road. Mr. Hatch, I'm going to ask you to do the order. I'm going to order that the 2023 taxes of $10,428.52 be paid from the escrow funds currently held by the circuit court.
What was that amount, Your Honor? I'm sorry.
$10,428.52.
Your Honor, the number that I have ends in July, so there may be more, so if you would just.
All right, pay the 2023 taxes.
I appreciate that, thank you.
All right. That can be sorted out when the property is sold. Either it'll be deducted from the sale price or it won't. Judge Stutzman can determine that as damages. I find the defendant has violated my escrow order, but I don't know what the proper sanction is. The tenant agreement that they had was if things went sideways, they would pay $1,000 per month. So I'm gonna enforce my escrow order. But I'm going to amend the amount to $1,000 per month commencing May 2025. I'm reducing it by half. I'm not doing any sanction for the money that was missed. Miss Blair doesn't get this money anyway, at least not yet. She certainly, I'm sure, could use $2,000 a month. And she could certainly use the proceeds from the sale of this property if we could ever get it sold. So the agreement is contradictory, the original buy-sell agreement. One portion says the tenant shall pay the taxes. I think that's a mistake. But as Mr. Soltis indicates, the mistake goes to the drafter. And then it also says that the landlord shall pay the taxes. I ordered that the defendant should pay the taxes. And we'll use the escrow money to do it. And then the escrow order will commence beginning this month, $1,000 per month, paid in escrow to the circuit court clerk. I don't know when your ruling is forthcoming regarding the jurisdiction issue. If you prevail on the issue, Mr. Hatch, there's still all the other issues. You guys had hoped they would be simple. One thing you could do is if you could come up with a figure between the two of you, this is what we believe the damages are, Judge Stutzman. We would like you to order damages in this amount, and then we can execute this sale. I believe my ruling for substantial and the order that the defendant complete the sale was appropriate. In fact, we didn't, I guess if your motion is just regarding money, then the specific performance is still there. We need to get to the finish line. I don't know if the circuit court will order a transcript of this hearing also. I'm not sure. I'd like to see the case move forward, but for purposes of both motions today, your motion to release the funds to the defendant is denied, but they shall be released to the clerk to pay the 2023 taxes. Now, 2024 is still looming, but I'm not going to make a ruling regarding that pending the circuit court moving forward in this case. But my fear is you guys aren't going to be back in circuit court for a number of months. And I haven't been out there. I have family at Quarry Lake and I've seen the property and but I haven't seen it in a couple of years. But life goes on. their children are getting older, may have changed jobs, or I don't know what the nation of their relationship is. Miss Blair's had 2 more years pass in her life. And this property's sitting there. I hope it's not got foot-long grass and raccoons in the eaves, but they should have some skin in the game, and right now there's none. So $1,000 a month starting May 1st. We're gonna use the escrow money to pay the 2023 taxes.
So just so I understand it, as far as the months that were not paid prior to today's date, that's
There's
water
no-
under the bridge.
That's water under the bridge.
Okay, so $1,000 per month into the circuit court on the first of each month is my understanding. Okay, and then 2023 taxes, I guess that would be put into an order so that the circuit court will know then to release the proceeds to pay those taxes.
Yes, it'd
Okay.
be a lot easier if it was still in our court, but
Yeah.
the circuit court clerk shall release those funds to pay the 2023 taxes.
And then the court also mentioned that the 2023 taxes could be offset from the purchase price. Would you like me to put that in the order as well?
That may be a damage question for Judge Stutzman.
Okay.
That's my view of it. He may have a different view. You're certainly free to argue that.
Okay. All right, so just for purposes of the order, 2023 taxes will be released from the escrow that's already held by and it's held by the circuit court, I believe.
It is now.
Okay.
Well, actually, it's probably the county treasurer. I'm not sure, but the treasurer could take it out of one pocket and put it in another pocket, but it will get the taxes paid. Nobody wants this property foreclosed on.
And $1,000 per month starting on May 2025.
Yes.
Okay, understandable.
Mr. Soltis, anything further?
Nothing further at this time, Your Honor.
All right. I wish you all the best in circuit court, getting a hearing date and getting some things. I certainly sympathize. These aren't easy issues, but the parties want to bring this to a close, and I don't blame them. All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
All right, we'll be in recess. I'll be gone for a few days, and Laura will be here watering my plant. All right, thank you all.
Thank you, Judge.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon.
Right, okay, thank you. Welcome.
All right, good afternoon, everyone. Good afternoon, Ms. Stiver.
Thank you.
I certainly would have been willing to have you right here in the courtroom, but if there's any need for you to consult with either of the lawyers, we can make that happen.
Okay.
Through.
Is Matthew Hauser there?
Not yet.
Yeah, okay. I did not know. I had not talked to him in several months, so I didn't know.
Okay, no, he's not.
Okay.
All right, Mr. Soltis is here, however. All right, let me call the case. This is entitled Rosemary Blair, Plaintiff Counter Defendant versus Joseph Bowers and Carla Bowers, Defendant Counter Plaintiffs. The original district court file number, and this is so embarrassing, is 221862 LT. This case has been going on since 2022. My order was in May of 2023, and here we are 2 years later, kind of still spinning our wheels.
Yeah.
The actual reason for this hearing is a motion to withdraw as counsel filed by Mr. Hatch on behalf of the defendant, counter plaintiff Joseph O'Donnell and Carla Bowers. They are not present. I frankly hope that they would be here. This matter was on appeal in the circuit court for some time, and a decision was made on July 16th let's see who this is. And actually I heard about it either by phone call or email or something while I was at Mackinac Island. And then the actual order entered August 5th. Judge Stutzman's order regarding the appeal. Someone has joined us by telephone. Who's with us? Who am I speaking with?
This is Carla Bowers.
All right. Let me give you a name. The parties here now, Daniel Hatch is here on behalf of his interest, on behalf of Joseph O'Donnell and Carla Bowers. It's his motion we're about to hear. Robert Soltis is here for Rosemary Blair. Robert Soltis was not original counsel. I think he was actually number 4 in line for Rosemary Blair, but I will say things got maybe a little more focused once Mr. Soltis came. At any rate, I learned that Judge Stutzman had issued an order. I didn't see the order till I got back. Then I attempted to set this for a hearing quickly, but I was gone and then the parties were gone and somebody went camping, or I don't remember exactly what happened, but we ended up with today's date on the hearing for Mr. Hatch to withdraw. In my original order back in May of 2023, I was trying to issue a practical order that would bring a conclusion to the matter. It was appealed, and as indicated, it was on appeal for quite some time. Judge Stutzman's order that is issued August 5th says, it is hereby ordered that Rosemary Blair's motion to set aside judgment and certain orders entered in part by the district court for lack of subject matter jurisdiction is hereby granted in part. Specifically, the default that was entered in count 1, 3, 4, 7, 8, and 9 is vacated and is in no force and effect. I didn't think I did a default in those matters. My order transferred jurisdiction on those counts to the circuit court. So I don't believe they were defaulted. They were just transferred to the circuit court because of the subject matter jurisdiction. Then it goes on to say that count 1, 3, 4, 7, 8, 9, 10, and 11 have been transferred to the circuit court and no findings have been made with respect to these claims. So those matters are still pending in the circuit court. And it's difficult to know exactly what's what by just referring to them as counts, but he further orders that count 2, 5, and 6 of the counterclaim remain with the district court, and the district court retains jurisdiction of those claims. He goes on to say that my order of July 31st ordering Rosemary Blair to return personal property is vacated, as he believes I did not have the authority to do that. But counts 2, 5, and 6 of the counterclaim remain. He's referring to my order of, I'm not sure our dates match, but I'm referring to my order of
It's July 31st, Your Honor.
Yeah, July 31. On its face, it says May 22nd, but it was actually signed on July 31. As to count 2, specific performance, here is Joe O'Donnell, late to the party, but he is here. Good afternoon, Mr. O'Donnell.
Good afternoon, Your Honor.
You're a little late to the hearing. I've been reciting some of the history of the matter, but Mr. Hatch is here and Mr. Soltis is here.
Oh, I'm sorry. I thought it was 120.
No, it was 115. At any rate, my original orders, count 2 stands. Specific performance. It is ordered that Blair shall deposit $5,000 to be held in escrow for consideration of the lease with option to purchase. It is further ordered that the defendant counter plaintiff shall be entitled to application of all escrow funds currently held by the court. It is further ordered defendant's counter plaintiffs shall continue to make payments consistent with the escrow orders, $2,000 per month, and that has been modified. Defendant's counter plaintiff shall pay the 2023 property taxes relating to the property. And the other counts, as I indicated, were transferred to the circuit court. I also ordered that in May that defendant was entitled to specific performance of the contract. So Mr. O'Donnell, Mr. Hatch has filed a motion to withdraw as your lawyer. He filed a similar motion in circuit court that was granted. I waited until Judge Stutzman ruled on that matter until I ruled on this matter. Before I let him out and ask you about that, I want to ask both attorneys, Mr. Hatch, what is your understanding of the current posture of this case?
I think the court did a great resuscitation of where we're at, Your Honor. I can just clarify with the actual names of the counts that were transferred to the circuit court and those that retain in the district court. The order entered by Judge Stutzman on August 5th was really what I see as a clarifying order more than, well, first, Mr. Soltis never filed an appeal to the circuit court. He filed an actual motion once the claims were transferred to the circuit court, which is distinct from an appeal, which was one of the arguments that he missed the deadline to appeal the district court's action, except those for subject matter jurisdiction. So really, I see Judge Stutzman's order as clarifying. And I agree, count 1, 3, 4, 7, 8, 9, 10, and 11. To the extent a default was entered in those claims, that default was set aside by this court, and those claims were then transferred to the circuit court. So I don't really see that as overturning any actions of the district court, because count 1, 3, 4, 7, 8, 9, 10, and 11 are in the circuit court, and those were transferred without a default being entered. Count 1, 3, 4, 7, 8, 9, 10, and 11 in the second paragraph, it just says what we effectuated in the district court, that those were transferred to the circuit court. That's the second paragraph of his order. And counts 2, 5, and 6, it just clarifies that those remain in the district court and that the district court has jurisdiction over those claims. Count 2 is specific performance, which is what this court's July 31st, 2023 order after our bench trial relates to. Count 5 of the counterclaim is summary proceeding for possession of property. Obviously, the district court has exclusive jurisdiction over that claim and retains jurisdiction. And count 6 is quiet title. So specific performance, count 2, summary proceeding, count 5, and quiet title, count 6 remain in the district courts, pending in front of the district courts. The order goes on. The only thing that I really see that Judge Stutzman did to overturn or affect any orders of the district court was the last paragraph where it states that the portion of the court's July 31st, 2025 order, which was the order after we had a bench trial in this case, that requires Rosemary Blair to return all personal property identified by Joseph O'Donnell and Carla Bowers, is vacated. He felt that the district court did not have jurisdiction. We've gone through that, but just for purposes of the record, I do want to note MCL 600.8303 states The district court shall have the same power as the circuit court with respect to civil actions to recover the possession of goods or chattels. We feel that that is very clear that the district court has jurisdiction to order the personal property, goods or chattels to be returned. But that is what Judge Stutzman ordered. So that's really as far as his August 5th order.
Well,
the only thing
that wasn't the first time I'd ever made such an order. Sometimes it comes up as an ancillary issue, but he saw it differently than I did. So I'm bound by his order. But as a practical matter, has all that property already been turned over?
None of it's been turned over.
Okay, so so now they don't have to because of Judge Stutzman's order.
Right.
Your Honor, if I may, I disagree with Mr. Hatch in the extent that Mr. O'Donnell and Ms. Bowers have possession of 2 boats. One pontoon boat, the other one is, I'll call it for lack of other word, speedboat. And those have been in the possession of Mr. O'Donnell and Ms. Bowers after this court made that order to turn them over. So they've had possession. Rosemary Blair has not had possession. We don't know where they are at this point, frankly, but.
Let me stop for a minute. Let me stop. Don't say anything at this point. Yeah, well, I believe I have the authority to make everybody give this stuff back. Now, those are a little different because those items are titled. A paddleboard or a canoe or a kayak or furniture is not subject to title. Those items are titled and they actually belong to the title holder. But all right, so nobody got their stuff back while this matter was pending. And now Judge Stutzman said that portion of my order is vacated. So there's no order regarding that. All right. The matters that are in circuit court, are they still lingering there? Or have those been resolved? Are there these 6 counts still in circuit court?
They have not been resolved. As I recall, correct me if I'm wrong, Mr. Hatch, is that Judge Stutzman allowed Mr. Hatch to withdraw and gave Mr. O'Donnell and Ms. Bowers 60 days to either find new counsel or appear on their own behalf. That 60 days will be up about October 2nd.
Correct, Your Honor. The last paragraph of the order granting my motion to withdraw in the circuit court requires Mr. O'Donnell and Ms. Bowers to file appearances in the circuit court action either through an attorney or in pro per within 60 days. And then also provide their information like their address, phone number, and email, not by way of the order, but just to the court. So it's not public record.
So those matters are still in circuit court and our matters are still in district court. Ms. Bowers, I can't see you, but I know you're here. Mr. O'Donnell is here. I'll ask you first, Mr. O'Donnell, what's your position regarding Mr. Hatch's motion to withdraw?
Well, I mean, I believe Carl and I both agree that we really are kind of just still like in awe and not really knowing what's going on. And I mean, we still need time. And I understood the circuit court judge is 60 days. And, and we've just been trying to figure out what's going on. And we still don't fully understand the case. And, our biggest concern right now is that we're not going to have any of these files and stuff. And Judge Stutzman made it sound like we have to redo the whole trial, redo everything. And now I don't know, we never got copies of anything, of any of the motions or any of that stuff. So we don't really have, copies of anything. So we're gonna have to start all over. And, and the cost bearing of all that stuff.
Well, certainly he will provide everything. But my fundamental question is, do you object to Mr. Hatch withdrawing?
I mean, yes, just for the fact that, I feel like that we're in so much trouble without him because he's the only one. This case is so thick and so complex and so detailed. And I don't even understand him. We relied on him implicitly for everything. And now it's kind of, I don't know what to say. It's just, we're just in the worst.
All right, well, let me ask Ms. Bowers, do you object to him withdrawing as well?
Absolutely. I don't, honestly, there's no way we can afford to have this case start over. We're just getting screwed left and right here on this house.
Well, I don't propose to start over again. What I would like to do is get at least the district court portion of this case to the finish line. I'm ashamed of the legal system that it's taken this long to try to resolve this case. Now, most of the things that I do in
Can I also say, like, this is a very, very big financial burden because there's a whole nother house, a whole nother property.
I understand, which is why we're in the posture we're in. So when the case takes as long as this has to resolve, it costs everybody a bunch of money, not to mention Rosemary Blair and her family. They've paid 3 attorneys, now 4 with Mr. Soltis. The property status is still unclear. I haven't been out there. I heard the place is not looking good. I was told it looked like it was abandoned.
The docks of the water and everything, Your Honor.
Okay. We heard all the testimony. I was not pleased with the way this happened. The zoning officer came in there and did a summary immediate eviction of Mr. O'Donnell and Miss Bowers. They had to move, the kids had to change schools. It was a financial strain on both of them, on their finances, on their relationship with their family. Miss Blair either wanted to complete this sale or get the property back so she could sell it. The world is different now than it was in 2022 and 2023. Interest rates were at 3.5%. Property values have gone up since then. Interest rates are now substantially higher. The parties had to pay escrow. Somebody had to pay the tax. It was a non-homestead property. So yes, I'm aware this was hard on everybody, and I would like to get some sort of resolution of it. Judge Stutzman referred the matter to mediation, which I didn't think was going to be successful, but I think they do that in every case, and that was part of the delay. Might be ready for mediation now, but at that point, they had my order, specific performance. They're ready to pay the price, apply the escrow funds, and the money was paid to the purchase price, take out a loan for the balance, and take title to the house. Miss Blair would have gotten several $100,000. O'Donnell and Bowers would have had the house, and there would have been closure, but it didn't go that way.
Your Honor.
So what I don't want to do is fight about it for 5 more years. So Mr. Hatch, I share some of the same concerns they do. You filed a lot of extensive pleadings, claims, counterclaims, multiple counts, multiple theories. They're not attorneys. This has to do with whether you're being paid for your services. So Mr. O'Donnell and Miss Bowers, this isn't a court-appointed attorney case. You hired Mr. Hatch to represent you in this matter, and he represents that you failed to pay him or even have much contact with him. And he feels because of those reasons, the relationship, the attorney-client relationship is broken down. So he asked to withdraw. Now, granted, whoever would be willing to take this case, bless them. Mr. Soltis was willing to dive in the middle of it, but I'm not sure anybody else would want to get into this case. It would be very difficult for you two to represent yourself in a pro pers situation. Mr. Hatch, have you and Mr. Soltis, I'm sure you have, talked about trying to get some resolution here since Judge Stutzman's opinion?
I have not, Your Honor. Since Judge Stutzman's opinion, because the motion granting my withdrawal can't talk to him about the claims in the circuit court case because I don't represent Mr. O'Donnell and Miss Bowers anymore. Those are really the pending claims, really. I mean, I think this court did an incredible job for the bench trial that we had, putting this on a nice silver platter about trying to wrap it up. And specific performance was granted. We have an order on who gets the property and when. That's contingent upon, you know, a payment of the remaining balance of the lease with option to purchase. I'm not calling it a land contract anymore. Mr. Soltis doesn't like that. So
Thank you.
yes, no problem. The issue is that I don't represent Mr. O'Donnell, Miss Bowers with respect to the bigger issue, which is the damages that they assert against Rosemary Blair that are through counts 1, 3, 4, 7, 8, 9, 10, and 11 that remain in the circuit court.
And the issue with that, Miss O'Donnell and Miss Bowers, is that you were hopeful to offset the purchase price by a damage award on your claims in the circuit court. And so let's just pick a number out of the air. Let's just say circuit court granted $50,000 in damages. That could have been applied toward the purchase price and would reduce the price. Those claims are not going to be resolved anytime soon. My order, and we're going to have to look at timeframes, that you purchase the house for the agreed upon price with the set off of the money that's already been paid and the escrow money stands. So you and Miss Bowers, you and Mr. O'Donnell are going to have the opportunity to purchase this house under that original agreement to purchase it. The time limits have all expired, so I'll set some sort of time limit. One of your remedies is to buy the house for that price. I ordered that she sell it at that price. Then you could continue your fight in circuit court regarding money damages. Mr. Soltis, do you agree with that analysis?
To some extent, Your Honor, basically, yes.
All right.
What happens if $1,000 lien that's against the house that she was not forthwith coming about?
Say that again. I didn't understand what you said.
$186,000 outstanding in her federal tax liens against the house right now. It's almost $200,000. I went to the courthouse, pulled it up like last week.
I was not aware of that. $286,000.
180. No, it's 187,000. I think it's higher than that now, though. But that was just the ones I could pull up that weren't. That's for federal tax liens she's had on there starting in like 2009 or something like that, or 8. And they're all on there. So they're all on that property. I don't think that those federal tax liens, I think, stick with the property. And they have to be for the property to pass title. You have to pay those off.
Judge, if I could just add, I think that as far as the dates go about when Mr. O'Donnell and Miss Bowers are bound to purchase the house under your order, I think that is necessarily tied to the circuit court action because on page 3, it says it is further ordered that when a damage figure is established by the circuit court, defendants counter plaintiff shall have 90 days to execute the option to purchase and the lease.
Right, so 90 days from the decision of the circuit court. And I'll be retired before that happens. I'm not being flip. I'd stay longer if I could, but the Supreme Court tells me I have to go next December 31. And Mr. O'Donnell, you may have to make the hard decision and Miss Bowers, the reason I can see him, I can't see you. All I see is a silhouette of a icon of a telephone. So I tend to address him because I can see him, but I understand that you're also there. This is the first I've been aware of this tax lien question. She can't give you title to the house absent the tax lien being cleared.
I think
Ms.
that's
Stiver, do you have
ICJ.
any knowledge? Just a minute. Ms. Stiver, do you have any knowledge of any of that stuff? Ms. Stiver, can you hear me?
Yes, I'm sorry, go ahead.
Are you aware of those tax liens?
No, I'm not involved in all that, nope.
Mr. Soltis, were you aware of it?
I was aware there were tax liens, Your Honor. I didn't know the amount.
So again, I would still like to find a solution to this problem that doesn't cost tens of thousands of dollars of legal fees for the plaintiff and the defendant. I'm not sure that's possible. I had ordered specific performance. Mr. Hatch prepared the order and he reminded me that that specific performance is attached to the circuit court damage hearing. I suppose. All right, the purchase price, as I recall, was $425,000.
$450, I believe.
$450.
I think.
Mr. O'Donnell, I don't have that order in front of me. $450. And that was $425.
Could have been, I don't remember.
$450,000, Your Honor.
All right, he's right. So there was $107,000 and then whatever's been paid into escrow. So it's probably about $300,000 to complete the sale of the property. But somehow the tax lien has got to be lifted before she can give you title. I'm not sure. It's a federal tax lien. I'm not sure what that's all about.
Income tax.
All right, so the question that's before us today is, does Mr. Hatch get to withdraw? Have you, Ms. Bowers, or you, Mr. O'Donnell, consulted with any other attorney?
Not yet, Your Honor.
I can afford another attorney. I mean, not to restart this. I mean, I don't know what I'm gonna do, but no, I haven't.
And you're right. No attorney's gonna want this. Your last attorney withdrew because he didn't get paid, or asked to withdraw because he didn't get paid.
He got paid quite a bit.
Yeah, well, I understand. I think the bill is much higher than you originally thought it was going to be when you got into this matter. I don't want to necessarily know what it is, but I'm understanding it's probably substantial. A lot of time and effort has been put into this.
We have paid a lot so far. It's not like we haven't paid anything.
I understand. You paid substantially. I had a murder case once where I was prosecutor at the time. They hired a firm from South Bend that was quite renowned and expensive and paid a substantial retainer. And they did some exhaustive pretrial work, used up the retainer, moved to withdraw, and a public defender got stuck with the case for $5 and tried the murder case, and she was convicted, and they drew a substantial fee for the work that they had done, but withdrew before the case went to trial. So Mr. Hatch did a nice job of setting out the standard in his brief. In addition to the issues regarding payment, it appears there's just also been a further breakdown of the relationship with lack of communication and lack of contact.
Your Honor, there's no communication without payment, so that's the problem.
Yes.
We tried communicating, but there was no, unless we paid, there was no communication. That's what we were told. You know, are you going to pay or we're not going to talk to you? Okay. They know we don't have the money.
It's not true, Your Honor, but I'm not gonna get into that on the record. And I'm not gonna betray client confidences, and I would instruct Mr. O'Donnell and Ms. Bowers that to maintain the attorney-client privilege. If you want to waive that, then you can talk about what you and I talked about on the record.
Well, all right. Mr. Soltis, I didn't ask your opinion. This sort of isn't your fight, but you're entitled to give me your thoughts on this motion.
Your Honor, I have no dog in this fight. I'm just an interested observer.
You sort of do. Absent counsel, you're going to be dealing directly with Carla Bowers and Joe O'Donnell, who don't understand the law and don't understand the complicated circumstance they're in. And it's going to be a lot more difficult for you without counsel on the other side. But certainly you've been in the same circumstance where you've had clients that weren't able to pay for your services. So if I do grant the motion to withdraw, I don't believe you're going to have counsel. Counsel is already withdrawn in the circuit court. I'm stuck in neutral in the district court because I can't do anything until there's a ruling on the damage hearing in circuit court. And you two are going to have to present your claims in circuit court for damages. And they're hard enough in district court. They're harder still in the circuit court. You'll be acting as your attorney, asking for tens of thousands of dollars worth of damages to be offset against the purchase price of this house and my specific performance order. Mr. Hatch or Mr. Soltis, do you see any path to the finish line? When Miss Blair was last here, she said, I just want to get my money and get this matter over with. And I know this has been very frustrating for her. And she's probably close to 90 years old. And this has been a difficult process for her as well. Just a minute. Mr. O'Donnell, I'm not going to do this while you're driving.
I was just moving across the parking spot, Your Honor. I'm not on the road.
All right. Are you at the airport?
No, I'm in Chicago.
All right. Yeah, I don't want to do it while you're driving.
Oh, I wasn't driving.
Okay. So let me ask that question again. I'll start with you, Mr. Hatch. I'm not telling you that you don't know. The O'Donnells are going to be floundering fish out of water. Mr. Soltis is going to have to deal with that on behalf of his client. My summary disposition order, my specific performance is in effect. Is there some way we could agree on terms of purchase and transfer of this house?
I would like to, Your Honor. I think my clients would be open to that. We've posed that option at the mediation that we were ordered to go to in the circuit court. And I actually think that was a good use of our time because we resolved our claims with Mr. Verpalot. We resolved our claims with Ms. Stiver and Mr. Patrick Blair.
Can I say something? I don't know if you know it. Patrick passed away.
Yes, I'm aware of that. Somebody provided me with the death certificate.
I did. He died in June 16th. He had a tumor on his brain.
He was your brother?
No, he was my significant other. I was married and I divorced him and then we got back together. Okay. So I was taking care of him from he got released February 21st and he passed away in June 16th.
I'm sorry to hear that, Ms. Stiver. I
Sorry
didn't
about
know about that.
Yes, it was not good. It was hard, very, very hard, and I don't wish this on anybody. Because I took care of him. I had hospice come in and everything in my home,
Okay.
okay?
All
Wanted you to
right.
know.
So, good. That's good to hear. Because now we're just dealing with the sale of this house. Anyway, you were starting to say there was a proposal that was put forward at mediation.
And it was, obviously there's rules that protect communications during mediation. All I say, Your Honor, is you can't force snow to go up. We've tried to resolve this in many different ways, shapes, and forms that I think that were very reasonable. But we have not been able to come to any agreement with respect to what the purchase price is, how to transfer the property, what property is to be transferred between personal property and returned, or where that might be. So we've given it the college try, but I don't see, unless things have changed since mediation, I don't see a path forward without, the circuit court calling balls and strikes as far as damages, and then it being, that damage amount being transferred back or offset from the purchase price pursuant to this court's order of July 31st. But I'm open to it, Your Honor. But again, at a certain point, I think we need to, I'm happy to try to resolve this with Mr. Soltis, but the fact remains that we filed a motion to withdraw under Rule 1.16 because there has been no payment and it is unreasonable financial burden on my firm. My hands are tied. I like Mr. O'Donnell. I very much like Miss Bowers. I tried this case for them. They became friends over this period of time. I understood probably one of the most difficult, parts of their life. And I think I represented them zealously in the bench trial in the district courts. We had some significant briefing in the circuit courts. Miss Blair doesn't go down without a fight. But the fact remains is that I am not on this case pro bono. If Mr. O'Donnell, Miss Bowers don't have the financial means to pay for a lawyer, there is legal services of West Michigan and Southwest Michigan that they do need to qualify based on income requirements. But they need to make a determination about what they want to do with this case moving forward. And if they want me to represent them, which I would be honored to do, to continue on this case, they need to pay my outstanding fees because my firm will not continue to let me represent them. And I'm not going to get into it, but it is a significant amount of outstanding fees that have not been fulfilled. And under the applicable rules, MRCP 1.16 and the Court of Appeals, that says this court can look to the model rules of professional conduct to determine whether or not to grant a motion to withdraw. We would submit that there are grounds to withdraw without payment, and there has been no payment.
But Your Honor, there has been payment, like more payment than is owed, if that makes any difference. We paid more than we owe.
Yes, but I understand. You paid a significant amount of money. I won't probably disagree with that. But once the matter got transferred to circuit court, there was an appeal, there were further hearings, there was a lot of there was mediation, there may have been some depositions. The bill didn't stop. If it had been resolved with my ruling, the bill would have ended then and that would have been done. But it wasn't exactly appealed, but the matter was asked for further hearing in circuit court. And it was going to go to circuit court anyway, because the whole other issues of damages and the other things that district court doesn't have jurisdiction over, it was going to circuit court no matter what. And Mr. Hatch doesn't work for free, and his law firm doesn't work for free, and his partners in his firm are saying, what's going on with this case? And here we are. So Mr. Soltis, some time has passed since that first attempt at mediation. Mr. Hatch thinks they went as far as they could without getting there. Do you have any thoughts on that?
Well, the only thing I can say is Mr. Hatch and I disagree on what is reasonable. And I don't think that will change.
And there's this issue of the tax liens. Let's assume that there's no damages. So about $300,000 is owed. So O'Donnell and Bowers would purchase the price for the balance of $300,000. If all that went to the tax lien, Ms. Blair would get about $13,000 or something, and if they're $287,000. So it's complicated. And but Mr. O'Donnell and Ms. Bowers, if I were to allow Mr. Hatch to withdraw, like Judge Stutzman did, you'd be given time to hire another lawyer. It's going to be very difficult for you to hire another lawyer. One, the case is very complicated. Two, your last lawyer withdrew for failure to pay. So no one's going to want to touch this with a 10-foot pole. You're not going to be eligible for legal aid services on the purchase of a $450,000 house. So that ain't happening. Which means you're going to be left to your own devices and your own representation in circuit court. Mr. Soltis will probably file motions on behalf of Mrs. Blair, and you're going to have to answer those in proper Michigan court rule pleadings, or they won't even accept them. So you could probably secure financing to purchase this house. It's an asset. The current price is probably less than what the house is presently worth. And you could finance the purchase of the house. You can't finance your attorney fees. I guess you could take out some sort of personal loan or sell an asset or something. But my sense is these attorney fees are substantial, as in tens of thousands of dollars. And everything you spend on attorney fees is money you don't have to spend on the purchase of the house. But you are going to be laying in the desert as a dry husk if you try to represent yourself in the circuit court in these matters. And Mr. Hatch has already been allowed to withdraw from the circuit court. There's nothing to do in my court until the circuit court case is resolved. Have the escrow payments as they were restructured been made?
Yes.
Mr. Soltis shakes his head no. You say yes.
Maybe there's a recent payment, but until very recently, they had not, to my understanding.
They've been paid every month. This month, I think, is not in yet, but every month's been paid.
All right. Are you in residence at the lake?
I was, but I'm back in New Buffalo right now.
So has anyone enjoyed the Corey Lake amenities this summer?
No, not really. We got the dock in late and then needed dock repairs, roof repairs. I had to get a bunch of stuff done. And then, we both work full time in the summer. So it was kind of one of those things. We were planning on living there and not commuting. And they got traffic. So it takes 2 hours to get there now from New Buffalo, or it did because of the traffic that they had this summer. But it's been maintained. I've been mowing the yard. I mean, everything's been maintained. The dock's in, everything's working, everything's good.
But let's say things start to break, the water heater goes out.
We had to replace all that.
Been replaced. The furnace has been replaced. We have replaced everything in there except for the and I have a set of appliances for my sisters. It's everything in there has been replaced by us. The furnace, the water heater.
All right.
Joe did the deck.
Well, let's hope it all lasts.
That was part of the
can't-
issue. Oh, I'm sorry, Your Honor. That was just part of the
Go ahead.
issue when Miss Blair evicted Mr. O'Donnell and Miss Bowers without lawful cause. Is that she let the house sit over the winter and then the pipes froze. And then Mr. O'Donnell and Miss Bowers had to then replace the furnace, replace the pipes, and all that was going on after the specific performance order. And those were going to be the damages included in the circuit court for the offset. So I think they are very interested in protecting their own assets that they've replaced inside the house and is not going to let it go to waste or, the pipes to freeze or not maintain it, because they have invested $107,000 into this house, and that doesn't include the tens of thousands of dollars to replace the furnace and the pipes and all of that as well.
Your Honor, they aren't living there and have not lived there. You gave them possession. So Miss Blair couldn't get in there and take care of it. So it is what it is.
Oh. Mm-hmm.
We got possession in the summer, Mr. Soltis. I am talking about the winter before that.
Yes, and I was aware of that stuff. All right. I don't know what's going to happen here. But I do believe that it isn't going to be resolved by the time I retire. But I also believe that Mr. Hatch is entitled to the relief that he's requesting. So what needs to happen now, Judge Stutzman gave you until October 2nd to hire counsel or to file an appearance on your own behalf. You are.
He gave us 60 days from the, excuse me, Your Honor. He gave us 60 days from the time that it was filed. I don't think it was filed till like a couple of weeks ago.
All right, well, whatever the deadline is, the attorneys thought it was October 2nd. But there are things that need to be heard in circuit court. They're your claims. You're the counter plaintiff, and someone is going to need to present the evidence and follow the court rules and the rules of procedure. This isn't a small claims court case. This is a circuit court case for substantial money damages. And you need a lawyer. You have one, and it might make more sense to pay the one you have instead of trying to scrounge up money to pay another lawyer who is also going to give you a substantial bill. The problem that you're in, and I'm not being critical, because so much time and so much money has been spent, you've run out of money. And maybe Miss Blair is about in the same boat.
I think that was her plan, Your Honor.
Well, I don't know. I regret how long this has taken to unravel, but it is what it is, as Mr. Soltis said. So is your plan to try to find another lawyer or just represent yourselves?
I mean, to be honest with you, I was hoping that some kind of resolution would be found in the meantime, but that's not going to happen. And I don't believe it's going to happen.
That's what I was hopeful for today. If I got everybody in the same place at the same time, we could see a way to resolve this. But Mr. Soltis eloquently said, reasonableness is in the eye of the beholder. And you're not this far apart, maybe you're this far apart, but you're not together with a deal. So you're gonna be in the circuit court, and Miss Bowers, so are you. And you're gonna be representing yourselves. But Judge Stutzman has already ruled on that matter. So I don't really like doing it because I don't like leaving you high and dry. No one knows this case as well as Mr. Hatch. No one. Not me, not Mr. Soltis, not even you guys. And when Judge Stutzman got it, he was like, you know, there are boxes worth of stuff and pleadings and counter pleadings and motions and orders. And it was a chore for him to get it into a understandable basis to make a ruling on it. I just don't like what's going to happen here. Ms. Bowers, you want to say something?
Has there been a ruling on it? I don't even really know what's going on with it, to be honest.
No, there hasn't been a ruling on it. All those 7 issues that I removed to the circuit court are still there. The damage hearing and circuit. I'm sorry, go ahead.
It kept getting continued. I think he didn't look at it the first time we went in, and then I don't think he was familiar with it the second time that we went in, and it just keeps getting continued, and then we just keep paying to go there for nothing. I can't speak to any of the
delay in circuit court. One day was due to a flood, so I won't blame anybody for that one. But there was a lot of delay in there, and I don't understand all of it. But as I said, I had my share of delay just from the order on August 5th, trying to get this hearing set. But August 5th to September 12th isn't too bad. All right, Mr. Hatch, is there anything else that should be in the order?
If the order is going to be granted, Your Honor, I would think for practical purposes, because Mr. O'Donnell and Ms. Bowers were given 60 days to either represent themselves in pro per or retain counsel. I think we're going to want to have that clause in here as well. And the proposed order attaches Exhibit 1. It just grants the motion to withdraw. And I think we probably need to either align that date with the date that the circuit court gave, or to give them the same amount of time, 60 days, to find a lawyer in the district court action. I would assume that if they hired a lawyer, they would represent them in both the circuit and the district court action. Yes. So by my calculation, the order was entered on August 5th of 2025, granting my withdrawal in the circuit court. 60 days after that would be October 4th of 2025. So I would just ask that they be provided with, and I don't think that between now September 12th and October 4th, when their children are in school and they're busy like everyone else, that's going to be sufficient time to make a decision to either hire a lawyer in this action or to represent themselves in pro per. So they've got to respond to the circuit court by October 4th, but I would ask for the additional 60 days in the district court to file an appearance through an attorney or in pro per. And even if those dates are staggered, Your Honor, I don't think it's going to matter, because the district court action is stagnant until the circuit court. So even if they hire a lawyer, represent themselves in pro per in the circuit court, if they're given another, I don't know what the count would be, 30 days in the district court, I don't think that would prejudice Ms. Blair in any way, and I don't think it would prejudice the court, because it's basically on mothballs until the circuit court makes a decision on the claims. So
I don't know that they actually have to file an appearance to say we're hereby representing themselves. It certainly can be done, but they just are at that point.
I was just thinking, Your Honor, for purposes of, for the court's mailings to go out, I think they need the
Yes.
addresses and all of that.
Good,
So,
good point.
Your Honor, and for the purposes, I need to know their contact information as well.
Okay, good point. Good point.
so that was a long diatribe, Your Honor. I got off on a tangent, but I think that the only thing that needs to be added to the order granting the motion to withdraw is a paragraph about when they need to file appearances, either in proper or through counsel in the district court action. It can really just be a cut and paste job of what's in the circuit court's order.
And I didn't print that order. It's in the circuit court on base file rather than mine, and I should have printed it. Now somebody's here by telephone.
I'm so sorry, it hung up.
Okay. It's Carla Bowers. All right, Mr. Hatch, I'm going to ask you to do that cut and paste job. I'm going to, without any sense of joy, grant counsel's motion to withdraw. I had the order right in my hand.
Any good Michigan lawyers watching this, reach out to us.
If anyone's watching this, they want to get in this case, contact the plaintiffs, the counter plaintiffs. All right, you will have 60 days from today's date, which would be August 12th. We'll go to November 11th. That's a holiday, November 12th, to either have an attorney file an appearance on your behalf or file your own appearance, both Carla Bowers and Joe O'Donnell, with your contact information and address, email, telephone numbers, because you'll be representing yourselves. At which point, Mr. Soltis will be able to talk with you directly. Right now, it's unethical for him to speak to you because you're represented by an attorney.
Your Honor.
Yes.
Is there any way we could put something in there that like we could get like a copy of everything? Because I was, we were kind of told that like, the trial thing was over. You know what I mean? I still have the demonstratives at my house, but like I don't have any of the files or the pictures, and we were never really given that stuff. So, I mean, I don't. Do we have to ask for that, or do we have to?
That's fair enough. Are you willing to return the file to the defendants?
Yeah, sure. I think it's my professional obligation or ethical obligation to return. I mean, I could file an attorney charging lien to retain the file. I'm not interested in doing that.
Well, to either forward the file to the new counsel,
yes,
or to the parties.
But I'm not interested in retaining any of the information. I'm happy to provide and will provide electronic copies of every single pleading and paper that was filed in the district and the circuit court to Mr. O'Donnell and Ms. Bowers via their emails that I have.
All right, why don't you put that in the order as well? All right. I'm, as Mr. Hatch says, stagnant until the circuit court takes action in this case. I'm sorry to see it come to this because it isn't going to end well for anybody. It's just going to take a long time to try to get somewhere. It's in everybody's interest to try to come to some solution to this. Find a number that she can accept and you can accept, and execute either the return of this house to her so she can sell it, or the execution of the specific performance so you can buy it at the agreed upon price. I don't have an answer to the tax lien question. If I knew about it, I forgot about it because I don't remember hearing it before. But the order will say that Mr. Hatch is allowed to withdraw as your attorney for Joseph O'Donnell and Carla Bowers. You have 60 days from today, which will be November 12th, to either retain new counsel that files an appearance or file an appearance on your own behalf with your name, contact information, including address, telephone number, and email address. It will also say that Mr. Hatch shall return electronic copies of all pleadings and filings and exhibits to you for your utilization in the circuit court case. Right now, Mr. Soltis is on thin ice talking to you guys. So he's not going to have any communication with you until after November 12th, when you either represent yourselves or you hire new counsel to represent you.
Your Honor, if I may interject, the circuit court order has a date of October 4th. At that time, I believe I can contact.
Yes, I guess. You can, fair enough. After October 4th, you guys can communicate.
He can communicate with respect to the circuit court claims, but he cannot
Yes.
communicate with respect to the district court claims.
Yes. And that includes the damages claims and the other matters. So effectively, what Judge Stutzman's order did is vacated my order regarding personal property and left the other things sort of as they were. He had a different view of MCL 600, but 8303. All right, Mr. Hatch, I don't know when I'll see you again, when you'll have cause to come to St. Joseph County. I thought you did an excellent job for your clients. And Mr. Soltis, you and I will probably see each other in the future. Mr. O'Donnell and Ms. Bowers, I hope you can move forward in this. But that's what I've got. Ms. Stiver?
Yes.
Stay in contact with Mr. Soltis.
I will.
And that's all I've got for everyone. All right, you're all good to go. Thank you.
Thank you. I just want to say
Thank you, Your Honor. Oh, go ahead.
always is a pleasure to be in front of you. And I don't take any joy in this either, but it's always a pleasure to appear in your court. And I'm going to make my way down there either for personal or professional reasons again to see you before you retire.
Well, it is Fair Week next week, so if you're coming, you got an extra elephant ear in your future. That goes for you and Mr. Bowers, or Miss Bowers and Miss O'Donnell. If you got to file some pleadings, do it next week and go to the fair. All right, you're all good to go. Thank you.
Thank you. Thank you, Your Honor.
Very good. Thank you, Your Honor. Best of luck, Mr. Bowers and or Mr. O'Donnell and Ms. Bowers. Take
You'll
care.
be in contact.
I'll be in
All right,
contact
thank
with
you.
for the order. So thank you.
Take care.
All right.